Hello and welcome everyone to Immigration Talk Show. I'm Nipasa. I'm going to be your host for this session that's lined up, and I'm very excited. I hope you are as well. It's going to be a very interesting session as we've got a very important guest who's going to be joining us in a short while. And before we start off with our session and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, thank you so much for joining us. Let me tell you that I've got good news that you can also participate in this session with us by commenting wherever you're watching us. We are live right now on YouTube, but you can also check us out on LinkedIn, Facebook, X, and on Instagram. Stay connected with us. And also, don't forget to ring that bell here on YouTube so that whenever we have discussions like these, you're notified. And another good thing is you can call us, dial in this number, and you can join us on call. The number is 425-436-6335, and the access code is 988-888. So, friends, yes, without further ado, please help me welcome our guest for today, none other than Attorney Chand Parvataneni from SPB Law Firm, Dallas, Texas. Hi, Chand. Really good to have you back again.
Thank you, Nipasa. Yeah, really good to be back, and hopefully we'll have a very productive session today. We'll talk about the visa bulletin and how it's impacting people's ability to immigrate to United States, how long the processing times are, how for some people it is like really bad because some things are based on the country of birth, not on country of citizenship, etc. So we're going to talk about a couple of issues regarding the visa bulletin, the kind of timelines people are seeing before they can get a green card. That's one topic. And another topic is compliance regarding I-94. It is very, very important that people look at their I-94s. And there is a lot of confusion. We are seeing a lot of cases where people accidentally, they did not realize that their I-94 is expired. And there is a reason for that. People have their H-1B approvals. Then there is a CBP I-94. And sometimes people get confused. And many people, not intentionally, but accidentally they get out of status. So it is very important people have to look at their I-94s. There are very, very strict regulations on when somebody becomes out of status. There is something called last action rule. So we will talk about the importance of I-94 and how everybody should look at their I-94s, know what I-94 to look at to ensure that their status is always legal in the country. Because if they ever fall out of status, they are jeopardizing their careers, their immigration approvals in the future. So we'll talk about those I-94s and what people should do to ensure their status in US is always legal.
I'm ex- I'm really excited, Chan, for today's session, and I'm sure folks out there as well are very excited because I can already see, Ricky. Hi to you. He says hello, and Rag says hello, Nipa and Chand. Really good to have you both join us. And Ricky, thank you for your questions as well. We are going to take them up a little later in the show, so stay with us, all right? And Chand, yes, the visa bulletin just got out, so definitely a lot of people are having a lot of questions in their mind because they have been waiting since forever. They feel, no matter how long you have to wait, it feels very long all the time. So I have
Yeah.
this first question. If you can tell us, for family sponsored applicants from India and China, we are seeing around 9 to 19 years of wait time. And why are these timelines still so long? And
Yeah.
if there is any chance that they might improve.
Sure. So when we talk about the timelines, typically when we talk about family-based immigration, it is always China, India, Mexico, and Philippines. These are the only four countries that are heavily impacted. And the reason for that is there are a lot of these countries. The populations are large, so you have more people in the countries. And then on top of that, when you talk about Mexico or Philippines, they have a lot of family immigration to United States. And when we talk about family based immigration, so there are four kinds of family based immigration. Uh, so when we talk about immediate relatives refer to the spouses of US citizens or parents of US citizens. So spouses or parents of US citizens do not have any problem. They don't have any wait times. And when we specifically say family sponsored preferences, there are four categories. So one is F1, the other one is F2, F3, and F4. And F1 refers to the sons and daughters of United States citizens who are unmarried. F2 refers to the spouses and children of green card holders. So you have a green card holder in the United States, and their spouse or their child is in some other country, and they need to apply for a green card for their spouses. So that is F2 category. And then you have the siblings of US citizens. So you have a US citizen, they can sponsor their siblings, their brother or their sister, and so on. So that is the F4 category. And usually, I mean, the timelines are extremely bad, the numbers that you just referred to. And the reason for that is there is a fixed quota. So every year there is a limit on how many number of people can come into this country in these categories. And what happens is the demand, there is too much of demand, and it exceeds the number of visas that are available, the number of green cards that are available under these categories. So when you're talking about, for example, India, so in India, if you have a US citizen and the US citizen is trying to apply for his sibling, brother or sister, so people who have applied a long time back in 2006, in July of 2006, those people are getting the green cards right now. So what that means is we're looking at about 18 years. So almost 18, 19 years. So if somebody who is a US citizen in 2006, they applied for their sibling in 2006, their siblings are getting the green card right now. And similarly, China, it's almost 2008. So almost again close to 16 years. Mexico is even bad. So siblings for any citizens who are US citizens, but their siblings are in Mexico, it's almost 24 years. So almost 24 years. The wait time is almost 24 years right now. So what this means is uh, the quotas. We have limited quotas, and you can, by law, by regulations, you cannot exceed those quotas. So Department of State, the consulates are limited in only approving those number of visas per year. And when you have more demand from certain countries, because again there are something called country quotas, every country can only get 7% of the quota that is available. So once you hit that 7% quota, that country stops. You cannot give more visas than allowed. So this per country quota limits are causing a major issue to these four countries: China, India, Mexico, and Philippines, when it comes to family based immigration. And going into the future, I don't think there'll be any kind of an immigration law that would change in on the family based side to increase these quotas, because there is nothing, no bill that is outstanding that is pretty recent where they're talking about increasing their quota, these quotas, these family based quotas. So what this means is, until we probably have any kind of an immigration law passed, we will continue to see this extended wait times, and until these country quotas are either removed or the numbers are increased, we do anticipate to see this kind of wait times at least in the next couple of years.
Absolutely. Thank you so much, Chand, for putting this up because, many hopefuls out there keep asking, are we going to have better news in the next visa bulletin or the next one or before the fiscal year this time? But seems like it's not going to change too soon. So thank you at least for being so clear about that. And Chand, looking at the EB2 and the EB3 for India and China as well, the wait is around 12 years. And what is your advice for people in these categories who are stuck in the backlog? And if they can switch categories or upgrade their cases, what do you advise?
Sure. So again, when we come to the EB2, EB3, or EB1, the employment-based categories, again, the wait time is pretty bad. And again, in general, what happens is the fiscal year for USCIS, for the government agencies, starts from October 1st. So what that means is when you have the green cards, what USCIS does is, when it's the first fiscal quarter, the first fiscal quarter starts in October 1st. So October 1st is where all the numbers are opened up, and the numbers, as we go through the quarters, the first quarter, second quarter, third quarter, the numbers are getting depleted. And when we come to the final quarters, so right now the July bulletin got opened up. So July, August, September. So this is the final fiscal quarter for the year. Normally what happens is most of the numbers are already used up, and it's only in October that we get the numbers back again. So historically, it is pretty normal that when it comes to the end of the year, end of the fiscal year, so theoretically, July, August, September is the fourth quarter, the final fiscal quarter of the government fiscal year. So the visa bulletins normally don't move. So last month and the month before that, and the July bulletin that just came out, it is kind of pretty disheartening because we have not seen any kind of a movement. And if you look at India, the only dates that have moved are EB3, and even EB3 only moved by just 1 week. It is in 2013. So from April 15th, 2013, it went to 22nd April 2013, just a week. So it is not really great movement. The other categories, EB1, EB2, EB, the other categories, they have not even moved yet, not even a single day. So again, the main thing is everybody's watching out for the October visa bulletin. October visa bulletin will definitely see some kind of a forward movement. It will not be very, very substantial, but definitely not what we are seeing in the last couple of months. So, in terms of what people can do, because the EB categories are backlogged, again, we are running into the same problem. There is a limited number of green cards that are available. So, we have 140,000 per year. That is what is available in the entire EB1, EB2, EB3, EB4, EB5. And out of that 140,000, for example, India is only eligible to get 7% of that quota. And the reason for that is green cards are based on country of birth. It is not based on citizenship, it is based on country of birth. So if somebody was born in India or born in China, so right now, even if they became a citizen of Canada or became a citizen of Australia, it does not matter. It is based on country of birth. So when you have your birth from one of the countries where we have a huge backlog, like India or China, so the other options that are typically available are, people should be looking at EB1 option. EB1 definitely has faster movement. The other option is EB5. So what a lot of people are doing nowadays is they're really exploring at EB1 option, they're really exploring at EB5 option. And when you look at EB5 option, there is a $800,000 investment, and then there is $1,050,000 investment. So there is something called set aside categories. So the EB5, if you are looking at the set aside categories, the dates are still current for all the countries. So even if you're from China or from India or any of these backlogged countries, if you're investing into EB5 but only the set aside categories, the dates are still current. But if you're investing into the EB5 unreserved categories, the dates are backlogged for India. So anybody that is exploring at a faster green card approach, definitely look at the EB5 option, but look at the set aside categories. When we talk about the set aside categories, we're talking about the rural category, we're talking about the targeted employment category, or we're talking about the infrastructure category. So that is one option that a lot of people have been exploring in the last couple of months. EB1, I'm seeing a lot of people become successful in the EB1 option. So when we talk about EB1 option, we're talking about EB1 extraordinary ability, which is EB1A, where I'm seeing a lot of people explore the EB1A option. The reason is, if you look at people from India or China, they have been in this country for such a long time, 10, 15, 20 years. So they have contributed a lot, and not only contributions, it is all documented. Maybe they have published papers, maybe they have attended a lot of good conferences, they've presented some good papers in the conferences, maybe they wrote some papers. Some people have applied for patents. So in the last 10, 15 years, if somebody has been in US making very, very good salary, they're highly respectful in their profession. EB1A, extraordinary ability, is a good category. So that is something what everybody should explore, especially if they have good resume to back up. So when we talk about good resume, we're talking about a high salary. We're talking about, do you have any papers? Have you been a judge in any conferences? Have you talked in good conferences? And do you have some contributions to the industry that are very valuable? And when we talk about contributions, the government, they're really looking at some targeted occupations. So if you're working in, like, some say data science, artificial intelligence, something that would really help the nation, the country, you will be given a preference. So always, if you do think that you have extraordinary ability, that is something for you to explore and see if you qualify for EB1A. There is also EB1B, which is for outstanding researcher. So if you have like a PhD and you have good research going on, EB1B is a good option. But normally I've been seeing EB1A being more available for people who are in the IT industry. And also EB1C. So if you're working in a managerial capacity and your company is a multinational company, your company has offices abroad, if you work as a manager abroad for at least 1 year out of the last 3 years, and then you want to come back to US and then work in US in a managerial category, EB1C is a great option, and a lot of people have been exploring the EB1C option. So this is something that I think all of you should explore. And we also have the EB2, EB3 downgrade and upgrade. But again, EB2 is pretty bad. EB3 is pretty bad because EB2 and EB3 both are extremely backlogged for India. The downgrade option right now is not a great option because both EB2 and EB3 are at a similar point in 2013. Both are backlogged. So the downgrade option that did work for a couple of folks a couple of years back is not really a great option. So again, anybody that has an approval under EB2 or EB3 category, an I-140, if you do apply for EB1 category and you do get an approval, what USCIS would do is they do something called porting of your priority date. So what that means is they will take your EB2 or EB3 priority date and they will put it on your EB1 approval. So anybody that qualifies for EB1 right now, if you do EB1, you can take advantage of porting of the priority date. Okay, so by taking advantage of the priority date, so whatever was your EB2 or EB3 priority date in the past, you can get that ported over to your EB1 approval. So I think that is the best option that I would advise people in this backlogged areas to take a look at. Look at EB1A option, look at EB5 option. And right now, EB5 I think is a great option, but I think even EB5 in about probably 6 months to 1 year, you will see a retrogression. So if you are interested in EB5, I think now is a great time. But again, EB5 is not easy. You have to spend a lot of money. And not only that, you have to do a lot of vetting. You have to look at the project. You have to really be comfortable investing into that project. And that takes time. So anybody that is thinking about EB5, start your research and try to look at a lot of projects. Don't look at one EB5 project. Look at multiple EB5 projects so you can analyze the risk and see what works out for you.
Thank you so much, Chand, for giving us that advice. I think this is what people wanted to hear as well. So thank you for that. And there is so much more to talk about. So I just quickly want to say hello to Karthik. I am Yugandhar, RK. Thank you so much, Jadav, for joining us. And we are going to take up your questions a little later in the show. But for now, stay with us. And I hope you're enjoying this conversation we're having with Attorney Chan Parvatineni. So please do not forget to subscribe to our channel if you haven't as yet. To all viewers out there, and yes, also ring that bell so that whenever we have discussions like these, you're also notified. And yes, check us out not just on YouTube but also on LinkedIn, Facebook, X, and on Instagram. So also, if you want to have a consultation with Attorney Chand Parvatineni, maybe you need some advice or some guidance on your visa. So why not contact him? And you can check out the contact details in this link which is displayed on the screen. Okay, Chan. So I wanted to talk about for Mexico and Philippines. Some family-based categories show wait time over 20 years, and it's really very long. So is there any realistic legal workaround for families who don't want to wait that long, by any chance?
Sure. So, for anybody who's going through the family based immigration from Mexico or Philippines, the good thing for them is their employment based categories are not as bad as their family based categories. So, anybody from Mexico or Philippines who have a case pending under family based, they should be looking at employment based immigration because their EB2, their EB3, their EB1 is not as backlogged as the family based. The employment based is backlogged heavily for India, but not for Mexico and Philippines. So that's something what they should be looking at. Definitely see if that is an option. And another one they should be looking at is looking at family based immigration or immediate relative category. So in case they qualify either through a relative or either through marriage, immediate relative category is one option because sometimes people get married to US citizens. Sometimes uh, something else happens. So immediate relative category is used for the spouses of US citizens or parents of US citizens or children of US citizens. So at some point of time, if they do qualify as an immediate relative, IR, there is no numerical cap and they move like immediately. So if they do qualify under immediate relative category, that's the best option because they simply can convert their F1, F2, F3, F4 to immediate relative. And then that becomes very fast. There is no numerical cap. And what that means is it is immediate. There is no waiting time other than the processing time. So that is one best option. And the final option, it's you can also think about using a non-immigrant visa. When if you are in the queue for F1, F2, F3, F4, typically there are some dual intent visas. So dual intent visas such as H1. So you can probably still come to US, work in US in a non-immigrant status using a dual intent visa. So maybe that's another approach that some people can take, because you might be qualified to work in US. So explore the dual intent visas. So these are some of the ways where you might explore and see if it works out for you.
Interesting. Thank you so much, Chan, for that. And looks good for Mexico and Philippines that they have an option to check out the employment based preferences. So, yes, thank you for that, Chand. And well, we are here to also discuss about our second topic of discussion today, that is the I 94. And why is it maintaining a valid I 94 status so critical? It's very important. So, we will touch up on that as well. But let's quickly take up a few questions from our audience. Let's not keep them waiting too long. So Ricky is asking, for those on H1B, is there a way to print I-94 separately apart from it being mentioned on the H1B notice?
Um, so when we talk about I-94, so there are two ways you get your I-94. One is through CBP, Customs and Border Patrol. You just go to the website. You just type in I-94 online. You go to the website, and you can get a CBP issued I-94. So the CBP issued I-94, the only information it will have is so anytime you come into the country through port of entry, that is the time the I-94 from CBP gets generated. So whenever you travel into the country, you get the CBP I-94. And when you apply for extensions, or when you apply for transfers, or when you apply for any petition with USCIS or any application with USCIS also issues you the I-94, and that is the I-94 on your 797, I think, that you're talking about. And what you should be doing is you should keep a copy of your CBP I-94, which will not change until you travel out of the country and come back. So if you don't travel, that I-94 stays as is. You should keep a copy of that. And then you should also keep the I-94 that is issued by USCIS. And then you should always see what is the latest one. And whatever is the latest one is the valid I-94. And that is something called last action rule. We'll talk more about it in this session. So from your perspective, you keep both the CBP I-94 that you can download at any point of time from the CBP website. And then you will have a USCIS issued one, which will be on your I-797. You should always keep a copy of both of them. And then you should always use the last action rule to determine what is most recent. And that most recent one is the one that you should use.
Thank you so much, Chan, for taking that up for Ricky. And Ricky, I hope you got your answer. Thank you for participating today as well. Let's take up this one from Jadhav now. For individuals transitioning from a non immigrant visa to an immigrant visa, what role does the I 94 status play in that process, and how does it impact the timeline for receiving the green card?
Sure. So I-94 is typically for non-immigrants. So anybody that's in any kind of a visa, they always will have an I-94. And I-94 basically simply says one thing. It will have an end date, and it simply says that you are allowed to stay in this country until that end date. So you always look at your most recent I-94, and since you're on a non-immigrant visa, that is the date you're supposed to depart the country. Unless, in your case, you said you're transitioning from non-immigrant visa to immigrant visa. The way you do it is you file a 485. So if you have a 485 pending, if the 485 is pending, then you are allowed to stay even if your I-94 expires. So if you file your 485 before your I-94 expires, then what it means is, as long as your I-485, the non-frivolous application, a legitimate 485 application, as long as it is pending, and you are allowed to stay in the country. So when you're transitioning to immigrant visa, which is basically the green card, it is more about the 485. And as long as the 485 is pending, typically you should be allowed to stay in the country. And in terms of impacting the timeline for receiving the green card, uh, again, 485s come under different categories. It could be for family based, it could be for employment based, and so on. And depending on your category, it takes time. If it is an employment based category, if it is or any kind of a category where your dates are current, more than likely, if your dates are current, 6 to 12 months is what typically you can expect for the 485 to get approved or get adjudicated. But again, sometimes what happens is there is retrogression, the dates go back. If the dates go back, what happens is you will not get a green card. USCIS will not adjudicate 485. They will keep 485 in a pending status, they will let you apply for EAD 765 or 131 advance parole. So you keep using those documents to stay back in the country. And even if your I-94 expires, if your 485 is pending, you can just stay back in the country and work as per your EAD card. You can travel out of the country using your advance parole and keep doing it. So I-94 is more for people who are on non-immigrant status. And if you're on non-immigrant status and you don't have a 485 pending, you do have to make sure that you can't overstay your I-94.
Okay. Thank you so much for taking that up, Chand, for Jadav. And Jadav, do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And folks, you can keep participating, keep commenting with your questions, or you can dial this number 425-436-6335, and the access code is 988-888. Join us to ask your questions, and maybe you can treat this as a short consultation with Attorney Chandra Vitaneni as well. So let's go on now and take this question from Karthik. He says, "Hello, Chand. I would really appreciate if you take this question. I was wondering if part time work is allowed on a TN visa. Additionally, can an individual hold two jobs on two different TN visas?"
So when we talk about TN visa and you want to do a part-time job, so you're already in the country on TN, and then you have a second job, a concurrent job. If you want to do a concurrent job, your employer will have to file an I-129. So you're in the country. So either from Mexico or from Canada, you came into the country, you have a TN I-94, and say you want to do a second job, a concurrent job. The way you would do it is your employer has to file an I-129. They do have to let USCIS know it is a concurrent job. So there is an option on I-129 where on the second page where it says what kind of an employment it is. You would have to mark it as concurrent. And then additionally on the I-129, on one of the pages, page 5, you will be able to let USCIS know it is a part-time job, and you'll also be able to let USCIS know how many number of hours you'll be working in this concurrent part-time job. The thing is, on TN, you do have to get an approval before you can start the job. On H1B, if it is concurrent, you get a receipt, you can start the concurrent job. If it is TN and you want to do a concurrent job, if you do your employer do will have to apply the I-129, wait for the approval. Once you get an approval, because you're notifying USCIS, because USCIS is allowing you by approving the TN case, you should be able to do the concurrent job.
Okay. Thank you so much, Chand, for taking that up for Karthik. And let's take this one now from I am Yugandhar. Hi, sir. My H1B petition has been approved on 2024, stamping not yet completed. If I miss this year's stamping, will have to again go for lottery system? That's the question.
Sure. So normally the rule is once you get your petition approved through the lottery, through the process, you are counted against the cap. So the way it works is because you're counted against the cap, you now have 6 years to work on H1B. And if you have not used the 6 years, you are technically cap exempt. So what that means is you don't have to go through the lottery if the case has not been revoked. There is no fraud in the old approval. You are technically cap exempt. Say in 2028, say after 4 years, you have another employer who wants to file a H1B for you. They don't have to put you through the lottery. So they can simply file a H1B, ask for cap exemption based on the fact that you have been counted against the cap. So in your case, you have been counted against the cap in 2024. So based on that, you should be cap exempt. That being said, in case you're out of the country for more than a year, USCIS does allow you to go through the lottery once again and recapture again. You will be able to get your entire 6 years. So, but again, in your case, if there is no problem with the old approval, the approval has not been revoked, because you've been counted in the cap, because you got an approval, a new employer should be able to file a cap exempt petition without going through the lottery.
That sounds very interesting and good news, I guess, for I am Yugandhar. Thank you for participating with your question. And let's take this one now quickly for RK. I hope you're doing good, RK. And he's asking, do you see retrogression on any of the dates for the rest of the fiscal year? Second H1B possible? I think he's talking about the lottery. And do you see companies not filing, which would increase the chances? Lottery.
Sure, sure.
That was in parts, but
So
I guess you got it. Yeah.
yeah. So when we talk about retrogression, say we talk, for example, we're talking about the dates for India, because India is a country which is like heavily backlogged. The dates are unfortunately extremely bad. I mean, we are looking at 2013. I don't think. I mean, again, even if there's retrogression, I don't think. I mean, there's like nothing else to go back, because since 2020, that is where the dates have been stuck at. I mean, in 2020 during COVID time, the dates went ahead, but again, I mean, again, most of the people from before 2012, they got their green cards, because in 2020 the dates were current for 2012, and so on. So most of the people did get their green cards. So the number before 2013, it is very low. So there are very few people before 2013 who have not received the green card. So there is not really much to retrogress for EB2 and EB3 for India, because the dates are already very bad, extremely bad. That being said, normally what happens is when we go into the last 1 2 visa bulletins of the fiscal year, because September is the last visa bulletin for this fiscal year. So, I mean, even if there is retrogression, I mean, again, it will come back up in October. So October again they will move the dates forward. So because the dates are so bad, I don't really think that there is any scope to really send the dates back. So maybe in the last visa bulletin, in the September visa bulletin, maybe they will move the dates a little bit back. But in October, I think they will again move it forward. So because the dates are really so bad, I don't think there is anything to retrogress any further in at least EB2 and EB3 categories. And
Thank you so
the
much. Yeah. Sorry,
and
Chan.
the
Go
other
on.
part of the question, I think, regarding H1B. So regarding H1B, I definitely think there will be a second lottery, because we are seeing a lot of petitions getting filed, but I'm also seeing a lot of petitions not getting filed. Maybe because of the economy, maybe because of various reasons. But because I am seeing a lot of people not file, I do think there's a second lottery. And if you say like, are majority of the people not filing? No, I think majority of the people are still filing, but I at least think that there'll be some percentage of people that are not filing, which means there is a good scope for a second lottery. So I definitely think that there will be a second lottery. I would not say it will be a huge number of selections, but I definitely think that there will be reasonable number of selections, just similar to last year. Because if you look at the last year's second lottery and the year before that second lottery, last year we had a second lottery, but not too many selections. But the year prior to that, we did have a lot of selections. So I think there will be a second lottery, uh, and again, I don't think it will be like too many selections, but at least I think we will see some reasonable number of candidates getting selected in the second lottery.
Yes, looking forward, Chand, and I hope so also. It's already mid June. So, if by any chance we have the second lottery, by when do you expect it to happen?
So normally it will be in the last week of July or the first 10 days of August. If they don't announce anything by first 10 days of August, more than likely you can assume that maybe not. But again, first couple of days of August, starting from end of July to August 15th is when I think you can expect some news about second lottery.
Okay, okay. Thank you so much, Chand, for taking that up. And let's take this one from Rag, and then we'll continue with some of our questions as well. Rag is asking, what are the consequences if I get a concurrent H1B and I work for the second company? Will it have any repercussions with the green card filing or issues at port of entry?
Sure. So if somebody gets an approval through concurrent H1B, all that means is if they want to go ahead and work on that second job, concurrent H1B, they are allowed by USCIS to perform that job. But again, employee does not have to go and start that job. If they don't want to join that job, they can resign. They don't even have to join the job. That being said, from a company perspective, what we always say is if you don't require that H1B, you should be revoking that H1B. The reason is if you keep the H1B active, tomorrow you might have a site visit and then you have to explain. So if you know the employee doesn't want to start, a good practice is the employer should go and revoke that H1B. So the employee does not have to answer in the future what happened, and the employer does not have to worry about having any liability for pay or anything. So, no, there is no requirement that just because you got a concurrent H1B that you have to go and start. Because if you're not interested in starting, let the employer know, and the employer should go through the formal process of notifying USCIS and withdrawing the H1B. That is the cleanest way. But the only time you'll have a problem with USCIS or consulate is if you work without authorization. So if you don't get proper authorization and you start working on a job, that is when you'll have a problem. But when you have an approval, you don't want to start that job, that is fine, as long as you maintain status, which means in your full-time other H1B, you are working as per the required means you're maintaining status, you're maintaining your H1B status. If you don't start your concurrent H1B, that is fine. Resign that job. Let the company know that you don't want to join that job.
Okay, all the best, Rag, and thank you for participating with your question. And folks out there, stay with us. We will take up some more of your questions a little later if possible. But now, Chand, I have a few more questions for you. So if you could tell us, for those with F, J, or M visas whose I-94 says D/slash S instead of specific date. So, could you explain what that really means and how it affects their stay or ability to apply for a green card?
Sure. So when we see a lot of people, their I-94 will always have like an end date, like somebody on H1, somebody on L1, somebody on any other non-immigrant visa. Typically, you will see an end date for I-94. But when it comes to the student categories, F, J, or M, uh, normally what happens is they will see something called D by S on their I-94. D by S means duration of status. So what is happening is they don't put an end date because they're not really sure when the program expires. For example, somebody is a student. It is very hard to predict the exact end date on their status. So what typically happens is they simply put it as duration of status. And what that means is as long as the student is participating in the program, for example, a student, as long as they're enrolled in the full-time program, as long as their service record is valid, as long as they are maintaining their OPT or STEM OPT, they are allowed to stay in the country. So the minute their student program ends, or their OPT ends, or their STEM OPT ends, that is when their status ends. So because it is very hard to predict that end date on the day of arrival, they'll simply get D by S. So whenever somebody sees D by S, all it simply means is you maintain your F1 status, or your J1 status, or your M1 status. As long as you're continuing the program, you are good. The day you fail to maintain status, or the day your program ends, that is the day you fall out of status and you should not stay back in the country unless you have a grace period. For example, F1 students have like a 60-day grace period after their program ends, and so on. So D by S simply means maintain the requirements of your program. The day your program ends, depart the country. And when you talk about green card, before their program ends, they can always qualify for applying for 485. So, for some reason, if the company files for I-140 and they're allowed to file for 485, say somebody's from a country where the dates are the current, they might be able to file for a 485 even while they're on student status, assuming they have always maintained their status in the country. So anybody that is qualified for adjustment of status, they are allowed to file for 485 even while they're on F1, assuming that they have always maintained status, and assuming that on the day of entry, the day of their initial entry, they did not have an immigrant intent. And if that is the case, they should be able to file for adjustment of status. So again, the bottom line is anybody that is on F1, always comply with your service. Always consult your DSO. Always make sure that you know when your service is getting terminated. So even though it is saying duration of status, it is not indefinite. It is based on your program participation.
Okay. Thank you so much, Chand, for taking that up for us. And folks, do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. Check us out not just here on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. And I'm sure if you're resonating with this, do not also forget to share this content with your friends and folks who could benefit most, with our content here and this conversation we're having, of course, today with Attorney Chand Parvataneni. So, Chand, we do have more questions, and I'd like to take this next one, which is if someone overstays beyond the date on their I 94, even by a few days, what are the real consequences? And is there any way to correct it without triggering future issues?
Sure. So normally, what happens is if somebody overstays their I-94, they are at risk. That being said, if you do not cross 180 days, most of the time, if you have some genuine reason, you should probably be able to get through. And I'll talk about some of the ways that we can do it. If you cross 180 days and you overstayed your I-94 by more than 180 days, you are at risk for mandatory bars, and that is when you'll run into all kinds of issues. And normally, what do you do? So, because if it is not intentional and somebody made an accidental mistake and they overstayed their I-94, how do you resolve it? So normally, if I see somebody has not crossed 180 days, the easiest option is you depart the country and then you re-enter the country with another inspection, with another CBP inspection, or you go to the country, go out for visa stamping. If it is less than 180 days, most of the time you should not have an issue. You'll be able to overcome. Either if you need to get a new visa, you might be able. I mean, I don't typically see problems if you don't cross 180 days. Uh, if you cross 180 days, that is when you'll have mandatory bars. So what you normally do at that point of time is there is something called NPT, non pro tunc. So there is something called NPT where you go back to USCIS, you tell what exactly has happened, and you prove to them that it is not intentional, and you show them the reasons why this happened, and you also have to show that you're not in any removal proceedings. You also have to show that you have not done any crimes or anything else. So if all is good, this NPT process is a discretionary process. So USCIS normally, if everything is good, they see a good reason, they approve NPT. So going through this NPT process, non-pro tunc, is one way where you let USCIS know and you fix the problem. So so NPT is one way where you go back to USCIS, fix the problem, or the other option is go out of the country, re-enter to get a new I-94. So if you go out of the country, you re-enter, that old issue with I-94 normally is resolved. So in the future, they're not going to come back and cause you a problem if you left the country and you re-entered and got a new I-94 issued to you. So these are the two typical ways that people solve the problems, either by re-entering, getting a new I-94, or by filing an NPT, going back to USCIS and working with USCIS to get an approval for NPT.
Okay. All right, Chan. Thank you so much for taking that up for us. And I also had to tell you that many of our viewers are having trouble locating their I-94 online. So, what are some practical steps that they can take if the system doesn't pull up their records?
Sure. And again, this is very important. Everybody should be able to pull up their I-94 record online, because any future extensions, any future applications, you always have to show your CBP I-94. It is very important. And sometimes, if you are not able to pull up your I-94 records, you apply with USCIS. USCIS sometimes will say that they're not finding a record. They could even deny a case. So what you should do is go to CBP online. You just Google I-94 online. You'll see a link, a cbp.gov link. Try to put your passport information and pull up your I-94. If you're not able to pull up, immediately contact CBP. And the way you do it is so the big cities will have a CBP office at the airport. So normally you should reach out to them. You can call them, you can email them, but most of the time they will say, come over to the office, come over in person. So go to the office, let the officer know when you came into the country, the CBP officer, and let them know that your I-94 is not pulling up, and they will be able to assist you. Not only that, sometimes we also see is when people pull up their I-94 records, sometimes some data is wrong. Maybe the end date is wrong. Maybe something is wrong. So it is everybody's responsibility that whenever they travel back into the country, they land in the country, within 2 or 3 days, look at your I-94 record. If you're not able to pull up your I-94 record, or you see some issue with your I-94 record, such as wrong end date on your I-94, immediately reach out to CBP. If you reach out to them immediately, they will fix the problem. If you delay the process, sometimes they will cause an issue. So if anybody is not able to download their I-94 record, reach out to the CBP office, or let your attorney. I mean, if you're working on H1B, let your company's attorney know about it. And it is highly important that you do have your CBP I-94. Every non-immigrant, anybody on a non-immigrant visa should have their I-94. But if not, there is a way to get it rectified through CBP office. Okay, so make sure you do it. If not, it is going to cause a problem down the line when you apply for extensions.
Okay. Well, thank you so much. It's very important, friends. So I really hope that you were paying attention and taking notes. And even if not, that let me tell you that you can always go back and watch this episode again even after the stream has ended. So thank you for that, and do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And also, if you want to have a one-on-one consultation with Attorney Chand, visit this link which is displayed on the screen. So, Chand, we do have more questions and also some from our Facebook groups as well. But before that, I wanted you to tell us, if someone overstays beyond their date. Oh, sorry, in one of the real cases, a professional entered the US on an O1 visa, but his I 94 was issued with the wrong expiry date, leading to a 9-month overstay and triggering a 3-year bar. So, what should travelers and visa holders do right after entry to avoid devastating errors such as this one? And how quickly can a mistake like that be
Yeah.
corrected if they're caught early?
Yeah. Normally, if you catch the mistake early, CBP will work with you. So, and what that means is everybody, they have this responsibility that they check their I-94. I would say at least 2 or 3 days within their entry into the country. If you check it immediately, normally there are like two options. One, you can email to CBP. Sometimes when you email, they're fixing it. Sometimes they don't. And if they don't, you go walk into the CBP office. So if you entered somewhere like port of entry, you entered in Dallas, you reach out to the Dallas Fort Worth Airport's CBP office. So they have an address. You look it up online. You'll see the address. You just simply go to the address and talk to the CBP. Let them know this is when you entered the country and you're seeing this issue. If you do it right away, what the CBP officer does is they look at the approval. They look at what's going on. Most of the time, they will fix the problem. It is only when you don't look at, because people do have the dress, they are required to check their I-94s. So if they don't check and it's a long time, and like in this case they realize after a very very long time after their I-94 expired, now even if they go to CBP office, they will sometimes claim that it is their mistake, that they overstayed and cause major issues. So to avoid that, the simple solution is anytime you go out of the country, you come back into the country. So anytime you're coming back from a foreign country back to US, you land into the country, everybody has to go through a CBP inspection. Everybody, even US citizens, have to go through a CBP inspection because you have to go through the port of entry inspection. So once you come out, any non-immigrant, you simply go to the CBP website. It is online. You just type in your passport number, your date of birth, your I-94 will pull up. Look at the record. If it shows wrong information or if it does not pull up, simply contact CBP. They will fix the problem. So, I mean, again, it's a good uh, uh, educational thing that look at your I-94. There is a mistake. Reach out to CBP, local CBP, CBP at the airport. They will fix the problem.
Okay. Thank you so much for taking that up for us, Chand. And also, I had another case study which is from our visa bulletin point of view. So, let's say a US citizen filed an F3 petition for a married child over 21 years for their son who is in India back in 2013. So, according to the current visa bulletin, the final action date for F3 India is around 2009, but the date for filing is 2010. So this family is now unsure whether they can begin NVC processing or if they need to wait longer. If you can just walk us through, what these two dates really mean in practice and how families in this situation can, plan ahead, especially when they're stuck and waiting years, after filing is like this.
Right. So normally when you're going through this F3 process, what happens is you get an I-130 approval and then it is stuck in NVC. And until the dates are current, they will not even send it to the consulate. So when you see the dates are current, at least in the second chart, that is the time where you reach out to NVC and work with NVC to make sure they're filling up all the documents, they're paying the immigrant fees, and they're working with NVC to send their paperwork to the consulate. And that is what they should be doing if the dates are current. And because that again takes some time for the interview to be set up. And that being said, there is something called Child Protection Act. So according to the Child Protection Act, the dates will be frozen. So even if somebody is crossing 21, based on certain rules, the dates will be frozen. So if some particular things happened in some particular sequence, based on the time they had to wait for that I-130 approval, all that period will be added up. So so the first thing they'll be looking at is to see when their actual Child Protection Act's ages, to see if their age has been frozen or not, and then work with NVC simultaneously to get things over to the consulate and get a visa interview. And that being said, it is unfortunate that the dates are so backlogged, more than 15, 16 years for these F1, F2, F3, F4 categories. But again, I mean, all they can do is patiently wait for the visa bulletins. The day they see the date current in the second chart, contact NVC, work with NVC to at least making sure that all the documents are uploaded. They pay the immigrant visa fees on the NVC website, and things start moving towards the consulate. But if the dates are not even current, there is nothing that they can do, and they just have to wait.
Okay. Thank you so much, John, for taking that up as well. And we do have some Facebook questions from our groups. So let's quickly take a few of them first. And this first one is from an anonymous participant. It's asking, we filed I 485 and I 30 concurrently for my parents. We got RFE for not sufficient income and had to co sponsor my sister in law. We have interview in 2 days. What to expect in the interview? I'm very nervous.
Sure. So a lot of, so when somebody applies for a family-based green card, so in this case, U.S. citizen applied for their parents. So anybody that is applying for a green card, we do have to prove that they're not a public charge. So a lot of people think that a lot of these immigrants are coming into the country and the country has to bear all their expenses. No. So the reality is, whoever is sponsoring, in this case, their child is sponsoring their green card. So what typically happens is, to get the green card, they are actually required to show that they have enough finances, enough income to ensure that they don't become a public charge. So they're not a burden on the government. So in this case, what happened is they don't have sufficient income, but the government says that you can always use a joint sponsor. So even if the U.S. citizen does not have enough income, they can always use a joint sponsor. And the joint sponsor, basically what they do is they also sign the I-864 as a joint sponsor. And when they sign the I-864 as a joint sponsor, they show their income, and they will be able to show that because they have enough income and because they are giving those attestations that they will sponsor uh, uh, the immigrants, USCI should not have a problem. So what to expect? So what to expect is they will look at the sister-in-law's income. They will make sure the sister-in-law's I-864 is properly filed as a joint sponsor, and if that is done, they should not have any problem. So I think it is simply the question of having a joint sponsor. In this case, looks like they already have a joint sponsor, the sister-in-law, and by looking at the sister-in-law's income, I don't think they will have any problem with getting the green card for their parents.
Okay. And I think by now the interview is also done. I really hope they got through it. So now let's take this next one. Hello, has anyone had a situation like this? My mother in law had an interview for I 485 and was told she was approved at the interview, and few months passed by and was sent a letter that more evidence was required to decide on her case.
Yeah, it does happen a lot of times. I've seen this a lot because in the interview they say it's approved, but what happens is, again, something shows up on the background, and more than likely it is something small. Because sometimes I've seen, like, hey, can you send us the I-94 from so and so time, or can you show that somebody has maintained valid status from that time, or sometimes something very very simple. So I did have cases where this happened, where at the interview they were said everything was good, and then they got an RFE. But most of the time, my guess is that RFE is something very simple, because at the time of interview, if they said the case was approved, they probably passed all the background checks, but they found something, and that's why they got an RFE. I would not worry about it. I mean, as soon as you get the RFEs, immediately respond back to the RFE. Most of the time, the 485 RFEs, if you respond back, they are very quick at approving those 485s once you submit all the documents that are required by the RFE.
Okay. Well, thank you so much, Chant, for taking that up. Now, this next one is from Andre. Just a question: what kind of questions should a under 12 child expect at on interview?
Most of the time, because you'll have the parent. I don't think. I've not seen children under 12. I've not been in any interviews where a child under 12 was asked any questions. I'm not sure. But again, I'm not. It depends on the category they're applying, and it also depends on what kind of a filing it is, and so on. But again, most of the time, I think it'll be on the category. What kind of a category they're qualified uh, for that particular benefit? Is it a parent-child kind of a green card? Is it a green card-child kind of a relationship? Or is it like a employment-based 485? Or is it something else? So I'm not sure what exactly is the benefit they are seeking, because a lot depends on the benefit they are seeking, and what kind of interview it is. Is it a green card interview? Is it N600 interview? Is it N400 interview, and so on? Because if it is a child and if it is something like an N600, they typically waive those kind of interviews or have their parents come for the interviews.
All right. Thank you so much, Chand, for taking this up for Andre. This next one is from Dave. I am on my 14th month waiting for I-130 to be processed. Is this normal?
Uh, Nowadays, it's normal. I mean, I-130 is like extremely, extremely slow. So previously, when I-130 was done for somebody who's like spouse of a US citizen or parent of a US citizen, they used to be very, very quick. But the I-130 is for sibling quotas, like for somebody who's like a sibling of a US citizen. It used to take time. Even before it used to take like 3, 4 years for sibling I-130s. Nowadays, even for immediate relatives as in like spouses of US citizens, even for them, the I-130 is taking a very long time, and I'm not seeing any I-130s, standalone I-130s get processed before a year. And the USCIS website is taking as long as 24 months. So I think anywhere between 1 to 2 years is what somebody can expect their I-130 to be approved, and looks like nowadays it is normal. And what I think everybody should be doing is go to the USCIS website. You will be able to look up the processing times, and processing times differ based on where your I-130 is. There are multiple service centers with USCIS. So look at where your I-130 is and look at the timelines for that particular service center, and you'll be able to know. But again, I think that is what you're seeing is pretty much normal nowadays.
Okay. So delays have become very normal now. Has it doubled by any chance? Like, suppose it was like 6 months back. If it was like 6 months, has it become like a year now?
I mean, it's not anything to do with the current administration, because the I-130 backlogs, I've started seeing it like almost like from last
Yeah.
2 years. From the last 2 years, I think things have been pretty slow. So even last year, we were looking at like over a year timeline for I-130s. So I-130s have started going, have been taking a little bit longer time, and looks like, I mean, for the last couple of years, they have been bad. And this year, I think it's going to be even worse because all the backlogs are accumulating, and on top of those backlogs, you have more applications. So I-130 is one thing. Unfortunately, we don't have premium, so things are a little bit slow on that standalone I-130 side.
Okay. Well, thank you, Chand, for taking that up and for the detailed explanation. So, this next one is from an anonymous participant. Is it safe to go to the biometrics appointment with everything that's going on?
So when we talk about biometrics, there are two kinds of things. One is like say the 485 biometrics. The other is very recently, starting from last, I would say 4 to 6 weeks, we have been getting RFEs, and I've seen like a whole bunch of RFEs, probably more than 10 RFEs, where you file for a benefit, either an I-140, either a H4 or a H1B, for example. We are getting hit with this biometric appointment notices, and then when I go back and talk to these people who got these biometric appointments, always every case that I have dealt with, they had some kind of a brush with the law. Sometimes like a DUI arrest, or sometimes like driving without a license kind of an arrest, sometimes like domestic violence. So whenever there is some kind of an arrest record, and they had some issue with the law in the past, looks like it's flagged. And USCIS, anybody, if anytime they see some kind of an issue, some kind of a criminal record, they're getting hit with these biometric appointments. And I did have like a couple of our own clients call us and say, hey, is it safe? Should I go? Because they know that they had this issue with some kind of a criminal infraction in the past. My answer is, if you're applying for a benefit, like either a H1B, H4, or I-140, you get hit with this biometrics appointment. I mean, I would say it is mandatory. You keep up that appointment. You do that appointment, because what we are seeing is right after they go to that appointment, after a few days, we're getting an RFE, and in the RFE they're saying, yes, we did this background check, because biometrics is used to do a background check. Now USCIS is coming back and saying, yes, we did this biometric with this background check. We are seeing this criminal history, asking us to explain, and more than likely that is what is going to happen. So I do strongly encourage people to follow up with the biometrics appointment, and say in the future you get an RFE because you had something that they found with the biometrics. You follow the legal process, answer the RFE. Again, the good thing is, say you go to the biometrics appointment, USCIS does not see anything incriminating, anything bad, then you're good. You're all set. But again, if they see something, you can expect an RFE where USCIS will ask you to explain that criminal infraction, give all the criminal records. So typically they ask for police records, they ask for all the court records. So you do have to submit all the certified police records and the court records, because these two are independent. And then you have to answer your RFE, prove that you have not done any crime that makes you deportable, because not all crimes are deportable. All crimes are bad, but some crimes are definitely deportable. And your whole thing is you do have to show USCIS what kind of a crime it is, and do you qualify for any kind of exceptions. So that is pretty much what's going to happen when you see these kind of biometrics appointment that are recently being given to a lot of people.
Well, that was very interesting. Thank you so much, Chand. And I do hope that you have a little more time to stay with us because we have so many questions and I just want to keep going if that's fine a little bit. So this is from Charlie asking, "Hi, I just filed I-130 for my 17-year-old son and unmarried 24-year-old son. Do I need to file also the I-130A? Thanks."
So typically, I-130A is for the spouses. So when you file for a spouse, I-130 for spouse, I-130A is typically required, not for children. And I've not seen the recent instructions, but typically it's not for the children. It is for the spouses. I might need to check back the instructions, but I don't think it is for your child if you're filing for an I-130.
All right. Thank you, Chand. All right, I think those were some of our questions from our Facebook groups, but we do have from our live audience as well. So let's take this one from Manya. Hi, Chand. This is regarding the H1B amendment. Do I need to file an amendment if I move with in MSA? I just moved 6 miles away from the initial work location, which is on LCA. Do I need to file AR11?
So when it comes to amendment, it's location. You're only moving 6 miles. So the only question for you is: are the job duties still the same or not? If the job duties, the work is still the same occupation, uh, you don't have to file an amendment because the move is within the same metro area, only 6 miles away. So check with your employer to see if your duties are different, and if your duties are still the same, your pay is still the same. I don't think you'll have to file an amendment. There is no material change because it's only 6 miles away. But when it comes to AR11, AR11 is your address change. So anytime, anybody, including green card holders, if you ever move your address, even if it is a different apartment number, same apartment complex, but a different apartment number, anytime there is any kind of a residential address change, immediately within 10 days, file an AR11. You simply do it by going to the USCIS website. You can do it online. It is like a 5 minute kind of a thing. So AR11 is like you follow that whenever you change your residence. But amendment is not. I don't think it is required unless, in your case, especially unless you have different set of job duties.
All right. Thank you so much for taking that up for Manya. And Manya, I hope that you've gotten your answers. Folks out there, please do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And I'm sure, especially most of you who got your answers, don't forget to also share this content with your friends. So we have Sishu from Facebook. Thank you so much for joining us again. And he's saying this is actually a follow up to my question in the previous session. Okay. Welcome back. And a quick recap. The question, I recently had a client change within MSA region. Okay, I think we just took that up. So that was Sishu, I guess. Okay, let me read it anyway. And after considering my scenario, you suggested need not file an H1 amendment but instead do an LCA posting. When I asked employer about it, they mentioned LCA posting will be done only for fresh H1s and not for someone like me. I have my H1 started in October 2024. Would like to verify that info with you. Can you please confirm that? At this point, do I have anything else to do? When I go for the interview for H1 stamping, what documents should I carry as proof of evidence for not filing an amendment? And if you have any other suggestions for me to keep in mind.
Sure. So in terms of amendment, yes, you don't need to do an amendment. But regarding the LCA posting, you can Google it up, and there is a link. There is a clear DOL link where they talk about moves within the same metro area. So they clearly say that when you move within the same metro area, you don't have to do an amendment. So amendment is not required because there is no material change. But there is something called LCA posting. The reason they require that to be done is because people at the new work site, they need to be notified about a non-immigrant working and the conditions for that. So it's a DOL requirement, not a USCIS requirement, but a DOL requirement, and it is out there. There is a link from Department of Labor. So I mean, normally, again, check with your employer's lawyer, because they will have that link, and they will be able to send you that link where DOL clearly specifies that LCA posting. So all they have to do is simply put the LCA copy on the wall. That's all they have to do. They don't really have to do anything. It doesn't cost money. It's just a posting, and it is mandatory. There is you can Google it, and you'll find that you'll more than likely find that link on the dol.gov's website. So don't use any third party links. It is a DOL link. So use that link. That being said, in terms of filing with USCIS, no, you're good. If you have a site visit, you should not have any problem in terms of your H1B employment.
All right. Thank you so much once again, Chishu from Facebook, for participating with your question. And thank you, Chand, for taking that up. And also, Chand, I think before we leave, if because with so many people entering through different ports, are you seeing an increase in I-94 errors lately? And what should travelers be especially mindful of, during entry?
Sure. I see a lot of issues. The reason is, I mean, again, what happens is people always think that their H1B approval or their H4 approval has a I-94. So when they come back into the country at port of entry, they just give their passport, and the passport probably has a visa from their old employer, because a lot of times people, they do transfers, and when they do a transfer, they get a H1B approval with a 3-year validity. The visa is probably from an old employer, so the visa will have a different end date. The I-94 has another end date. Sometimes the passports expire, so the passport expiration date is sometimes different. And what happens is, when they travel back into the country, they simply give their passport. They simply, and the US nowadays CBP, they don't stamp the passport. They simply say yes, you're allowed in, and they expect people to look at their I-94 online. And a lot of times, what I see is people just assume that because their H1B approval has a different end date, they assume that the CBP officer also put the same end date on their I-94. But a lot of times, what CBP officers sometimes do is they match the end date on your passport, or sometimes they match the end date on your visa. Because sometimes it's a mistake. They don't look at the I-94 on your approval copy. So mistakes happen. So just to avoid that confusion, I do see it all the time. Every week, I at least have one case where the employee thinks that the I-94 is till the end date on their approval copy, but the CPP officer shortened the I-94 to the passport expiration date or the visa expiration date. Made a mistake probably sometimes. So people don't realize that. So yes, I do see this all the time, which is why we always have the burden. So like employee, you're traveling back to United States, you do have the burden to download the CBP I-94, because you see a mistake, CBP will correct it. But again, you do have to download and then look at it. In the olden days, what used to happen is they used to give a paper I-94 at the port of entry. You used to look immediately, spot a mistake. Nowadays, because it is online, people are not realizing that. So the simple solution is you come into the country, go to CBP website, download the I-94, keep it with you. Any mistake, they'll resolve it.
All right. Well, thank you so much, Chand, for taking that up, and for patiently actually taking up each of our questions today in this session. I wish we could continue on and on, but I think we will have to leave some of the questions for our next session. And I really hope to have you back soon again, Attorney Chand.
Sure. Thank you so much, Nipasa. It was very nice talking to you.
Same here, Chand. And all the best then, and see you soon. Folks out there, thank you so much for participating as well. If you want to have a one-on-one consultation with Attorney Chand, and you all you need to do is visit this link which is displayed on the screen, and yes, go check him out. Thank you so much, everyone, for joining us. And also, if you have any questions, or you want to get in touch with me for any questions which we can push it to our attorneys, you can reach out to me in my WhatsApp number as well. And my number is 408-335-6444. This is also my dial-in number. You can call me on this number. And my email is nipa@staffingme.com. So feel free to reach out to me. And yes, check us out. We are Immigration Talk Show. Our handle is at Immigration Talk Show here on YouTube. So subscribe to our channel, ring that bell so that whenever we have discussions like these, you do not miss out on any, because we have very important information to share with all you folks out there. And also check us out. We are on LinkedIn, Facebook, X, and on Instagram to stay connected with us. So thank you once again, everyone, and stay tuned on Immigration Talk Show because there's a lot more coming. Have a wonderful day.
Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam. And today we are back again with a very exciting and important session that is lined up just for you. And before diving into the topic, let me go ahead with this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. Use of information at your own risk. All right, friends, with that, once again, welcome back everyone to Immigration Talk Show, and I'm your host, Sam. And today the topic is green card process, myths versus reality. What's the truth? So, getting a US green card is like dream for many, but it's also surrounded by confusion, rumors, and half truth. Some say it takes decades. Others think that it's just a matter of luck, and many believe that you just need to marry to a US citizen and you'll get a green card. But you know what is actually the reality behind the green card process? If not, then this video is for you. So make sure to watch this session till the end and also participate in this webinar by asking more and more questions. Because in this session, we are going to break down some biggest myths, also going to reveal the real facts, and also help you understand what actually works and what doesn't. And to help me out, make this session a wonderful one, I have a very special guest here. Joining me in a bit, none other than very energetic and a great speaker, Nandini Nair. So, hi Nandini, and thank you so much for joining here. So good to have you here.
Thank you, Sam. I really appreciate it. I'm happy to be here.
All right. And friends, let me tell you about something about attorney Nandini Nair, that she is a partner at AY Strauss and leads the immigration practice with over 25 years of unmatched expertise. And her insights have been featured in the New York Times, CNN, Bloomberg, and more. She's also been recognized as a trailblazer in the legal field. So many great things about you, Nandini. And once again, welcome back to Immigration Talk Show. I'm so happy to have you here. How are you doing?
I'm good. I'm good. I'm happy to dive into this topic. I think it's really important. So,
Absolutely. It does. And the session is really going to be interesting because we are going to burst some amazing myths and facts. So let me go ahead with my very first question. And, this is very important that, according to you, Nandini, that you have a lot of experience regarding immigration and everything. So, till now, what is the biggest myth that you hear about getting a green card?
I think. Well, I think it depends on the background of the individual. Some people, it's an easier route. Okay, it's that's the truth, right? If you're from Europe, get sponsored by an employer, wait time is a lot less. If you're Indian, obviously it's a lot more. So the
Yeah.
myth, I would say, for your audience that I hear from business side especially, is the way they think they qualify for a certain type of green card is actually not correct. They are, my friend got their this way, and so I should be able to get it this way. And in my practice and in my years of experience, my biggest thing is having to disappoint some people to tell them, no, you don't qualify. I understand where you think this is how it works, but it actually isn't. So the biggest myth I always find is that they assume that the road that somebody else followed is the same road that they get to follow based on whatever criteria is. And that is something that I face every day with the people, having to walk them through this journey.
Wow. It's not just about Nandini, the green card process, but generally, and mostly in terms of immigration, people should understand that everything depends upon case to case. Each case is different.
Mhm.
So that's amazing, and thank you so much for making us understand. Instead of assuming, it's better to be on the facts and get to know what the actually things are. And I think let me go ahead with my next question. That can you burst the myth that a green card is actually the final step in the immigration journey, or is there more?
Yeah, there's more. Obviously, it's getting citizenship, right? The green card is a very important step, and you can live in the United States forever without getting to that next step. But is that the final step? No, it's the citizenship is your final step. And I always recommend most people, again, based on their own circumstances, to go and get that citizenship. Why do I say that? Because even if you have a green card, you can still get deported. You can still be forced to leave this country. It is not the safety net you think it is, as we are seeing today with this administration. So,
Yeah.
do you want to create a safety net for you and your family? The best option is whenever you're eligible, file that US citizenship and become a US citizen. That's going to protect you in the future.
Absolutely. And I think that was really a great point, Nandini, that, my next question was about to be that if somebody has a green card, then what are the chances of deportation? Because people think, they assume that they have a green card, so it's impossible for deportation. But I
No,
think that's,
that's that's not true at all. Actually, you can get deported. You are not a citizen of the country. You are a citizen of another country, and you are just getting permission to live here legally and to be able to work without having to have a visa of some kind. That's what the green card gives you. You're not allowed to vote, right? So the government, has the ability to say, if they don't like you because, let's say, you committed a certain felony or certain crimes or certain situations like that, they can then have the legal authority to deport you. If you're
yeah.
watching the news today, you're going to see people who have valid green cards. They've been here for years and years, but maybe they were an activist and maybe they got arrested for something like that. And you are seeing these individuals getting deported or being put into detention. So
Mhm.
no, green card does not give you full protection to not be deported. You have to always still mind the laws of this country. You have to still follow, the conditions of the green card.
Yeah.
There are people who think, oh, well, I got the green card. Now I'm going to go live in India, you
Mhm.
know, because I have this safety thing. No, it doesn't work like that. There's conditions to that. You can only leave for a certain amount of time. If you want to come back, you have to have a certain type of permit to come back in. And if you don't have those, your green card is gone. So
True.
again, it's important to know that the green card is not the final step here. Go for that citizenship. And if you become a US citizen and you want to go back to India, you want to go back to China, you want to go back to Europe, wherever, you will still be able to come back into the United States, unlike a green card holder. You could be gone for 20 years, you could still come
Mhm.
back. So, yes, green card holders can be deported from the United States. It does not give you the protection you think it does.
All right. Thank you so much, Nandini, for explaining us about that. And friends, till now we have covered few questions. And in case if you still have any queries or anything regarding the topic, then please go ahead. You still have time. Put them on the comment section, and we will definitely take them up. Till then, also if you haven't subscribed to Immigration Talk Show, make sure you do it right now. Okay, Nandini, now this next question is again a very interesting one. And this is, most of our friends also says that best and the easy way to get a green card is to marry a US citizen. So
Mm.
what is actually the reality behind it? Like, is it true that marrying a US citizen truly makes sure that he has green card, they'll get without any delay or without any denial? What's the reality behind it?
Okay, first of all, there's no guarantees in any application, right? So that's a myth. That's a myth right there. There's no
Yeah.
guarantees. Every application stands on its own merits and its own facts.
Mhm.
Is marrying a US citizen one of the safer and fastest methods of getting that green card? Yes. That is an absolute truth. That is. But when I say it's not a guarantee, it also depends on the facts of this case. For example, I have practiced enough where I have seen people get married for just getting the green card. They were not really relationships. It was, individuals who are making a deal with each other for payment and getting the green card.
True.
I have seen also issues when people, especially in our culture, they have arranged marriages, right? Because then those, even though that's a cultural norm in our culture, it is
Yeah.
not the cultural norm here. So
Mhm.
those type of applications will have a difficult, not impossible burden to overcome, to show that this is not about just getting the green card. This is a valid relationship. They are involved, they want to live their life together. So again, everything runs on facts, and
Mhm.
everybody's case is a little different. But if somebody asks me, hey, what's my fastest way to get a green card? And this is not a, again, uh, saying it to tell everybody go jump and marry a US citizen. I'm just going to tell you on the processing and on the facts, yeah, that's your fastest way to get the green card. Absolutely.
All right, absolutely. That's very well put up. That is the fastest and the easiest way. Not easiest, but at least better than the other ways. But it's also not the reason, that anyone who doesn't have a real relationship can go ahead and get married.
Mhm,
And
mhm,
also, Nandini, one news I'm remembering that
mhm.
right now, these marriage based green card interviews are also being stricter. I mean, the questions will be asked a little specific with the couples, right? Earlier, it used to be some documents and I mean, little lenient way, but now it's going to be a very tough way. So, if you can also let us know something about, interviews, like what questions
Yeah.
officials can ask, then that will be very good.
Yeah. So let me first of all say that when I look at these type of cases, the first couple of things I look at is the ethnicity of the two individuals. And it sounds silly, but what I look at is an Indian person marrying another Indian person, okay? Or is it a American person, let's say white, marrying an Indian person? The
Mhm.
reason those things are looked at by me is because the officer looks at that, because generally they understand that Indians generally, again, it's not all the case, it's, and it's less and less, marry other Indians. So when they marry outside of their ethnicity, that opens up a red flag in their mind. Like, oh, okay, right? So how did you guys meet? So now the officer is going to say these type of questions. So how long did you date? And remember, it may be against our cultural norms to be dating, like, here, but that's what they're looking at, right? Oh,
Yeah,
so you're different. Okay. All right. Did all your family members were at the wedding? That's one of the questions that people don't realize. You are not just going to City Hall and getting married, and that's the end of that. They're going to question that, because also culturally, Indians have big celebrations and family members come and things like that. So they look at that. They look at the pictures,
true.
and stuff. So they'll ask about those type of questions. They will like look at your Facebook. People ask, oh, do they actually look at social media? 100%. I always ask for social media snapshots. because generally most people tag their husbands or spouses or girlfriends and things like they post pictures. So these are definitely things that people need to be very aware of, that the officer will look at and ask these type of questions to you. But the history of the relationship is the main thing that they'll ask you, is how did you meet, when did you meet, why did you decide to get married, who was at the wedding, how, various questions like that will be asked at every single interview that I've ever been to. So they should be ready for that.
All right. Okay. I am sure our viewers are keeping a note of all the pointers that Attorney Nandini Nair is explaining. And let me go ahead with my next question, Nandini. And this is about, do green cards expire? And does expiry means that someone has lost their permanent residency?
Right. And this is a myth. This is definitely a myth. And let me break down the reality. Yes, green cards, the actual physical card generally has a 10-year expiration unless you got a 2-year green card. Okay. Yes. And there is an expiration date on that.
Okay.
But it does not void your permanent residency. It does not void your green card status just because the card expired. That is actually a big myth that people seem to have. Like, oh, my card expired. How am I going to, work, or how am I going to do this? No, you got that green card status is attached to your body. That card is just a evidence to show that, hey, I have this status. It doesn't, so if that expires, it does not take that away from you. Now, of course, I always tell people never let it expire. Try to renew it if it happens and stuff like that. But I have clients that, it expired 10 years ago and I had to, get a new card for them. Don't have to refile the application for them. I just have to get them a new card. So people should be very much aware. If the card expires, don't freak out. It does not mean that your green card status has expired. It just means the card expired.
Okay. And also, Nandini, talking about, is there any limitation regarding renewing the green card?
No, there's no limitation as long as, you can do it before, like 90 days before, you can do it a couple of years after if it expires. Again, you're going to do fingerprints, obviously. So every time somebody does renew something or put in an application, I always make sure that clients understand this, and I check their backgrounds every time I'm doing an application. If from the time you got the green card to the time you're going to file a renewal application, something has happened in your background, that's going to be a flag, even on the basic renewal. You're like, hey, is this person doing something wrong? Right? And remember, you're going to get fingerprinted, right? So if you had a criminal issues and things like that, you are going to might have some problems here. So that should be asked. And even when you naturalize, okay, when you go and apply for citizenship, they're going to go back through that history and stuff because you're going to do fingerprints. So
Yeah.
all of these things can, cause the pullback of that status. But just because the card expired and you have not, that's all that happened. No, you could just go and get it renewed and stuff.
True. All right. Okay. And let me also say hi to our viewers because Ricky is here, Ranjit is here, Jadav is here. So, hi, guys, and thank you so much for your questions. Okay, let me go ahead and take up Ricky's comment here. So, Ricky is saying that if I'm not the founder but a core member of the startup helping technically as well as in raising funds and bringing in new projects, can that be used in EB1A application?
He's not the founder, but he has helped to develop, and I assume what he's saying is grow the company. Can he apply for an EB1A? Under extraordinary ability, is he talking about, I assume? Again, every application, listen, works on its own merit. This is another myth that I deal with so much in this green card application, where we have individuals who believe that based on certain things that they have in their background is sufficient enough for them to get that green card, whether it is a multinational manager, whether it's the EB1, extraordinary ability. They don't understand that each application is a case, like a trial, right? Like you got to put up your evidence as to show that, hey, I am this, this, and this. And just because you have evidence one doesn't mean you got it. You, if the requirements are 8, let's say, you not having 5 is a problem. And even that 3 that you seem to have, if they're weak in their quality, in their content, okay, so you have some publications. You published in like some little paper, with a team. Oh, but I was publicized, no, that doesn't work. If you're a doctor and you were published in the New England Journal of Medicine, that one thing might be enough to help in that criteria. So everybody has to understand that having a few little dots here does not make the whole application, and it does not make a successful application. That's why you really have to talk to a lawyer, have that lawyer walk through your background and say, okay, I think we have a shot here. And I'm very honest and to a fault in that, because I'm not here to waste anybody's money. And I always tell them, listen, this is a weak application. We can take a shot, but I'm going to tell you right now, this is weak. I have 25 years of experience doing this. I can read it immediately when I see it, like, this is not going to work and stuff. Or, hey, this is not a bad place. Let's go. Let's take that shot. I can pull it together for you and stuff. So again, people who are founders or people who are not founders, it doesn't mean about that. It's, again, where's the rest of the criteria? What else you got to show the officer, So again, to Ricky, if it is, Ricky, talk to a lawyer, show them the background, see if that can work for you. Do a consultation with somebody, don't sit in your own mind thinking this will work or not work. Get some expert advice here.
That's right. And Ricky, why don't you go ahead and get in touch with attorney Nandini Nair, because she has lots of experience, and with two expert advice, she is going to give it to you. So please go ahead, visit the link that is on the screen, and you'll get the contact details of her. Reach out to her and share your query or your doubt regarding whatever problem you're facing, and she would love to help you out. Okay, and with that, Ricky, if you haven't subscribed to Immigration Talk Show yet, then please do it right now. And let me go ahead with Supriya's question. So Supriya is saying that I have heard so many things online about how long the green card process takes. Like some say it's just a few months, others say it can take years. What's the actual timeline I should expect? Yes, Nandini.
That is a $1 million question. Okay. So Supriya, it's all of that. That's the funny part. It can take a few months, and can take a few years. It can take a few decades and stuff. It actually really depends on a lot of different things. One is your country of birth, not country of citizenship. And as you're probably hearing, yeah, it'll take years and years. Unfortunately, for nationals from India, China, Mexico, Philippines, okay, the backlog is tremendous.
Yeah.
Even though they have the same exact qualifications from somebody from Australia, and they're following the same exact path, whether it's an employer-based filing or something like that, their route and their timeline is going to be different than yours, simply because of your country of birth. So, that's one important factor. Second important factor is, how is the green card being filed? Like we talked about marriage to a U.S. citizen, right? Obviously, that's the faster route. But employment-based, there's different kind of categories. Some categories are faster, some categories are less. But again, you have to look at where the person is from, the category that they're going to file, and it can move back and forth. An Australian person who's an EB1 can get their green card, I'd say like a year, less than a year, maybe even, But in EB1 India, same exact qualifications, we're backlogged like 4 years now.
Oh my God.
So EB2, Australian person,
Yeah.
can get it probably in 2-3 years, just because the situation is difficult right now with the perm process. An Indian individual starting in 2025, they're looking at 30 years.
Oh my God.
Exact same person, right? So again, that's why there's not a right or wrong answer, and that's why you're confused, Supriya, because it can go from months for some individuals to decades for others.
That's right. That's a bit of truth, I'll say. And
Mhm.
there's a follow up. Okay, she's saying, Supriya, that does it really depend on where I'm from or the type of application? Exactly. That's what Nandini you have shared. And Supriya, I hope that you got your answer. It was really a very interesting question, a $1 million question. And in case if you still have any follow up, then please go ahead and put them on the comment section. We will let you know more about the topic. Okay, Ranjit is here. So, hi, Ranjit, and let's see what he is asking. He's saying that I'm a bit confused about the whole priority dates thing I keep hearing about. Can you explain how priority dates work and why sometimes they move so slowly or even seem stuck? Okay, another interesting question.
Yeah, wow, Ranjit, you're asking a good question. Okay, so very simply, okay, the US government has said we will allow a certain bucket or certain amount, quota of green cards into the country every single year. Okay,
Yeah.
there was a laws passed, the Congress agreed. They said, okay, ABC. So to think of it like they said 100 green cards can be issued every single year. But then they said, listen, we don't want one country to dominate those 100 open slots. So we are going to put in a second hurdle and say only 7% of that 100 can go to one country at a time. Okay. And within that 7%, you have to break it down between the different categories you have EB1, EB2, EB3, EB5. No, EB5 has a separate category, but like those categories. So think 100, 7% of 100, and then breaking it down between those categories. Okay. So that's important to understand how there is a tiny amount of green cards that are actually being issued for an Indian national, a Chinese national, a Mexican national, a Philippine national, because you're capped at that 7%. So then the 7% also includes spouses and kids. So you got a family of four, they just took four green cards right there and then. Okay.
Mhm.
What's the priority date? The priority date is the place in the queue. Because, right, we have a queue here now, right? So how do you get a priority date? Your priority date is based on certain type of applications. It may be the perm application that you filed. When that's filed, that sets your priority date. Okay. When you maybe you don't, you can skip that and you go to the I-140 because based on the certain category. When you file the I-140, that sets your priority date. And that's the date you're looking in that visa bulletin, say, India, I'm an EB2. Oh, here we are. That's where I am. And why does it move slowly and even stuck? Because of that 7% issue. India has an oversubscribed population, meaning that there are thousands more applications than the available spots every single year. That creates the queue and that creates the backlog. And the reason it gets stuck is because the families are taking these green cards. It's not based just on the principal person filing. It is also they count how many family members there are. And we don't know how many family members there are or CIS until the 485 application is filed and approved. That's why the data is never accurate.
Wow. So much to process. And that was beautifully explained, Nandini, explaining everything from scratch. Really great. And I'm sure, Ranjit, you have got a proper understanding of the topic. And in case, if you still have any follow up or want to know more, then please let us know and we will take that out. Okay, Ricky is here with another question. And Ricky is asking that can you give some tips on expediting EB1A application based upon senior role in advancing a startup?
Again, I think every case stands on its own merits, and it's impossible for me to just give you a like 1, 2, 3, do this and stuff like that. Everything has to look, I have to look at the case. I would have to look at the background. I would have to look to see what are the criteria. And like I explained before, individuals sometimes have this idea that, hey, I met one or two of the criterias, so I should be qualified, and sometimes I get people think to me as the lawyer, like, well, can you help me with 3, 4, and 5? No, I can't. Like, I can help you organize it, I can help you frame it correctly, I can help you present it well and stuff, but I can't do 3, 4, and 5 for you. So I would say, Ricky, if you're looking for tips on this, again, I don't think any lawyer, really a good lawyer, would be able to kind of on this kind of format be able to give you that advice. I think it's an individual conversation that you must have with a lawyer, where they review your background, and then they possibly can give you a better understanding of where things can work or not work for you. So I really just recommend that to you.
All right. And I think, Ricky, you can directly go ahead and, get in touch with the Tony Nandini Nair. You just have to visit this link and you'll get the contact details of her. So go ahead, reach out to her and give her a proper detail about your status so that she can, advise you in a better way. Okay, and with that, let me take up Jadav's question. So, hi Jadav, and thank you so much for your comment. He's asking that I'm a graduate with 20 years of experience, married, and have 1 year kid. If I want to apply for a green card, then what strategies should I follow? And what are the chances that we will get the green card and when?
Okay, Jadav, I'm assuming you're here in the US on a visa. Otherwise, you wouldn't be asking this question. Again, what's okay, so there's two. You're already married, so a family based, the fastest route is not going to work for you, right? You're already married, so generally people will say you marriage to a US citizen is the fastest way, but since you're already married, that's not going to work. So family based option is not going to work for you here unless, again, you have parents who are US citizens and they're able to sponsor you as an immediate relative. That's going to speed up the process and stuff in certain ways. Not as fast as you being a minor child, but some option is there. Other than that, it's employment based, right? Which is where you have to have an employer sponsor you for a
Yeah.
green card. And if you are Indian and if you're going through the traditional route, unfortunately, I don't have great news for you. It is going to take years and years to get to that final step of the green card. But if you start, the sooner you start and have that conversation with the employer, the better for you. Unless you are like, I'm just going to keep it working for 6 years here. Or if you're on an H, for example, 7 or 5, if you're on an L, and I'm going to go back home and that's all it is, that's fine. But most people, especially when they have kids, they're desperate to have that green card, right? Because they want the kids to be able to have an education in the US and go through, they don't want to pull them out from here. So, but I would say, Jada, you have to talk to your employer. If you are working here in the US on a visa, and that's probably your only real option. Obviously, there's the EB-5 option, also investing money and stuff like that. But even for Indian nationals, that's a backlog of like what 4 or 5 years now. But obviously, much better than doing the traditional perm process and stuff. But there's a lot of money and capital you have to put up, and just different things like that. And people sometimes don't just have that option. So, but talk to your employer if you're wanting to go the traditional way.
All right. So, Jadav, I hope you got your advice and you will make a note of it. And here's a follow up question from Jadav Nandini, that is it true that hiring an attorney can speed up the green card process, or does USCIS treat your case the same whether you have a lawyer or not? Okay, what do you have to say on this?
Listen, you don't need a lawyer to file anything. Really, you don't. Okay, I'm not going to say you do. However, what is the purpose of having a lawyer? The purpose of having a lawyer, and obviously an experienced lawyer, is that they understand the system. They understand the agency. They understand what you need to present to get a successful outcome. That's the reason you go to a lawyer. It's the same way you go to a doctor, right? Like, or a nutritionist. Is it that, or to a trainer in a gym, right? I think we all know how to go to a gym and do something, but why do we use a trainer? Because they give you the expertise and knowledge to get you the result that you're seeking. Same concept with a lawyer, right? I'm going to put that application in a way that I know CIS wants to see it. You don't know it because you don't file those things. I know it, right? And that's what you're getting from me. My knowledge, my experience, my strategy, my know-how, my inside information that I might have, things like that. That's the purpose of hiring an attorney. Otherwise, yeah, go for it. If you think you can do it yourself, go for it. Not a problem.
Absolutely, and that's very well put up. I love the example, Nandini, that you have put. But I think, keeping in mind the terms and conditions. Right now, the immigration policies are changing day by day. It's better advisable to have an attorney and get an expert advice, because everything is changing, and so many new rules and policies are coming day by day. So, Jadav, I think it will be a little safe option for you to get in touch with attorney Nandini Nair, because that is the way, that will be easier and fastest way for you also to get your green card. Okay, okay, Ranjit is here and he's saying thanks, Nandini, for explaining it in simple words. That's so sweet. Let me go ahead with Gigi, and Gigi is saying that my son just turned 21 in May. Should I wait a while for him to petition for me, or is it okay to file now? I came in with a visitor visa and has been here for 25 years.
There's no waiting period once he becomes 21. But here's the issue. Um, how's he going to support you? So when a petitioner files for a green card for a family member, they have to financially support that person, or you have to get a co-sponsorer. So when someone is 21, are they working? Are they still in school? How will they be able to prove that they can financially support you until you become a US citizen, which we're looking at, years from now?
Yeah.
So it's not just your son turning 21. Look at the other requirements for that green card application. It's not just the relationship, it's the financial ability to support that applicant that also is important. But you can also get a co-sponsor and things like that. Some people are very resistant to that because now, especially with the Trump administration, they are definitely looking at some of those things and saying to people, the co-sponsors, are you still supporting this individual? Are you going to support this individual? So people might be a little nervous about doing that. So, but you have to kind of put that into perspective about the financial part of it.
Okay, all right. So, thank you so much, Nandini, for taking up these questions. And now we would also like to move ahead with Facebook questions, because we do have lots of viewer over there. So, Control, if you can please share your screen and you know, please make us aware about the Facebook questions. Okay, so this is pretty long, but let me go ahead. This is a question we got from our viewer, and who is saying that my post completion OPT ends on June 2, 2025, and I'm planning to apply for the STEM OPT extension with the requested dates of June 3, 2025 to June 2, 2027. But my college DSO sent I-20 with post completion and date as 1st April 2026, and STEM OPT start date 2nd April 2026, and end date is 1st April 2028. So I'm applying to USCIS for STEM EAD with this I-20, but dates are not matching. The DSO informed reason for this as the cap gap extension has been automatically added to your service record, which in your specific case results in an updated end date of April 1st, 2026. Therefore, the service system forces us to issue the STEM OPT recommendation dates based on that date, this resulting in your STEM extension showing on your I-20 as April 2nd, 2026 to April 1st, 2028.
Mm.
Your I-20 is correct. If your STEM OPT is authorized, USCIS should issue your EAD card based on your correct STEM OPT authorization period, which in your case will be June 3rd, 2025 to June 2nd, 2027. So, will USCIS accept my STEM EAD application with I-20 shared by DSO, which have different dates? Yes, Nandini.
Okay, so This is a little confusing to me because he's talking about the cap gap extension. So that's issued generally when somebody has been selected in the H-1B.
Mm-hmm.
So I'm not sure if this individual, if that's what's going on, and that's why the dates are off here. But do I think they'll accept it? I think yes. I do agree with the DSO what they're saying, and so I think you should not have an issue applying with this I-20 with the different dates. And if anything, they might kick it back, and you might get it, like an RFE, and your DSO will provide a letter, and you should be able to get that through pretty easily and
Okay.
stuff. So I'm not super concerned about that. Based on these things, like I said, the cap gap is throwing me off a little bit, but the other stuff, yeah, I'm not super concerned about it.
All right. Let's move ahead then with the next question. I think we can't see the next question. Control, can you please change the next question? Um, I think there are some internet issues that we can't see the next one. But that's okay. I think let me go ahead with another question that I have with me, Nandini. And
Mm,
till the time we can, continue with the Facebook questions.
yep.
Okay, so this is another myth, Nandini, that most of the people say. Many people believe that having a US born child automatically gives them a green card. So I would like to know, like, how accurate is that?
No, that's not accurate. That doesn't. It's not an automatic process. Like we were just talking with Gigi, right? When your child turns, if they were born in the United States, and a lot of people's kids are born in the US, right? They're here on visas, they have kids here, and the
Yeah.
kid turns 21, then the kid can sponsor the parents. Yes, that is all true, but again, it's an application. As we talk about it, nothing is a guarantee, right? Everything has to stand on its own merits. Everything has to be decided by USCIS. And just because your child is a US citizen does not translate into you. It does not transmit to you. They have to get to 21, then they have to put in an application, then that application has to get approved. That's the process of getting the green card through your child.
Absolutely. And many people think, just by having a child, they're going to get the green card. But no, that's not the thing.
Mm.
And Nandini, I think we have a Facebook question here. So this is I have been sent my passport along with a 221G form, asked me to come.
Mhm.
Along with passport and this blue 221G form, have not asked any documents, then what it means.
So if they've asked you to come for an interview, that means they have some questions. They don't need the documents because either they have documents from your application that's sufficient, but they have
Mhm.
some extra questions they have want to ask you. I see this all the time that there's not additional documents that are being asked. My response to you to prepare for this is have your documents still with you. Whatever you are going to present, and even if they haven't asked for it, still bring it with you in the
Mhm.
event that the officer asks for something, or you some clarification. So don't walk in there without all of that information. But is it like common not to get any document requests? Yes. But they're there to interview you. Yeah.
Okay, that's great. And there's another question, Nandini, and it is that do I need to submit my new I-94 to USCIS after my return? Since after travel, I-94 gets updated.
um, I'm not sure what that means, but what I'm assuming is in the olden days, before I-94 was automated or electronic, we used to get a card, right? When we used to enter, and that card was attached to a page in our passports. And
Mhm.
the law was that when you were leaving the United States, you are supposed to hand that back over to the airport officials who are looking at these things so that they can then manually go in and enter this information in the system. And if you didn't, then it could cause some problems and stuff like that. Your record isn't clean. You don't have to do any of those things right now. Your I-94 is linked to your passport, so when the passport is scanned upon your, departing the U.S. or returning back to the U.S., it automatically gets updated on the CBP website. So there's nothing you personally have to do at this point.
Okay. Okay. And let's move ahead with our next question. Okay, this is from Gopal, and Gopal is asking that family based adjustment status filed on November 29, 2024. So biometric is done. When can we expect the green card? Yes, Nandini.
I mean, what do you mean by family based, right? There's very different processing times generally, right? Is it marriage to a U.S. citizen? Is it parent of U.S. citizen? Like there's just different things. But generally, let's say you're here, you filed an adjustment of status. That means that you filed a 485, you filed it about November 29th. So let's say December 1, generally it's only been 7 months. You are looking probably at least, if it's an immediate relative position, I'd say towards at least towards the end of the year. I'm not seeing that any earlier than that at this point. And remember, there's interviews now, so local offices, processing times are different. If you're filing in Iowa, where there's not that many applications or something like that, the interview schedule is much better. If you're trying to file in New Jersey, when there's so many applications, there's hardly any spots at this point. So it all, like I said, everything depends on the facts of each individual situation.
Yeah.
I know everybody wants like a B C, and it fit to everybody's profile. It just kind of unfortunately doesn't work that way. You can get high level information, but keep in mind that everybody's case is different.
That's so true. That's so true. And thank you so much, Nandini, for explaining everything in a great way with amazing examples. I personally really enjoy having shows with you, and I hope you also do with me. But that was really amazing, and I'm really looking forward to another session. And friends, let me tell you that Nandini is a little busy today, so we have to take a leave 15 minutes before. But you can also get in touch with Attorney Nandini Nair in case if you are still having any questions. Go ahead, get in touch with her. You'll get the contact details and she's going to help you out. Thank you, Nandini.
Thank you for having me, Sam. I appreciate it.
Thank you. All right, friends, with that, that's the end of this webinar. And thank you so much for joining us. Don't forget to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. And also follow us on LinkedIn, Facebook, X, and on Instagram as well. Until now, it was really great having Attorney Nandini Nair here, and we have understood so many things about green card process. So thank you so much, everyone, for joining us. I'm Sam, and keep watching Immigration Talk Show.
Hello, everyone, and welcome back to Immigration Talk Show. I'm Nepasa, and I'm going to be your host for this session that's lined up. And before we head on with today's discussion and we have our guest join us, I have this important disclaimer. And that is by watching all our videos, you understand and agree that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use at your own risk. Well, Thank you so much, everyone, for joining us. And absolutely, like I said, we are going to be joined by a guest for today, and we're going to be discussing on preparing for the unexpected. What happens during an H-1B work site inspection? So, yes, we're going to talk about different site visits and how it going to affect and how to prepare ourselves for it as well. And to help us through all of that and dive deeper into this topic, we've got none other than Attorney Justin Rivera from Boston Immigration Litigation join us. So please help me welcome him once again. Hi, Justin. How are you doing today?
Okay, it's a Friday, so going into a long weekend, so that's always nice. But yeah, I'm doing well. How are you doing?
Doing good too, and I'm excited to, yes, the long weekend. Memorial Day, right? Monday is also going to be a holiday, I think.
Yeah, that's correct.
Absolutely. So I'm excited for today's session, and this is going to be a good one because everybody they have been very concerned about site visits and how to prepare themselves, whether to answer or not to answer. So a lot of questions from my end, and I'm expecting folks out there to also participate with their questions. And let me tell all you folks out there, all the viewers watching us right now, you can join us by commenting wherever you're watching. Our handle is at Immigration Talk Show on YouTube. You can share this with your friends and folks who can also join us. And another best thing is you can call us on this number. So dial this number to join us on call, and the number is 425-436-6335, and the access code is 988-888. So I think, Justin, let's waste no more time and go directly into the questions, if that's fine.
Yeah, absolutely.
All right. So this first question I have for you is, what are some common reasons that trigger an H-1B worksite inspection?
So when it comes to worksite inspections, they're done by FDNS. FDNS is the Fraud Detection Division of USCIS, and they have the ability to do random site visits, and they do enforce random site visits, but they also have the ability to do a targeted site visit where they basically say, we have procured some information that leads us to believe that there should be additional inquiries made into this organization or this individual petition. So, how that can happen is a candidate could be going for a visa interview at a consulate, the U.S. consulate, and make a statement that the consular officer thinks is odd or off. And then that individual, the consular officer, will basically write up a report where they make a recommendation to FDNS to proceed with an investigation. So that way that would work. Like, let's give an example. Let's say candidate A, he goes to the consulate abroad. He's going for an H-1B visa interview. During the H-1B visa interview, candidate A is asked, where are you working? And he says, oh, I work in-house with my company. And they go, okay, well, what do you do? Like, what is it that's being done in-house? And he goes, well, I work on Project A. And they go, okay, well, can you show anything, any proof that you've worked on Project A, or what is Project A? And the guy gives some sort of answer that's like it's not a passing muster for the consular officer. So the officer could give the person a 221G or a visa refusal, or they could even approve the visa. But after that conversation, the officer has the ability to write a report, and that report basically will contain information like individual claims to be working in-house on Project A. Project A is not well defined. Look into. Okay, now the case moves over to FDNS. FDNS is going to have the ability to say, okay, let's look at everyone who has a petition filed with this company that says they work at Project A. They work on Project A in-house. Let's pick a couple of them and do site visits. And so now you've opened up this investigation with FDNS where they're targeting a specific thing. They're not going to tell you that. You're never going to be given the justification as to why the site visit is occurring. That is all behind the scenes. And in fact, they're going to do is say, we're doing a site visit. Sorry, I had a piece of hair on me that I thought was a bug. They're going to do the site visit saying, this is a random site visit. It's just a site visit that, we're doing because you were randomly selected. That's not true. They already have something that's giving them a justification for the site visit. And so what they're trying to do is work backwards from that to find a reason why there's an issue with the petition. And the name of the game is fraud. They have extrapolated the definition of fraud to basically include any deficiency in a petition. So what do I mean by any deficiency in a petition? Okay. LCA says you're going to be working in Austin, Texas. Site visit happens. You're actually in Dallas, Texas. Well, before, that's a violation of the LCA, which totally actionable from the perspective of saying violation of the LCA, we're going to issue a notice of intent to revoke, saying that the LCA is deficient. Well, before this administration, that's probably the end of it. You file an amendment to get the petition corrected. They send it in OIR. You let them know you've corrected the petition. They'll probably revoke the previous one. Maybe you see some small issues with the amendment. It depends. Now, instead of issuing an NOIR where they're saying, hey, the LCA is not in compliance, they're going to issue that, and then they're going to say under it, statements of facts were not true. And what they're going to allege is you committed fraud or misrepresentation because this person's not working where you said that they did. And I want to really, really suss out the difference here in what is being done. Beforehand, if they revoke your petition, that H-1B is revoked. But the revocation just basically means you can't work subject to that petition. You could still work subject to another petition that's subsequently filed and approved. Now, if they're putting fraud or misrepresentation in your record, and the NOIR, the revocation occurs, and the revocation notice includes that language saying fraud or misrepresentation. Well, now you have a company that has a taint of fraud or misrepresentation on them that is probably going to follow them on any subsequent petitions that they file. It's definitely going to be something that is kept within USCIS's records and database. They're going to always have a record of the petitioner and that instance of alleged fraud. It's also going to be an issue for the employee, because if the employee has a fraud finding placed on their record, that finding carries with it an inadmissibility bar. That inadmissibility bar previously was something that was going to come up when the individual goes to adjust status or when they go to apply for a visa at the consulate. Those are each times where that issue could occur. Now we're seeing USCIS is bringing up this bar on any subsequent filing that occurs in the United States. Meaning, you file an extension. They say you can't qualify for an extension. You're inadmissible because of this fraud finding. You file a change of status. Same thing. And of course, you go to adjust and you have that same issue. So it's a very serious thing that can occur. And it is being wielded in a much more liberal way than it was prior to this administration. Hopefully that answered the question.
Well, thank you so much, Justin, for that. And really, I mean, it's crazy because, yes, there's a lot of fraudulent activities, and, USCIS and the whole immigration system, they're trying to check it. One step at a time, it's happening, but there's still so much more. So we really hope that this gets, we all wish that it gets done off as soon as possible. So don't know when can that happen, but yes, thank you. And hi to Ricky. Thank you so much for joining us here on YouTube. We're looking forward for your question as well. So please feel free to ask your question. So now, Justin, this next question is, can USCIS show up for an inspection without giving any prior notice? And how should a company prepare for that?
So yeah, they can show up without notice and they can show up with notice. Usually if they give notice, it's going to be 48 hours out. They're going to basically say, hey, here's an email. I want you to send me the following documents and I'm going to come talk to you within 48 hours. And the goal of that is you're, as the employer and employee, you are intimidated. You are given a short timeline and you freak out and you hand over everything that's asked for without stopping to make a consideration about whether or not the things that they're asking for are things that they're actually eligible to request. Because what they do is they basically say, you have to participate in an FDNS investigation now. It's mandatory as of the January regulatory changes. But participation is not the end-all be-all, meaning that everything that is requested has to be furbished. There has to be a rational connection between the petition that is being reviewed and the information being requested by the officer. So I'll give you an example. A lot of times the officers like to use the site visit and the subsequent communication with the employer as a fishing tactic, basically an opportunity for them to go on a fishing expedition where they say, we're going to open your books and we want to look at everything that you got. We want all your payroll records for all your employees. We want a copy of every LCA you filed. We want all your petitions. We want everything. Well, at the end of the day, the purpose of the site visit is supposed to be to verify the information that's provided within the petition. So that should be the limit of the scope of the investigation. And most times, if you're not repped by an attorney, they're going to push as much as they can to get as much information as they can. You have to understand, their end game is to prove fraud. The more they prove fraud, the more they justify their budget, their existence. And so their end goal is they want that. They want to be able to show fraud or misrepresentation. And there are plenty of officers that I have dealt with personally who are going to intimidate and bully and try to force people through threats of coercion into getting what they're requesting, even if it's outside their scope. On the other side of that, there are the officers who act like they're your friend, who say, "Hey, I'm just doing my job. I'm just doing my job, and this is my job, and I'm not trying to do anything. We're not trying to prove anything. We're not. There's no intent here. There's no malicious intent. It's just a routine inspection check. Like, don't worry about it. Hand me over the stuff, and nothing will happen to you." And those officers are just as dangerous, if not more so, than the ones that are blunt about what they're doing. In order to prepare for a site visit, you really have two courses of action, one being significantly better than the other, in my opinion. One, you need to make sure that your employee, if they're working at a client location, knows who the individuals are that they are supposed to say, that's my direct supervisor or my in-client supervisor. This is my employer supervisor. If there's a vendor involved, maybe that information. There needs to be a clear chain. The other thing is, obviously, what they're doing needs to correspond to what's in the petition. If it's not, then you're already in trouble out the gate. So that's option one, where you say, all right, we're just going to make sure that he's working where we said he's working. He's doing what we said he's doing. He knows who he reports to. Those are the basic kind of questions. The better option is you give your employee and your employer, you make sure that they have a G28, that they're represented by counsel, and that the G28 is the only thing that is handed over to the officer when the officer shows up. At that point, you just say, look, I'm represented by legal counsel. My counsel will be the person who funnels all this information, and we can correspond moving forward via email or set up a phone call. What that does is two things. It alerts the officer to the fact that you have representation, which blocks them from being able to continue speaking to you. Secondly, it gives time. Instead of them just rattling off a laundry list of things that they're saying that you need to produce, give me this, give me that, give me this, you have a lawyer there who can actually sit and go through and say, well, that makes sense, that's fine, that doesn't make sense, we are not going to produce that. And the difference there is colossal, because if you're repped by an attorney, there's someone there who you are entitled to have who's going to be representing your interest. Remember, like the hypothetical I said with the guy that's saying he's your buddy, that's the FDNS officer, the guy's not your buddy. That guy's end game, the job that they do is to get your petition revoked. That's the ultimate goal. It is not for them to show up and say, well, there's nothing to see here, I've done my job. It is to get petitions revoked. And so without representation, you're putting yourself at a pretty colossal disadvantage. But if you're not going to use representation, then what you really need to make sure you're doing is, who is the person that the officer is supposed to be directed to speak to? What are the job duties the person's doing? And do they correctly correspond with the LCA? And when you're working at a client location, it creates a more difficult situation, obviously, because you don't have control of the client or what the client's going to say. If it's in-house, you have a little bit more sway, or you're on top of the situation. So that being said, if it is an in-client situation, I think this is something that everyone needs to start to be aware of, and I'll sneak it in here just so it's something that I make sure that we have brought up. We are now seeing officers ask the client how many years of experience are needed for the position that's being done with them, with the client. So why would the officer ask that? And I actually had an opportunity on a call this week to ask the officer, because what I didn't understand was, what does it matter? What does it matter what the client requires for the position? And he says, well, what we're doing now is we're looking at the years of experience that the client requires for the position, and then we're looking at the level of experience that's required by the employer. And if those numbers don't match, we are asking whether or not the person is working at the wrong wage level on the LCA. So let's say a hypothetical. Employer hires a guy to do a job. The hiring material, the job offer, says the position requires 2 years of experience. Person is placed at a project with Google. Google says that the position requires 6 years of experience. Well, if the employer filed that position using a level 1 LCA because they said the position requires 0 to 2 years of experience, now we've opened the door for USCIS to come back and say, well, the client is the party that's ultimately receiving services, and the client requires 6 years for the position. 6 years looks more akin to a level 2 or even a level 3 position. This person's being underpaid because the LCA is improperly filed. And so you could sit there and say, well, that's good because, they're properly enforcing wage levels. And that's helpful to even the beneficiary, because the beneficiary is going to benefit from this. They're going to have to file a new LCA and pay the guy more. No, that's not the intent. The intent is to issue a notice of intent to revoke, claiming that there's a fundamental deficiency in the LCA, meaning that there's been the commission of fraud or misrepresentation. The beneficiary is not going to benefit from that, and that the beneficiary is going to end up getting a fraud claim attached to them on subsequent filings. So all of that is to say, if you don't have an attorney, you're not aware that these are the kind of things that they're doing. You're not aware that these are their tactics or their underlying justifications for asking the questions they're asking. And also, you're probably not aware that you don't have to give them the job posting, because the job posting isn't a part of the petition. You've stated in the petition that the LCA and the support letter have the information needed, but you don't realize it, and then you just handed over evidence that could end up being problematic. And so, yeah, I would say my conclusion is, if you're going to go it alone without representation in this day and era, I think it's definitely dangerous. But if you do, you need to make sure that your employee has been prepped on what to say, and that the information corresponds with what's in the petition, and that he or she knows who the people are that they are supposed to direct the officers to.
Right. I mean, it's crazy, and it's very tricky, because if you look at it, you may just fall into trap, right? So to be out of it, I think it's always best to have an attorney or a representative for you. So, yeah, thank you so much, Justin, for the detailed explanation.
Mhm.
And folks, yes, if you do want to contact or have a one-on-one consultation with attorney Justin Rivera, go check out this link that is displayed on the screen. And with that, I would also like to say hello to Cynthia, Ricky, and thank you so much, Ricky, once again. Selomit, for your questions. We will take them up. Just stay with us. So, yes, getting very interesting, Justin. Let's move on to my next question that I have for you. So, what kind of documents should employers have ready in case of these sorts of sudden inspection?
What kind of documents should employers have ready? Employers should be ready to produce obviously the petition, the labor condition application, the PAF, the public access file, and be ready to be asked questions about the individual's work, who they report to, how they report. That's something that's now being questioned a lot. Are you doing timesheets? Are you doing monthly reports and check-ins? Really, what is being looked at now is, how are you functioning as the employer as it relates to running this person's payroll, and how do you know that they're working the amount of hours that they're supposed to be working and doing the job they're supposed to be doing? The thing about it, which is interesting, is that what's really interesting about it is the employer-employee relationship is gone. It's not something that's no longer that exists in the regulations moving forward, but they're still asking questions about it. And again, that's something that you can push back on if you know it, but if you don't, you're sitting there providing information. I'm assuming that they're doing it because, again, the name of the game is fraud, and they want to try and find some way that the employer or employee is making a misrepresentation. But yeah, you need a copy of the petition. I'd have the approval notice. I would have the LCA, the public access file. If you are working in a client situation with vendors, etc., probably have a copy of the most recent purchase order as well, just to show that the project is ongoing, because bona fide job offer is the other big thing they're looking at is, can you prove that this is something that is actually going on now and is going to continue to go on in the future?
All right. Well, thank you so much, Justin, for taking that up. And I think we should quickly take up some of the questions from our audience as well. So let's do that. This first one is from Cynthia. During the inspection, who exactly comes to the work site? Is it just government officers, or could there be other people involved? Am I answerable to the questions asked, or I have options to be quiet?
So yeah, when typically the way it's done is you get an FDNS officer, one officer or two officers, and they're usually going to show up and say, "I'm here for a site visit. I need to see person X," and then from there they get an opportunity to go before person X and talk to them. Here is where your answer is contingent upon whether or not you have legal representation. If you have legal representation, it's permissible for you to say, I'm represented by an attorney. Here's a copy of my form G28. Everything needs to be funneled through them. If you don't have legal representation, if you're saying, I'm not going to talk, I'm not going to do anything, the issue there becomes the FDNS site visits are now mandatory. They're no longer voluntary. Beforehand, you could just say, I'm not going to do this, and you're done. You don't have to put any skin in the game or say or do anything. Now, it wasn't always the best thing to do because, you can walk a line between non-compliance and not fully participating, but the completely not saying anything, immediately they're going to say you're non-compliant. So in today's age where it's mandatory to participate, if you're completely non-compliant, you may open yourself up there to getting some sort of notice, NOIR related to the case, due to non-compliance that has triggered them to issue an NOIR because they have some derogatory information that you wouldn't help them assess or verify. Legally, yes, you cannot talk. You have a right against self-incrimination. So you can legally not say anything, but if you do that, you are kind of opening yourself up. I think that the way to toe the line between the two would be to answer, basic questions about, where you're working, what you're doing, what your job duties are. And then if it becomes more of an extrapolated thing where they're asking, 14, 15 questions, they're asking for a bunch of different documents, I think that's when you push down and say, look, I don't have time to do this right now, or I would like to participate, but I have something, that I need to do. And please send me these requests via email, and I will do my best to accommodate you in a timely fashion. Something like that gives you a little bit of leeway, that doesn't show full non-compliance, is probably the best way to kind of skirt the line. But yeah, at the end of the day, I don't think I would advise someone that doesn't have a G28 to not say anything. I would say what you really should be doing is, and I understand it's self-serving because I'm an attorney, but I'm saying generally speaking, even if it's not me as your attorney, the best course of action is to have a G28, hand it over, and say, I don't have to talk to you anymore because I have an attorney.
It's interesting, yes. And there's sort of a very thin line, right? So friends, do not fall into that trap. And yes, always, I think, have that representative. Prepare yourself, especially if you're the employee, you have your whole office there, you have someone to represent or who is answerable, who is properly, knowledgeable to be answering to all these officers. So thank you so much, Cynthia, for that very important question. And let's move on now to Ricky's question. Ricky's asking, there is a site inspection, and should one not say or give anything until the company legal representative alongside? Tom?
think we broke it. We were breaking up a little bit there. I can read the question.
Oh, I'm so
I,
sorry. All right. So I was saying Ricky's question is almost similar to Cynthia's. So he's asking if there's a site inspection, should one say or give anything until the company's legal representative is available alongside?
So I think you can make that argument if you're represented by counsel that's locally available, because then you can say, look, I'm waiting till my attorney gets here to say anything. Thing about that is immigration law. It allows for anyone like that's barred in a state to practice. So you have a lot of circumstances where somebody who, let's say, is in New York is represented by an attorney in Florida. Well, your Florida attorney, unless you're going to cut them a very big check, is not going to fly up to New York to sit down with you for a site visit, questioning. So the way that you deal with that is instead of saying my legal representative needs to be physically present here for us to have a discussion, what you say is I'm represented by counsel. My counsel is going to be taking over answering any of your questions, and if I am needed in any way, I can communicate via email or on a phone call that my counsel is present on as well.
Okay. Well, Ricky has more questions, and Ricky, I would just say, please stay with us. I will take up more questions, and thank you so much, Justin, for taking that up. And let's quickly take up Cello Mids as well. In the event of an H-1B worksite inspection, what are the rights and responsibilities of employers, employees, and inspectors? And how can employers ensure that they are cooperating fully with the inspection while also protecting their interests and those of their employees?
So the way it works is like this. The FDNS investigation, as I've said a couple times, is now a mandatory thing, participation. You have to participate. If not, you get labeled as non-compliant. There's not really fully an understanding of what the impact of being labeled as non-compliant is. I would assume it's going to trigger a notice of intent to revoke on the petition, saying that they weren't able to verify information, something of that effect. So the employer and the employee should participate. Now, the level of participation should be rationally related to the individual petition of the beneficiary that is at issue. So, for example, to give you a little bit of an understanding of that, what I mean is this. If I'm an officer and I'm conducting a site visit, I need to say, I am here to conduct a site visit in relation to petition IOE, 080872, whatever. So you know the receipt number that is associated with the petition that it is they're asking questions about. Now you say, okay, I'm the petitioner. I filed that petition. What are your questions? And from that point, the questions that should be asked are questions about this person's petition. It should not be things like, give us your payroll records for the past 3 years. Give us a copy of everybody that works for your company that's on an H-1B. Those are not within the realm of the scope of that individual petition. What the officers try to do is use a participating employer or employee as a entry point into obtaining as much information that they can about the organization. They're going to take that information about the organization, take it back to their coworkers and say, what can we comb through here to find something, to find some way that we can pin fraud or misrepresentation against this company? And that's the line that has to be towed, is the employer does need to cooperate, but the employer also can understand that the cooperation can be within reasonable parameters. So you are not obligated to answer every question that's asked by the officer. You're not obligated to produce every piece of information that they are requesting. You are required to participate. And what participation looks like is you are giving the things that are asked for that are related to the petition. If you go outside of that scope, like let's say hypothetically, you're like, I don't care. I have nothing to hide. I'm just going to turn over everything to them. We're a legit company. I'm not worried about it. That's your choice. But I will tell you from personal experience that I had a very compliant client that worked. They were a small company, 30 to 40 employees. That's how they operated with FDNS. They said, look, we have nothing to hide. We're good. We're going to just hand over everything. We're not going to worry about it because we're a legit company. Couple months later, that company is contacted by the Department of Labor, and DOL has been contacted because they have been referred to investigate into the company's pay practices. Now, the allegation was essentially that the company did not pay employees on holidays that were not recognized as federal employee holidays. Basically, what they said was, if you didn't pay somebody on this holiday that the government recognizes as a holiday, then you committed a violation. And so my company, who has complied in as much a way as they possibly believe they can and thinks that they've done everything right, now gets into a DOL investigation where in order to get out of the investigation, they have to go back and pay penalties out as fees to each employee for these days that they were supposedly needing to pay for. Now, remove from that the fact that this employer paid everybody the LCA wage that they were supposed to. They produced proof that they paid all of these people the wages from it. And just look at the end game of it. They furbished documentation information to USCIS outside the scope of the petition. USCIS compiles that information, looks at it, and says, we can't find anything on them really. What else can we do? They either proactively contact DOL or share that information with DOL and say, look through this and see if there's something you can find. But it comes back to the same thing. At the end of the day, their goal is to get something out of you that they can use to either revoke the petition or penalize the company. And so you have to be able, if you're not going to use an attorney, to toe a very, very dangerous line between what is participation and what isn't.
Thank you so much, Justin, for taking that up. And thank you, Salomit, as well. So, very interesting questions we're having today. We got Christopher also join us, and Cynthia says, thanks a lot, Justin. So,
You're
thank you
welcome.
too, Cynthia. We'll take up Christopher's. What are the potential consequences of an employer if they are found to have engaged in benching or unauthorized employment of an H-1B employee during a work site inspection? And how can they take corrective action?
Okay, I think right now we need to make a distinction with benching. Benching is where you have somebody off project that is still being paid in compliance with the LCA. Benching isn't illegal. It's appropriate if you are saying, I have employee X in between projects and I want to assign them to another project. In the interim, I'm going to continue paying their salary in compliance with the LCA, and then I will file an amendment as needed, unless an amendment's not needed because they have a new project in the same metropolitan statistical area. That isn't illegal. What is illegal is benching without pay, because benching without pay is a violation of the petition and the LCA. When you sign the petition, you say, I am going to comply with everything that's in this petition. Part of what's in that petition is I'm paying this person X amount of money. And that's what you put on the LCA, which is for DOL, and that's what you put in the petition, which is for USCIS. If you bench without pay and you're caught benching without pay, the first thing you need to do is go pay the employee the money that you should have paid them, because you're going to be under the eye of DOL if that information is discovered. Secondly, you need to know that benching someone without pay, if caught in an FDNS investigation, is almost certainly a notice of intent to revoke scenario, because now they're going to come back and say, well, this person's not really working. Why is this petition still in existence? Why hasn't this been revoked? And you're going to have to deal with that at the NOIR stage, where you're going to have to hire an attorney to put some sort of argument together explaining that you went back and paid them after realizing it was a mistake that they weren't paid, and that you've moved them to this project, something. But that's usually what the issue is going to be with benching. Unauthorized employment is like I was talking about earlier, unauthorized employment previously was something where it would be, well, you go file the amendment. You correct the action on the case. You make sure that the individual's working in compliance with the properly filed H-1B petition. And you hope that that's sufficient for USCIS to say, okay, no harm, no foul. They're going to try to revoke the previous petition. And at that point, you say, well, he's on this petition now. Here's proof. Here's the filing. We've moved him over. The oversight has been corrected. The issue now is FDNS and through USCIS is trying to now make an argument that unauthorized employment is a grounds for fraud or misrepresentation finding. Basically saying, your failure to comply with the petition when you've signed the LCA and you've signed the petition amounts to a finding of fraud because this person's not where they're supposed to be and they're not doing what they're supposed to be doing. That is, like I said earlier, a much more dangerous situation because there are penalties that can occur for the employer and for the employee. That's its whole other thing with the unauthorized employment. If you're caught in either of those circumstances, the consequence of that is going to likely be action from USCIS to revoke the petition and potentially action from DOL.
Well, thank you so much for taking that up for Christopher. And Christopher, thank you for your question. Thank you for participating. And I hope you got your answer. So, friends, please do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And I hope that you're resonating with what discussions we are, this topic we are discussing today with Attorney Justin Rivera. And please feel free to also contact him and the details. In fact, the link is here on the screen where you can contact him. So thank you so much, everyone, already. And we do have more questions. So, Justin, I think my next question to you would be, if an employee works at a client site, what paperwork should be available to prove they're performing H-1B approved duties?
It really just has to be the information that's in the petition. That's what they're entitled to. If you're the employee if you're the employee, you're basically saying, I'm doing the work that is, within the information provided in the support letter for the petition. And it complies with the, is the information correct and accurate as reflected in the LCA and the support letter. So in terms of paperwork, it's really not much. I would say the petition probably. Now, that being said, what really matters during that site visit isn't the paperwork, which, like I've gone over, is the approval notice, hopefully a copy of the petition, the LCA, that stuff. It's really the statements of the employee. Because when the employee is talking to an FDNS officer without an attorney or the employer present, the FDNS officer has the opportunity to confuse the employee, to ask leading questions to the employee because they're trying to get derogatory information. And in those circumstances, that interaction can become dangerous. One example that I can give to you guys, which I've told before, but I'll tell very quickly right now, is we had to work with somebody to get their fraud finding removed so that they could come back into the United States. And the whole impetus of it was when the officer spoke to them, they spoke to them about the wrong petition. So the officer didn't explain what petition he was talking about. So when the employee was answering, the answers were all for a different petition. And so the officer's not sitting there correcting him saying, oh, yeah, wait, just to be certain, I'm talking about this. No, the officer's sitting there going, okay, fantastic, because they're writing their notes saying, I've got him. I'm going to get this person for fraud and misrepresentation. So it's really about, if you're going to go it alone, sans attorney, you need to have coached your employee. Your employee needs to understand what it is they need to say and at what point they need to say, all right, I'm done. We're going to do the rest of this on the phone or via email. And truthfully, I have to say, and again, I admit it is entirely self-serving, but I think it is very dangerous to go this alone anymore. We have seen the increase with the site visits beginning to really ramp up. I think they're going to ramp up much more once we get into late summer, getting closer to that October 1st start date for the new H-1Bs. And I think that people that are not represented by counsel are putting themselves at a disadvantage. And if you decide not to be represented by counsel, you need to be aware of the fact that it is a lot easier for them to work backwards to get the information that they're going to want out of you versus out of having to go through your attorney. So yeah, if you're going to tell them, you're working at the end client, my employee, you need to put some sort of packet together for them that basically says these are the documents that you should turn over to the officer during the site visit. And if they want anything else, they need to reach out to the employer or, talk to you via email or set up a call with everybody.
Okay. Okay. Thank you so much, Justin, for taking that up and for the detailed explanation. Well, we do have our Facebook questions as well, but are also case studies. So let's take up this case study first. An IT consulting company places an H-1B employee at a third-party site but doesn't update the LCA or keep the client contract on file. A USCIS officer visits unannounced. What issues could arise from this situation?
I mean, that's exactly what they're looking for right now. That's what they're hoping. That's kind of a golden goose for them because right now you're saying, you're basically saying this person's performing unauthorized work. We've moved them to another location. They're operating in violation of their previous LCA, and they are operating in violation of the petition. So, like we talked about earlier, you have a possible DOL issue if the person's wages aren't higher than what they're supposed to be in that area of intended employment, and you have a possible USCIS issue with the revocation of the petition for the performance of unauthorized work. Carried in with all of that, you now have the door open for them to allege fraud or misrepresentation in relation to the original petition. So, yeah, I mean, that's pretty much every bad thing that they have the ability to do, they have in that situation. And that's why, with my clients, I have really told them before, and I cannot stress this enough. The era of holding off on amendment filings is over. The era of saying we'll move the person there and we'll wait till they get past the probationary period of the project and then we'll file the amendment, that is over. Because here's the other part of it. If you have someone working at a client location, FDNS can and will talk to the client. And that client is going to tell them what happened. So if that guy joined 60 days before the amendment was filed and they find that out from the client, they've got you. You don't have a comeback to that. There's nothing for you to do there. So you have to keep everything in order now. It's no longer an issue of, we'll get to it or it's on our HR's to-do list. People need to understand over the past few weeks, both the FBI and the DOJ have been instructed to increase enforcement in immigration. Okay? I'm going to tell you guys right now, FBI agents aren't running to the border to help turn people around, okay? What they're going to likely do is say, what are the easiest things that we can go after to show compliance? And one of the easiest things for them to do is work with USCIS and work with ICE to find evidence of visa fraud. And that means that, look, what you guys have been dealing with these past couple of years, it's second tier enforcement. These are enforcement agencies that are, they're given tools and methodologies, but these aren't people that were trained, they didn't go through an FBI academy. They don't have years of service doing investigations. That is what exists in the top tier. And that top tier has now been tapped and said, look into this. See what's going on here. So it's just not the same game it was. And FDNS and their site visits are always going to be problematic because they want to hit you for visa fraud. What is going to be a bigger issue now is, do we start seeing agency cooperation? Do we start seeing more referrals for criminal investigation? Do we start seeing an increase in the FBI finding justifications when they see a pattern of misbehavior for stepping in and opening investigations? All of that is on the table now. So yeah, this person in this situation, I would say you're in a world of trouble. You need to file an amendment ASAP to try to correct everything. And then you need to be willing to provide that information to USCIS when it's requested. But there's a lot of negative fallout that's going to come from that.
Thank you so much, Justin. And yes, there's a lot of scrutiny happening, and we really hope that everybody is safe and make sure that you have your documents in place and you know that you're on status. And thank you so much, Justin. So far, so good. We do have more questions from our Facebook groups. So, Control, if you can please display them, it'll be great. We'll take up a few and let's keep them brief, if that's fine with you, Justin.
Yeah, sure.
So, this first one is from an anonymous participant asking, "Hi everyone, I'm holding a valid F1 visa. I studied the first semester at the university in Texas. Then I transferred to community college in Texas. I plan to travel outside the US. My CVS ID is transferred to the new school, and it's still the same number, CVS. Should I re enter the US with a new I 120, new school, and old school name on visa? Is it okay? Like, I'm afraid that the school name on visa doesn't match the name school on I 120. So I can't enter the US anymore. Thanks so much for your help."
Yeah, my understanding has always been that the F1 visa is school specific. So what I mean by that is if you're going to enter the US and attend that school and then transfer to another school, it's permissible. Meaning if you transfer, you get your new service and everything like that, and you're able to stay in. But my issue there, it becomes, if you depart the United States and you've changed the school and then you come back into the United States, what happens if you are questioned by CBP? And if CBP questions you and sees your I-20 and sees that it is a university that is different from what is on the visa, is that enough for them to then say, we're going to cancel the visa because you're not attending that school? To be honest with you, I think it's more of a gray area. And that in a traditional setting, it may have been something that got you could sneak by under the radar. Probably something that it's not. When you come in, they're saying, look, they've got a valid SEVIS, they've got their F1 visa, they're fine. They can come into the United States, right? What I worry about now is because it is school specific, the F1 visa, I do worry that it could create issues with CBP. So I would be very cautious about it. Alternatively, obviously, we know that the H-1B visa, it's not employer specific. As long as you enter with the original employer, you can transfer and you can go in and out as long as as long as the visa is still valid. My fear is that, look, let's just call it what it is. The F-1 visa has been targeted pretty heavily over the first couple months of the Trump administration. They've gone through this thing where they've terminated people in SEVIS for pretty much no reason. They've canceled people's visas for no reason. And we're aware of the fact that they have increased the refusals of F1 visas at consulates. So while I would say that I can't on its face say that it's impermissible, I would lean towards the idea that it's a good idea to get a new F1 visa that reflects the school, even if that's not necessarily required. So that would be my general advice on the matter.
Thank you, Justin. And let's go on to our next one now. This is, "My F1 visa rejected or what?" Number one, I'm fully self funded. Number two, I have already B1, B2 valid visa but don't visit USA. Please give me a suggestion.
Okay, so I think what he's saying is his F1 visa was rejected, and he's asking what the basis was of the rejection. Guess what? They don't have to tell you. The state, if they revoke your visa, all they got to do is shoot you an email saying it's been revoked. They don't have to explain anything to you. You don't have another course of action, to be completely honest, other than to go apply for a new visa. And when you're at the visa interview, ask them what the basis of the revocation was. Outside of that, you really don't have anything to go off of. I had an individual last month who got their H-1B visa approved and was traveling to the United States, and they were stopped in Qatar, I believe. And they were stopped in Qatar and told that the visa was no longer valid. And they were not allowed to get on the plane to go to the United States. That person, to this day, has not been told why the visa was revoked. We had to work backwards and realize that he was one of the people whose services had been terminated and that his F1 visa had been canceled. And they apparently used that as a pretense to cancel all visas associated with him, meaning his H-1B included. What's incredible about this is the SEVIS termination happened while the consulate had his passport. So the SEVIS termination happens, 4 days go by, the consulate issues his approved visa. And then he travels the following week and is told in Qatar that his visa is canceled. So all that is to tell you, they don't have to give you an explanation outside of we're saying it's been canceled. And then you don't have recourse other than applying for a new visa. To this day, there does not exist any mechanism to uncancel a visa. There is nothing out there that says, using this procedure, the State Department can go back and say the visa we canceled is being turned back on. There's nothing to do that. There's nothing that sits there that allows them to do that. So yeah, I don't know why your visa was rejected. Your visa was rejected. If your visa was canceled, you don't have any recourse. If your visa was rejected, meaning that you were at the consulate and the email and sorry, you're at the consulate, you applied, and then they handed you a visa refusal, you need to look at the basis of the refusal. The refusal is going to list a justification. Now, 9 times out of 10, what I've been hearing is that justification is now 214B. So 214B says your activities do not comply with the visa that is being requested. What does a 214B mean in specifically? Okay, I'm signing up for an F1 visa. I'm going in for an interview. I have to show that I have non-immigrant intent. You have a presumption of immigrant intent because America is so high and mighty that they believe that anybody that comes into our country by default wants to stay here, which do with that information what you want. However, you have to work to prove to the officer that that's not the case, that you have a firm timeline, that you're going to accomplish a task that is permissible by your visa, and that at the end of that task, you will depart the United States. How do you show that? You show that you are going to comply with the visa. I'm going to attend school here. I'm going to do X. I'm going to go for this degree. Here's where I live. It's by the school. All of that's fine. But you also have to show that you have those ties to your home country that will prevent you from immigrating permanently. Well, when you're a college-age kid, how do you show ties? You got to show them through your family because your parents are the ones that own the house or the apartment. It's not you, so your ties are typically shown through that. Your family is in that country. Your family is, they're going to live there. They don't have an intent to immigrate themselves. And when you're done studying, you're going to go back go back to your country, your family. So what I see happening now more and more with these F1s is 214B coming into play because the individual has a U.S. relative. And are they using that U.S. relative as a pretense to claim that there is immigrant intent? There's not definitive data to back that up. It's just my, tinfoil hat theory of why are they using that as a justification. So that's one thing to look at. Look at the reason for the refusal. Luckily, the consulate has to give you a reason. And then that reason is going to be what you track backwards and determine if I apply again, what are the changes I'm going to make.
Very interesting. Thank you so much, Justin, for taking that up as well. And well, we have more questions. If I think let's take this last one. So this is saying, "Hi all, just wondering if anyone here has recently gone through the visa renewal process at the Paris embassy. My visa expired recently and I'm trying to decide whether to travel this summer. I'm French, planning to go home. I've qualified for the interview waiver, but I'd love to hear how things are going now, how long it took, any issues, etc., just to make an informed decision. For context, I am fully funded PhD student at the UC Berkeley with a GSI appointment, got my MA at CU Boulder last year. No law enforcement issues. I usually go home every summer to see family and hope to do the same this year. Thanks in advance for sharing your experience.
So, I don't have words about the French embassy specifically, as I have not attended a visa interview in France ever in my life, because I don't need to. But I've also never even been to Paris or at all.
Me
Great
too.
job with the Olympics, though. Those were fantastic. I would say this. 95% of immigration attorneys that you're talking to right now are going to tell you that you shouldn't travel if it's non-essential travel. I know that there is this idea that, the immigration attorneys are, boogeymen who are creating this false sense of fear because they don't want that. That's not true. We are by nature trying to put you on a path that has the least amount of risk associated with it. Anything that elevates risk is problematic for us as an attorney because we want to make sure that you are able to do the thing you want to do, which for somebody that's on a visa in the United States is usually to live here and or to work here or to go to school here or whatever. So when we say we don't recommend traveling unless it's essential, that's what we mean. There are two barriers to entry for individuals who are getting new visas into the United States at this point. The first issue is the consulate. The consulate, all of them writ large, the consulates have been told to perform enhanced vetting on visa applications, meaning anyone that's applying for a visa is going to be looked at with a more stringent line than they were previously. What does that mean for a normal person that, they've never been arrested, they've always complied with their visa? It should mean nothing. It should mean that person's completely fine. But if you are going to renew your visa, you now have to, look at, have you ever said anything on social media that was negative towards the United States or Israel now, apparently? Have you ever liked a comment that someone else made that could be construed as negative? Have you ever said anything in an Instagram post or whatever? I don't do social media, so I don't know any of that stuff. But is there anything there that they could latch onto to make problematic? Let's say, no, there's nothing. Okay, good for you. You should be okay to travel abroad and get a visa. You go abroad, you get the visa, you think, awesome, my visa's back. It's time to go back to the United States. Okay, welcome to barrier number 2, CBP. CBP, since the change of the administration, has gone from an entity where, they're doing their job, they're looking at docs. If you have something previously on your immigration history, you might get put in secondary inspection. CBP now is an aggressive actor, for lack of a better term. CBP now is saying, do we have the ability to cancel people's visas coming in and put them in expedited removal? Because once we do that, they count towards the 1 million deportation goal. And that's who you're handling at this point. They're not the same. It's not the same as it was before. Now, look, can you go get your visa and you're squeaky clean and come back into the United States and you're squeaky clean and they look at your passport and they let you walk right in? Absolutely. It can happen. But in an era where our job is to define risk for you, there is going to be risk at a higher tier than there ever was previously with re-entry. CBP can and will utilize this opportunity as a chance to review your entire immigration history and to put you in a room with CBP officers. You do not have a right to counsel when you are speaking with CBP because you have not been admitted to the United States. CBP can and will put individuals in secondary inspection for hours. They will question you with different officers. They will question you with multiple officers. And they will question you and make statements that are not true. because their end goal is to cancel the visa and have you removed. So, why I say this is you can go do that, you can get your visa renewed, you can come back, and you can be completely fine. It can happen. But there is more individuals getting their visas canceled than I have ever seen in my history practicing now than there has ever been before. So I think it's dangerous. There's a level of danger to it. You know, ask the kids who came in to Hawaii to go on vacation a couple months ago who had their B2 visas canceled because they said to the CBP officer, we like to do freelance work back in Europe. That was it. That was all they needed. They said, okay, they like to do freelance work back in Europe. They're going to be working here. Visas canceled. And that's it. That's all it took. So yeah, I would say yes, you can do it. Be prepared. Probably talk to an attorney beforehand. If you're not talking to an attorney at the consulate before you go for the interview, that's up to you. I would very much say though, talk to somebody before you come back into the United States, because if you haven't traveled abroad yet and re-entered, you are not aware that this is a different animal than it was before. So yeah, you're probably fine, but I've seen the horror stories. You know, I've seen the cases that are terrible. I've seen the people detained for over 24 hours at an airport that have had their visas canceled and been put on flights the next day back to their home countries. So I would just say be cautious.
Thank you. Thank you so much, Justin, for taking that up and explaining it so thoroughly. It was really nice how you made it sound like the different levels in a game. Welcome to obstacle one and then two, and well, that is really happening. It's nothing to nothing too amusing, but it's really happening. I think knowledge is power. So I would say, keep yourself updated, and just like Justin has said, consult with an attorney. And if you do want to consult with attorney Justin Rivera, please check out the link that's displayed on the screen. And yes, don't forget to subscribe to our channel because we come up with the latest updates for you also. And our handle is at Immigration Talk Show. And I think with that, Justin, we will wrap up our session for today. It's really wonderful how you patiently answered and took up each of our questions. You know, very interesting how you answered them as well. Very insightful session today, indeed. Thank you.
Awesome. Yeah. Thank you guys very much for your time. Have a wonderful weekend. Everybody enjoy the 3-day weekend. I'll talk to you again soon.
You too, Justin. Happy weekend.
All right. Bye.
Bye bye. And folks out there, thank you once again for joining us. And if you do have more questions, please feel free to keep commenting. And also, you can WhatsApp me or call me on my number in case you have more questions. My number is 408-335-6444, and my email address is nipa@staffingly.com. And I would just say stay tuned on Immigration Talk Show because we have so much more coming in and for latest update on everything US immigration. So thank you once again, everyone, for tuning in. Don't forget to subscribe. Our handle is at Immigration Talk Show and hit that bell icon so that you will be notified whenever we have discussions like these. So bye for now. Have a wonderful day and see you very soon.
Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam. And today we are here with another very exciting webinar that is lined up just for you. So make sure to watch this webinar till the end and also participate here by joining us on dialing up this number. And you can also write anything on the comment section. And before diving into the topic, let me go ahead with the disclaimer first. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information at your own risk. All right, friends, with that, once again, welcome back to Immigration Talk Show, and I'm your host, Sam. And we are live on LinkedIn, Facebook, X, and also on Instagram as well. And you can follow us on these many platforms too. And talking about today's topic is another very important and very interesting one. EB2, EB3, and EB5. What is the fastest green card path for you? So, we all know, friends, that getting a green card is a very big deal. But you know what? Our focus shouldn't be just to get it, but also to get it faster and quicker. And that is why we are here. We are having this live webinar where we are going to talk about these three very popular green card paths: EB2, EB3, and EB5, where we are going to explore some major differences like what are the process, what are the eligibility requirements, and most importantly, which one can get you your green card the fastest. Okay, and before diving into the questions, let me also tell you that the great news is we have an expert over here who will be joining me in a bit, who is really, I would say, great in her insights and provide expert advice in a great way, none other than attorney Rani Manti, who has 28 years of experience in helping employers and foreign workers to navigate the complexities of immigration law. So I would just like to welcome our attorney and our today's guest. Hi, Rani, and thank you so much for being here. Really excited for the show and looking so pretty today.
Sam, thank you for having me. It's a pleasure, and I'm glad to share some valuable information about the green card process, which is a very important process for nationals, immigrant, foreign nationals all over the country. And so I'm very happy to be here.
Absolutely. Likewise, I think our audience are also very excited for this topic. I think this is a very catchy topic and a very important topic, especially in 2025. So, friends, the best thing is that you can also reach out to our attorney, Rani Amandi, and you just have to visit the link that will be visible on the screen. And you just have to go there. You'll get the contact details of her and go ahead and join her. Okay, and with that, Rani, here we have a very important topic. And this, friends, I think let me go ahead with my very first question. That if we can understand some basic information, because there are so many viewers, who are not very much clear regarding these three popular paths. So, Rani, if you can let us know, what are some major difference between these three categories in terms of process, eligibility, and cost.
Absolutely. So there are approximately three green card processes that we're going to discuss today. The first is going to be we're going to focus on the EB2, the EB3 category, and the EB5 category. We have an EB1 category which relates to individuals of extraordinary ability in various fields and known for their extraordinary talent. But we're not going to go there. We're going to just focus on EB2, EB3, and EB5. So in terms of what are the major differences? Number one, it's eligibility requirements for each of these EB1 or EB2 categories. And secondly, it's going to be the timeline. And that's the most important part, of course. And number three, it's going to be the costs also. So we're going to share some of that with you. In terms of the eligibility requirements for the EB2, let's start with that first. One should possess at least a bachelor's degree and 5 years of work experience in a particular field of study. Whereas for the EB3, you need at least just a bachelor's degree or 2 years of work experience. So the distinction for EB2, you could also have a master's degree. So those are the two primary differences between EB2 and EB3. EB2 is master's plus any years of experience, and or a bachelor's degree and 5 years of experience. Whereas EB3 is just 2 years of experience and or a bachelor's degree. For the EB5, You don't need eligibility in terms of education. You just actually, your qualifications there are capital. You need to possess $800,000 of capital in order to invest in this, to obtain the EB-5 visa, which turns into a green card. The reason we talk about EB-5 is because it actually, at this time, has the quickest processing times, and that is of paramount interest to our viewers. The biggest issue is, what is the quickest green card? And I'm going to highlight that that is the quickest green card right now. The processing time for the EB-5 currently can be as quick as 2 years and can go to 4 years, regardless, at this point, regardless of your country of nationality. In terms of the EB2 and EB3, in terms of their timeline, for the rest of the world, the processing times can be much quicker. Typically, they're in 2022, 2022 timeline for the EB2 or EB3. But if you were talking about India and Indian nationals, the timeline right now for the EB3 category is they're working on April 2013 cases, whereas for the EB2 category, they're working on February 2013 cases, which means we have a timeline backlog of 12 years, because now it's 2025, and you take the difference between that, the fact of what cases they are processing currently. So when you compare the fact that you've got a 12-year wait period versus before you even file for your adjustment of status versus your EB-5, where you're actually receiving a green card possibly within 2 to 4 years, we're talking about a time difference of 8 years that it's quicker. The EB-5 is quicker by 8 years. So that's the crazy part about it. Let's talk about the costs. Let's talk about the differential in costs with all of these. The EB2, EB3 green card is typically paid the majority of the costs are borne by the employer. Sometimes the employer may pass the costs on to the employee, maybe at the last stage. We see fees ranging from $8,000 to $10,000 to $12,000 for this green card process. But don't forget, the first two stages can be completed within the first 2 to 3 years, and hence 2/3 of the legal fees are paid up then, typically by the employer. As a matter of fact, the employer is legally obligated to pay at least the first stage of the perm application, and even the first stage, and could also pay the rest. Whereas for the EB-5, the green card or green card process can be substantially higher. Those fees can be up to $60,000 as to the legal fees. It could range from 25,000 on average for the legal fees. But in addition to the legal fees, there is a management fee cost that also has to be paid, and that could be another 35,000. That's why we say 60,000 out of pocket there, in addition to the investment of $800,000. But the good news about the EB-5 investment, and I'm sorry that this is not a quick differential between the three, because it's a general question you asked me about their timeline and the differences. The last point I'll make about the EB-5 is that you can accumulate the investment capital for the EB-5 through family and friends. You can also, it's primarily family, and who can give you gifts. You can also take a loan to accumulate that capital, a loan against collateral, or even receive just a promissory a note with take a loan with a promissory note. So that's it to wrap up the differences between the EB2, EB3, and the EB-5. And now I'm sure I thoroughly confused everybody.
No, absolutely not. You are very much. And with that, Rani, as you have explained about the difference among these three, I would also like to ask that you are saying that EB-5 is better than the rest of the two, right? But as we have been looking into the news also that EB-5 may be replaced with the Trump Gold Card. So, if you can also shed light a bit on that, like about the golden visa card, right? We have heard that, and we have been also hearing, but we don't know whether it's a rumor or it's a fact, but what it is, and if it's going to replace, then how everything gonna be? If you can also let us know.
So the information surrounding the Trump Gold Card is not clear. And when it's not clear just yet, because it has to be implemented with regulation or policy, typically that would be a congressional approval for that process. And we haven't heard further information about it just yet. So I think at this time we just have to go with what we have, and there's no need to wait, because even if you start the process and file a case, it's not the case that it will be eliminated. Those who have filed those cases will be grandfathered in to continue their green cards. So you can either wait for whenever any new law arises or is implemented, or you can take those steps and be proactive if you are able to meet the eligibility criterion for the EB-5. So that's what I think. That we're not sure of how it'll take impact. But don't forget, it's a $5 million amount. And very few amount of people can do that. Hence, if you compare the EB-5 to the Gold Card, the EB-5 is an $800,000 investment. If you tack on certain legal fees, it can be another $60,000. So that's why I think that I don't see any issue at this time in not moving forward with all your other options.
All right, that's a great one, and I think that's fairly said, Rani, about this question, and we all agree with that. And with that, I would say that there are so many people who have joined us, and I can also see a list of questions here. So, hi Ricky, hi Magic World, hi Nubi, hi Rudra, Ricky, Fawad, everyone, guys, thank you so much for joining us. We are here live for an hour. Go ahead, ask as many questions as possible. Our expert is here and she would love to take up all your questions. And also, don't forget to like, share, and subscribe to our channel. Friends, our handle is at Immigration Talk Show. So I think Rani, let's take one of the questions from Magic World and let's see what he's asking. So Magic World is asking that could be please let me know how to check in H1B amendment case whether the employee changes his location in the MSA or outside the MSA. And how do I will come to know? Please let me know about this.
So it's not a green card question, but I'll be happy to answer it. First, if you're the employee, the law that governs H-1B amendments is whether the new location, the worksite location that you will be working at, is within the same metropolitan statistical area called the MSA or not. That is checked by the attorney. Typically, the same MSA is a 60-mile radius from within that area. And hence, you can generally estimate that if it's within commutable distance, which is according to the Department of Labor rules, about a 60-mile radius, then you are fine, you're within the MSA. However, it has to be checked by the attorney. And that is about a different county, whether it's a different county, you could look that up. If you've got a new city, look up the county. If it's not the same county, then, it's based on the labor condition application of the U.S. Department of Labor guidelines. When you look up a particular city, sometimes it falls within the same counties, but this is not something that you can verify per se. It has to be under the Department of Labor rules, which the attorney typically checks. So that's how it has to be done. Have the employer verify with the attorney, or you could look up whether it's within the same county. But as I said, some cities fall within the same county anyways. I hope that answered the question.
Absolutely. And thank you so much, Rani, for picking up this question. Okay, and friends, also don't forget to subscribe to our channel. And Magic World is here, so I hope if you have any doubt or any other following up question, then please go ahead and put them in the comment section, or you can also get in touch with Attorney Rani Amanti. The link is here. You just have to visit this link, and you'll get the contact details of her. And with that, let me go ahead and pick up some other questions too. Okay, Ricky is here. So, hi, Ricky, and thank you so much for your participation. He's asking, my NIW I-140 petition was filed by employer. NIW I-140 petition processing time for the Nebraska Center is 16.5 months as per USCIS website. So, can you give some idea on the typical processing time that you are seeing for the I-140 petition? Also, if the employer lays off, then what happens to the pending NIW I-140 petition? Yes.
Time is whatever you got. That's 80% of the time of the cases are being processed within that period. So you can estimate some are quicker, some are slower. So it doesn't mean that it's 100% going to be processed that way. So just keep that in mind. It's a good average processing time. If the employer lays off when the pending national interest waiver is pending, that's a problem. Maybe it'll get approved without further request for evidence. But when you file for your adjustment of status, based on that, you do need the employer support. So that is going to be an issue that affects your case, unfortunately.
All right. Okay, that's okay. And Ricky, thank you so much for your participation. In case if you have any other doubt, then please go ahead and put them on the comment section. Till then, I think Rani, we can continue with our questions too, because I have so many questions to ask from you. And that is, what happens if someone qualifies for both EB2 and EB3? How should they choose that which path to take? Basically, which path is better, EB2 or EB3?
I'll just make it very simple. It's simply about the processing time. If you qualify for EB2 or EB3, say you have a bachelor's and 5 years of experience, or if you have, basically that's if you are qualifying for both, you'd have to have the bachelor's plus 5. And I would say that you want to have the quickest green card processing time. The green card for employment-based petitions are comprised of 3 stages: the perm application, the I-140 process, and adjustment of status. It all boils down to the adjustment of status timeline. When is my priority date going to become current? At this current time, for the month of June 2025, the EB2 is being processed at January. They're processing January 2013 cases, whereas for EB3, they're processing April 2013 cases. And that means that April 2013 is quicker, which is related to EB3. However, I have been looking backwards for several months to see what's been going on. And what I see is that when one moves forward, the other one might sit there, but then the next month or two, the other category may move forward. If you want to start now, start with the EB3 process, as it's a couple of months quicker at this time. But these cases move back and forth with the priority dates. That means that the number of green cards being processed or green card visa numbers that are being given out, sometimes they catch up quicker, and they've processed them, and that's why they move the dates forward, saying that we're going to process the older cases now. And so I would say you just go with the one that's quicker at the moment. But you know what? It could also pull back a little. So it's almost like they are neck and neck, frankly speaking. So they're almost the same.
Okay, that's great. And also, Rani, if you can give us, green card cheat sheet that will help our viewers to determine the best path for them, depending on their status, education, or experience, and other factors, then that would be wonderful.
Sure. what I wanted to talk about is, in terms of the cheat sheet, it's really the simple thing is like, number one, what is your education and experience? If your education is at least a bachelor's degree, and or if you have 2 years of experience, so we're talking about the eligibility criterion. Is it the bachelor's degree? Is it a 2 years of experience? If you don't have more than 4 years of experience, if you don't have a bachelor's in 5, you're going to have to go for EB2. EB3, I'm sorry, the EB3 category. If you do possess a bachelor's degree in 5 years of experience or a master's degree, you're going to go for EB2. That is your criterion based on your education. The final thing is with the EB5, you can go for the EB5 if you have the capital through your family members, or if you've taken a loan for that $800,000 investment. The cheat sheet is that the EB2 and EB3 are just going to take, for Indian nationals, they are going to take you 12 years right now. What's quicker in processing time is the EB5, which is going to take you 2 to 4 years for the initial green card. But it's all about the capital that you have. So it's really about the criterion, about what your education is, what your experience is. So I'd love to hear if anybody has some questions just about that. But that's really your way that you're going to go. The other part is if you have a family member, going to your little categories, if you have a family member who's a U.S. citizen, who can sponsor you for your spouse visa, or a parent or a child, then you're going to go that route. So you really, those processing times for the family-based immigration can take about 18 months. So it's not that bad, but it's family-based. So if you're stuck with just employment-based, you're looking at those criteria. The other point is if you have, if you're an individual of extraordinary ability in a particular field, and you are able to demonstrate you're in the top 2, 3, 4, 5% in the world in this category, then you can shoot for the EB1 extraordinary ability green card. And those processing times are around about 3-year backlog at the moment. So you could still get your green card through the EB1, but that's going to be at the higher level. You are in an extraordinary ability category, go for the EB1. So that's it. I just wanted to wrap it up and just kind of show you all that these are the pigeonholes that you can evaluate yourself and your merits on, and that's how you can go. With the EB1, keep in mind you can self-petition, whereas for EB2 and EB3, you need an employer. With the EB5, you don't need an employer, but you need capital. So that's the issue at hand.
All right, that's wonderfully explained. And thank you so much, Rani,
My pleasure.
explaining things in a very detailed way. And let me go ahead with my next question. And this is a very demanding question, right? That most of our viewers do ask. That why do some EB5 investors lose their money and still don't get a green card? What do you have to say on this?
So it appears that the unfortunate aspect of such a case would be the attorney and the investor failed to conduct due diligence in regards to the viability of the regional center project. That means that, number one, is it certified by the United States Citizenship and Immigration Services? Most likely, yes, because the attorney would not have gone that route. However, the failure lies in that the regional center perhaps has not had a track record of processing green cards. And that is what it's surprising when this happens, because one, the investor should not have invested or moved forward with such an application without understanding if there was a track record. And that's what we encourage. We do not guide you to a regional center that just sounds good. Oh, it's creating the basis of a regional center is to create 10 jobs for 10 U.S. workers based on the capital, the capital given by the investor. The regional center is an economic center that has been sanctioned by the United States Citizenship and Immigration Services that is creating jobs for multiple people because they're taking investment capital of many investors. What is happening is that it's an economic unit that one portion of the funds to create that capital or economic activity would be investor money, maybe only 25%. Another 25 to 30% could come from a loan from the bank for that regional center, and the final aspect will be cash from the operators of the regional center. Regional centers are nothing more than shopping centers, apartment buildings, malls. It could be development units. So these are huge capital projects that can run to a few $100 million, and 100 million, 200 million, 300 million dollars. And as I mentioned, the capital from the investors end up being a small portion. Sometimes it's 10, 20%. But that means that for every $800,000 that is invested by the individual from the investor, then 10 US jobs have to be created. So furthermore, so they take X number of investors to reach that certain capital to meet that, the projections. But if the growth of the regional center over time, you get your first green card perhaps within 2 to 4 years. It's a temporary green card for only 2 years. Prior to the expiration of the temporary green card, the investor has to file for the removal of the temporary condition to obtain the permanent green card. So the regional center has to be viable throughout that entire period, which can be up to 5-6 years. And if it did not stay profitable, the investor loses their money because there is no income to the EB5 at the permanent stage. The permanent green card stage will be denied if it's not profitable at that point. And that's where the investor loses their money and their green card. But that's why it's important we use a FINRA licensed broker. It's a broker. There's only 12 FINRA brokers in the United States. They are specifically held accountable. We consult with them to ensure that we're working with regional centers that have viable projects and have a track record to issue green cards. So that's the difference between someone losing their money and failing to conduct the due diligence.
All right, that's really great, and thank you so much, Hani, for taking up these questions very patiently and explaining things in a great way. Now, I think let me go ahead with some of our viewers too. Fawad is here, and friends, also don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Okay, so let's see what Fawad is asking. So Fawad is asking that I have a master's degree in computer science and about 5 years of experience in tech. Some folks are telling me to go for EB2 NIW, and others are saying EB3 is safer. Okay, so can you help me understand which one would likely be faster for someone like me?
So, with a master's plus 5 years of experience, you just because you meet the qualifications for an EB2 application does not mean that, and the national interest waiver, which has a quicker processing time, doesn't mean that you may qualify for the national interest waiver, because again, you have to demonstrate that your work is in the national interest of the United States. So you have to be able to show that through certain criteria. There's 10 different criteria to show that you've been published or you have articles written, and the nature of the work is within the national interest of the United States. If that's the case, certainly try for the EB2. But if I were you, if you're able to, through whatever means, is lock in your EB3 priority date, lock it in through the employer, and if the employer is willing to pay, or you are, then spend the extra money on the EB2 national interest waiver if you meet the criterion, and then proceed with both. Just because I would not rely just on the EB2 national interest waiver in case it doesn't work out. But certainly the EB3 is safe, and I certainly would recommend start with the EB3, then work on the EB2.
Okay, I hope Fawad, you are understanding, and EB3, good luck with that. And in case if you have any further question, then please go ahead and reach out to Attorney Rani Amandi. You just have to visit this link and you'll get the contact details of her. And feel free to ask any question regarding your immigration journey. And she would love to help you. And with that, let me go ahead with my question, Rani, that I have for you. And okay, let me go ahead with this question regarding let me talk about some denials, okay, because most of the time we have been hearing that there are so many reasons that the EB3 green card applications get denied. So I would like to know it from you that what are the most common reasons that the EB3 and EB2 green card applications get denial or delayed.
I think that the some of the issues that affect the perm, there's three stages for the green card. That's the perm application. So that is the stop. That is the location where you're looking at potentially, once it's filed, the Department of Labor could issue an audit, and the audit sometimes is, it could be just a simple matter, a simple question as to, justification for the particular position meeting that requirement. Has the employer been overly restrictive in filing this particular labor certification? Have they made it too narrow? Because if they made it too narrow, it's kind of blocking U.S. workers from applying. Have they tailored it closely to the beneficiary, the foreign nationals' experience? So things like that might pop up. In my 2.5 decades of practice, we've had 100% success rate because we are very careful. I think that when you take a case, you have to carefully document the case. You have to ensure you're not being overly broad or restrictive in different ways. I would say it's like a 99% success rate, but what we make sure is that you have to be very careful when you're drafting the requirements. The other reason a case can be denied is if there's incomplete, if the employer's failure to correctly document the recruitment campaign. So prior to filing the perm application, the employer has to run advertisements in 4 to 5 different media sources, the employer website, an employment-based website, 2 Sunday newspapers, and a third other option, which is a one-time ad in another newspaper. After completion of the recruitment campaign, there's a 30-day wait period, at which time the employer has to document the response for any resumes received and whether any of those workers were qualified, if there were U.S. workers that were received who are qualified to meet these requirements. So if the employer failed to document that, that's a problem. If the employer received resumes from qualified U.S. workers, that's it, game over. The employer has demonstrated that there are U.S. workers available for the position. If there are U.S. workers available for the position, then there's no green card. The basis for this green card to be issued is that they could not find any qualified U.S. workers. So the moment you have that could be a problem, and it is a problem, and the case will not be certified. The fact is, again, it goes down to carefully documenting the job position and job duties with the employer, pulling out all the technical aspects of the position, and ensuring that the position is correctly documented. And so that's the other areas where the recruitment fails, because the recruitment report fails to correctly document, and that U.S. workers have responded. Sometimes it could be the prevailing wage determination, which takes forever, but typically, the prevailing wage is a 4 to 6 month process that is filed prior to the perm application being filed. But either way, it will be certified, but it might delay the case a bit. So delays can come from the perm because sometimes they take longer. They can go to 8 months sometimes, and that could be another potential delay. But audits also delay cases. So audits can delay cases by adding another 4 to 6 months onto the perm processing timeline. Currently, the perm is taking 14 months for approval. It was running even more than that in the last few months, but right now it's come down to 14 months, a little under 12 to 14 months on average. But as I said, the triggers on an audit on the prevailing wage can add 4 to 6 months on to any case. So that's basically the basis on which some cases are delayed or denied.
All right. I hope our viewers are understanding. And friends, I hope you're keeping a note of everything whatsoever Attorney Rani Amandi is explaining. And let me go ahead with my next very important question and that I have prepared for you, Rani. And most of the time we have seen that some of the EB5 applicants, they start, but after some time they get a good job. That means that they qualify for the EB2. So, what if someone who is starting EB5, but later on, if they get a good job, who are qualifying for EB2, should they switch or keep going with the EB5? What's your call on that?
So my position has always been, let's be safe. Let's be innovative, but let's be safe. Let's secure our green card spot. And what I would say is that I would always keep two open if I can. I would, if you had started the EB5, go ahead with it. If your employer is willing to go ahead with the EB2, go ahead. And when you are the EB2 or the EB3 has a 3-stage process, the perm, the I-140, and the adjustment of status. Whereas for the EB5, it's going to be your investor application, and then once it's approved, it's the adjustment of status. Currently, EB5 is current for rural investment regional centers. That means you can actually file the I-526E and the adjustment of status at the same time. You could actually do that. I would do that if I have a track record with that regional center, so you can file at the same time. Whether, as to which case, if you have 2 adjustment of status cases pending based on an employment-based application and the investor application, I would say let them both be processed, and you could then see, you can actually change the basis on which the adjustment status application is being processed if you see a quicker timeline from one or the other. If you're an Indian national, EB2 and EB3 is just not, is 12 years behind. So we're not even talking about that. So if you're a national from any other country, that's when you really want to evaluate this and see if you want to switch between EB5 and EB2 and EB3.
All right. Thank you so much, Rani, for taking up that question. And this is really very important because most of our viewers, get really confused between these two categories and they have faced similar situation. But let me go ahead with another question, and that is regarding the international student. So, what is going to happen? And, can an international student OPT plan for a green card through EB2 or EB5 just away, right after the graduation?
Absolutely, nothing prevents an F1 student from having an employer sponsor them. The issue that arises is that while the perm stage can take, actually, since it's taken 12 months or 14 months for the perm processing, it takes another 6 months for preparation with the prevailing wage to be filed and approved. So you're looking at least at 18 months, which is a year and a half, before your first stage can be cleared. Once that stage is cleared, you have to file, the employer will file the I-140, which is the actual immigrant petition. At that point, the immigrant petition is in contradiction to you as an F1 student, because an F1 student is has a temporary visa and is not permitted immigrant intent. It doesn't mean you can't process the green card. It means that don't travel until you receive your green card. And that makes no sense for Indian nationals because you're looking at 12 years that you can't travel. So it makes sense for other nationals from other countries because they're only maybe 3 years behind on the priority dates. So maybe that student will say, I'm going to finish my schooling, I'll wait, and I'll file my I-140 and my adjustment of status application. So they will be in a position to receive their green card, but it's not for Indian nationals to file that F1 that green card if you're an F1 student visa holder because of the incompatibility of the non-immigrant intent of the F1 student, and which is in contradiction to the green card immigrant intent.
All right. Thank you so much, Rani, for that answer. And I would like to now shed light on some of our viewers' questions too, because I can see so many long, long questions are here. So let me take up Rudra's question. And hi, Rudra. Thank you so much for your participation. If you're participating for the first time, then make sure you have subscribed to our channel till now. And if you haven't, then do it right now. Okay, so Rudra is asking that I'm a VAWA approved applicant. I recently had my second interview on 4th February 2025 after my 601 and 212 waivers approved. After interview, my case went to AP. Is it the bad sign even after waivers? Okay, I think I'm so sorry, Rani, but here's a little explanation of the whole scenario. So let me take up this question. I hope this will be clearer. So, hi, I'm a VAWA approved applicant. I recently had my interview at Mumbai Embassy after my both waivers approved, 1601, I-601 and I-212. Interview went pretty well, but officer put my case under administrative processing. Is it that common for case goes under AP? And
This answer with the fact that I don't process VAWA applications, nor do I process the 601 waivers. However, the one point I can speak to is administrative processing is the additional verification that the consular officer conducts, which delays a case. Good news is you were approved, so that's wonderful. However, administrative processing is where they could conduct some background checks and due diligence back in the United States to verify the basis of what happened for your VAWA case and check on fingerprints. So it could take anywhere from a few weeks to 6 months. So administrative processing unfortunately puts everything on hold. The question is whether it's going to be quick or not. If you have someone in the U.S. who's connected to a congressman's office, you can have that person bring this up. If it's someone connected to your family, bring this up and see if they can intervene. A congressman every congressman has an immigration unit. So I would reach out specifically to a congressman who's a senator, a U.S. senator, that's part of the Senate. He or she is part of the Senate, U.S. Senate, not the House of Representatives. But that is one way to see if they can. They can sometimes have direct answer to the U.S. conflict.
I'm so sorry to interrupt, Rani. I'm really sorry to interrupt, but there's some audio issue from your side. And I think it's a little major audio issue because we can't hear you at all, and there's some different type of sound coming. So I think if you can join us back,
Can you hear
or if you
me?
can do something.
Can you hear me now? Okay, or not?
Yeah, it's fine. It's fine. I think. Yeah, we can continue.
Yeah, because actually your voice also got a little staticky just now, so maybe it's just some internal thing. Yeah, okay. So what part did you hear? What part did you hear?
I think you can just give us a brief about it because it was tracking some different sounds, not that much clear.
Oh, okay. Shall I go ahead? Okay. What I was saying is that I don't have experience in 601s and WAWA applications. However, administrative processing is something that happens even once a case is approved. And the consular officer is conducting some additional background checks on the case. That time can range anywhere from a few weeks to 6 to 8 months. If you have connections with your family, if anyone's here in the US, they can contact the local congressman's office and see each congressman has an immigration unit and they can inquire about that case. Sometimes congressman's office or they will contact the consulate directly. If there's some urgent matter, if there's a reason that you need to get here quicker than later, they can look into it and try to understand what the issue is and they can help expedite.
All right. Okay. So I think you got your answer. And in case if you still need any help or any other thing, then please go ahead and put them on the comment section and we will definitely take them up. Next, Jay is here. So, hi, Jay, and thank you so much for your participation. The question Jay is asking Rani that how much does the country I was born will affect the speed of each option? I am from India and I have heard that things can be painfully slow. Is that true for all three paths?
Unfortunately, the first two are slow, painfully. Yes, 12 years is a long time for you to wait, and you have X number of extensions in the country to bide your time until your date is current. Once you have filed your green card application. DB5 is a quicker route, as we talked about, that it can take 3 years for your green card approval. But yes, the reason why is that countries such as China, India, and the Philippines have had historically greater number, and Mexico, the highest number of applicants. So because they have the highest number of applicants, and there's only a certain number of green cards or visa numbers issued in a particular year, that's why these country nationals are bumped to wait. They started a waiting game because they used up all visa numbers in that particular period, and it goes year by year by year. So unfortunately, yes, it is a waiting period. Good news, if you're not married, of course, everyone knows about a U.S. citizen. Marrying a U.S. citizen, you can get a green card in a short time. So you're lucky if that can save you your time because you actually get married to a U.S. citizen. Now, besides a U.S. citizen, if you marry a national from any other country than India, that national's country of birth will expedite your green card. So, if you marry someone from Pakistan, if you marry someone from Bangladesh, if you marry someone from United Kingdom, France, they fall under all countries' chargeability. And right now, the backlog there is just about 3 years on average for those countries. So you can actually have your green card in that shorter period of time, depending on the country of birth of your spouse. And the person should not just be a naturalized citizen. They should have. It has to be based on their country of birth.
All right. Those are very important points, and thank you so much, Rani, for explaining things in a very detailed and very clear manner. Thank you, Jay, also for your participation and asking this very important question. This was a very important one. Okay, and also don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Now, let me go ahead with the Vivek one. So, hi Vivek, and if you're joining us for the very first time, then welcome to Immigration Talk Show. And the question is that how fast will the visa bulletin change for EB3 for Nepal? As my PD is June 8, 2024, how long it takes approximately?
I don't have the visa bulletin in front of me. However, uh, Vivek, you would fall under all other countries' chargeability. So I think they're at around 2022. So you're not far behind. You are in good shape. You're probably just a year and a half behind. So that's all you have to wait. I not offhand, I don't have it unfortunately, but you do fall under all country chargeability, and we can look that up, and you will see, and you just take the difference between what they're processing right now. You look up the visa bulletin, just Google visa bulletin, go to the month of June, go to the all country chargeability column. You fall under that there, even if your country's not mentioned, because you are not one of the other countries with backlogs. And then you would just take the difference between your priority date and the number that's currently mentioned. I think it's about 3 years on average. Right now, I think they're processing 2022. It might be 2021, but you take the difference, and then you're in good shape. You're not far off.
All right, that's a good one. And all the best, Vivek, and thank you so much for participation. Now, let me go ahead with Supriya's comment. So, hi Supriya, and Supriya is asking that EB5 seems very risky. Is my money secure? And have you seen people getting their investment back? If yes, then after how many years?
Yes, we've seen investments being returned. Typically, the investment capital can be returned uh, within five years, 5 to 6 years on average. The As I stated in the past earlier, that you must seek someone who is either guiding you with connection to a FINRA broker. These brokers have studied all the different regional centers. They are also held accountable because they are going to review and give you a 2 to 3 different regional centers. And we only find regional centers with track records of giving green cards, of issuing the green cards, and who have a reputation in the industry. So these are large construction companies and whatnot, because they're the ones who are developing and building. So it's not risky if it's done through appropriate professionals, and that's what we've been dealing with. So that's the point at hand. Find out if you can, whoever you deal with, I want to go through a FINRA broker to help make my decision in selecting a regional center. That's what you're going to do. That's what you're going to say.
All right. Thank you so much, Rani, for your answer. And Rudra is back and he is saying, thank you for answering my question. I just want to add one more question. Okay. I had my dismissed forgery charges. Is that could be a major reason for my case to went AP? Yes, Rani.
Probably, probably. Luckily, it's dismissed. Then they are verifying that information. It's possibly that, because if they're verifying fingerprints, it's going to be, they will look to see were the fingerprints taken, and fingerprints are related to the criminal database. So yes, it looks like it could be the issue, and if it's dismissed, that's good. So it might take some time for them to review that and make the decision.
All right. So, Rudra, thank you so much for. And if you haven't liked, share, and subscribe to our channel, then please go ahead and do it right now. Okay. Okay. Vivek is also here, and he's also saying thank you so much for getting me the guidelines. Thank you so much, Vivek. And go ahead, like, share, and subscribe because most of the time we come up with these amazing webinars with attorney Rani Amandi, and hope you don't want to miss it. And also subscribe to our channel, then also hit the bell icon so that whenever we come live, you'll get the notification. Okay, and with that, Rani, let me go ahead with my question, another very important one. And that is, yeah, about this that some founders apply for EB2 NIW while growing their startup. So, what do you have to say? That is this a smart choice or a risky one?
Okay, so think anything's risky if you really have to have it evaluated very carefully with an experienced attorney. The reason why you are going this route, seeking immigration advice, is you want the best possible advice. So it's risky. If it's risky, the attorney should say, I think it's risky, and you want to do this, you want to try this yourself, then you can, but understand you have a slim chance of success. Our job as attorneys is to advise of the likelihood of success. And then the individual makes the decision. If I tell you something's 50-50, I will say it's 50-50, and you have to say, okay, I'm going to take my chance. Because 50-50 is not 80%. So that's our job, to advise you, and hopefully the attorneys, we have a professional duty to be honest and advise you appropriately. So, it's risky if the attorney tells you it's risky. If the attorney says you have an 80% chance of success, then go for it. Hopefully you research the attorney enough to know that the attorney's experienced. If the attorney's experienced and has a good, 10 plus years of experience, that should be good. And research your attorney that you're dealing with. That's the number one thing that you individuals must do. So that's what I think is very important, is research your attorney who's giving you the advice, and ask, what is my likelihood of success? Yeah, that's a good question. So once again, I don't know what your startup, I know nothing about that, but it's a general question, but we would have to look at the facts of your case to tell you and advise you your chances of success.
Absolutely, friends. And with that, if you need a proper guidance, then I would suggest that don't wait anymore. Directly go ahead, visit this link, and get the contact details of Attorney Rania Mandy, and ask any question or any complexity that you're facing right now in your immigration journey. And with that, Rani, I have a few questions, that I would like to go ahead with the Facebook group as well. So I think I'll take just a couple more minutes. I hope that will be okay for you. Okay, sure. Then let me go ahead with this first question. And there's anonymous member who is asking that, hi there, what is the average processing time for EB5 if I'm from Vietnam, but already in the US? I'm looking forward to hearing from all of you. Best regards. Yeah.
So the average processing time, if you're in a rural project and you apply within the month of June, perhaps July, is approximately 2 to 3 years. So we're seeing the approvals are coming within under 2 years. And at the same time, for the rural economic project, you can also file for adjustment of status while you're in the United States. So that means you are in legal status. If you are here on another legal status, that's fine too. So yes, you are seeing approvals within 2 to 3 years for your initial green card. The initial green card is for a 2-year period, and prior to the expiration of the initial green card, you would apply for your permanent green card, and then that processing is another 2 to 3 years. So, but you do get your initial green card within a 2-year period. That's possible, 2 to 3 years.
Okay, that's great. And yeah, this is the next question. That hi, few years back, I had enrolled in a PhD program using Day One CPT. I was able to get my first H-1B stamping successfully in 2022, and now I'm planning to get my renewed H-1B visa stamping via Dropbox. So, any thoughts if it is safe for travel given these conditions? Yes, Rani.
Look, I mean, I don't see any issues as long as you haven't criticized the United States government or, engaged in any sort of, it's going to be, they're looking into social media carefully. They're looking at, if you have a criminal record. Those are the simple things that used to just be about your criminal record. But other than that, now the countries are looking into social media. So you want to make sure you don't have anything that's contradictory to the interests of the United States. And rightly so. If you come to the United States, you're looking to have a better opportunities, have better opportunities. So it's rightly so. You shouldn't be, you don't want to be too critical of the United States either. So other than that, if you're going to get an H-1B, it's fine. We haven't seen any issues. As long as you've not committed crimes, and I don't see any issues. Yeah.
Okay, that's great, and that's a pretty positive attitude. So thank you, Rani, for participating in this very important question. And let me go ahead with this the last question that I have for you, and that is: I booked my Dropbox appointment for next week for H1 and H4. So I wanted to see if I can move it by 2 to 3 days, but I'm not able to log in, and it says, "Sorry, you have been blocked." In fact, when I sent email to support, they keep on sending the response that we have responded to your query. Please log into account and check under feedback or request section. I sent a couple of emails saying if I'm not able to log in, then how do I check my account to see what solution they are suggesting? So, yes, Rani, any suggestion? Also, anyone having any idea if there are Dropbox appointments available in June for the week of 15th June?
Okay. The drawbacks matter is an administrative issue to be dealt with the U.S. consulate directly. This is not an immigration question. It's a technical, administrative question related to a particular entity. So it's not something that I can answer. I think that maybe somebody else online can give him help, but I would also drop by the consulate and see if you could, get more information and wait for the email response, or keep trying through email and phone call.
All right. I think that's all, Rani, and it's almost more than a year. I mean, more than an hour, sorry. So it was really a great session, and so many important questions, and that to a very demanding topic. So I would just like to say, thank you so much for giving us time, and also your insights were really great. Our audience, we got really a great amount of engagement. So many people have joined, and Girish is also here. So I think, Rani, let's end it with Girish's question, and after that, we can take a leave. So Girish, thank you so much. And Girish is asking that his friend applied U visa, has lost H1B job, and traveled to India with son. Lost H4 status and stayed 5 months in USA without status and unauthorized work on H4 EAD. She dependent USA. Any option to return back to the USA?
Departed, I would think. I don't know what happened to the U visa, because if you would apply for it, that's what you would wait for. I mean, the only basis for you to be in the United States again is for someone to get a job opportunity. I understand you're saying that the question may be whether being out of status for 5 months in the US and working, it says, and unauthorized work on a H4 EAD. It sounds like a lot of little things going on, little facts that are not clear, but if you get a new opportunity, to come to the United States on H1, you or your husband, then you simply will be questioned on various things at the consulate. But if you did not stay beyond 6 months out of status, then you're okay. Because if you stay beyond 6 months out of status in the United States, you have a bar of 3 years. If you stay out of status for over a year, you're barred for 10 years. So I think that you just made the cutoff, so you should have a chance, and I would try again and see what happens. Because if you want to come back, try on a different visa. If it's a work visa or if it's a student visa, try and see what happens. But I'm not sure what happened to your U visa, though.
That's right. And I'll say, I hope, Girish, you got your answer. And thank you so much for the participation. We are just about to end this webinar, but in case if you have any question, then please go ahead, put them on the comment section. Maybe not now, but after the live stream ends, then also my team will connect with you and surely try our best to provide you the answer. And with that, Rani, I think that's all for today's webinar. So thank you so much. It was really a pleasure and honor to have a show with you, and really looking forward to have a next show with you next week. So thank you so much for joining us.
Sam, thank you. It was actually enjoyable, very enjoyable, because I like to see that we have viewers who are concerned and have those questions, and it's something that we can resolve and provide them some good information in a quick time. So I'm happy that we were able to do that. Thank you. I look forward to working with you again, and thanks for the opportunity. It's been a pleasure.
Likewise. Thank you so much, Rani. Have a great day.
And you too. Thank you.
Okay.
Bye.
Bye bye. All right, friends. So that's all for today's webinar. I hope you watched it and enjoyed it too. And you can also get in touch with Attorney Rani Amandi. And you also don't forget to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. And with that, friends, also don't forget to join us at 4 p.m. EDT. We will be coming live on Daily Immigration Dose. And thank you so much for joining us. Make sure to stay smart, stay safe, and keep watching Immigration Talk Show. Thank you, everyone. I'm Sam signing off for now.
Hello, everyone, and welcome back to Immigration Talk Show. I'm Napasa, and I'm going to be your host for this session that's lined up. And before we head on with today's amazing webinar, I have this important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. And friends, like I said, today we have another very amazing session lined up, and we are going to speak about, everything that's making a buzz right now, especially with regard to student visas here in the US. And to help us, dive deeper into this topic today, we are going to be joined by attorney Isadora Velasquez, and we're going to be speaking about what's changing here with the student visas and how could it affect the foreign students. And by the way, our guest is from ISA Law, yes, based out of Miami, United States. So yes, if you talk about ISA Law, they combine expertise in business and family immigration law. And we are going to be very, very excited today because we have Isadora Velasquez joining us all the way from Miami. Hi, Isa, how are you? Good to see you.
Good to see you again. Very happy to be here because this topic is hot and changing every day. So I'm glad to discuss it.
Yes, so true. Every day is so interesting, especially when you talk about US immigration law, right? So
Correct.
you have been busy, I'm sure. Tell us about it. What's going on with ISA law?
Well, we do a lot of detention work. So, for better or worse, we have been very busy. We do a lot of court cases. So, we are here in Miami and all over the United States. So, yeah, it's been a very busy couple of days, but very fulfilling because we have been able to maneuver many changes. So, I'm hoping I can explain all of them to you guys and your audience so that we can be ready for things that may be coming our way and we're not caught off guard when they show up because there will be new changes, not only from a local level, but also from the Supreme Court and especially for students. So it's good to be prepared for what may happen soon.
So true, so true. And thank you so much today for making time to be here. And I'm very excited because we have some very amazing questions from my end. And I'm sure that folks out there, who are also watching us from different corners of the world are going to be happy to join us with their questions as well. And let me tell you, folks, that you can comment wherever you're watching. We are live right now on YouTube, but you can also check us out on LinkedIn, Facebook, X, on Instagram as well. And please feel free to drop in your questions. We are going to take them a little later in this webinar that's happening today with none other than Isa Dora, attorney Isa Dora from Isa Law. So check us out. And another very exciting thing is that you can join us on call. And the number is displayed above on the screen. The number is 425-436-6335, and the access code is 988-888. So feel free to join us. And Isa, I'm excited. So I think without further ado, let's just go into the questions if that's all right with you.
Of course.
All right. So I've got this first question that's coming up, and that is, was the US State Department's global pause on student visa interviews something that you anticipated, or does it feel like a sudden move?
Well, it felt a little bit sudden, I think, for all of us. And the reason was because we were actually caught off guard when we started seeing the detention of residents for voicing their opinions. We know that anyone who is not a citizen could have been detained, and the privilege of being in the U.S. can always be taken away. But doing so for specifically having a different opinion than the government is something that we had not seen at such a high level before. So the pausing of specifically the student visas for the particular reasons that the government was advocating definitely caught us off guard. At the same time, we was something that we thought was going to be redirected only to a specific organization, in this particular case to Harvard University. And we found it interesting when the government decided to pause it for all institutions altogether. Interestingly, though, the fact that it was originally directed solely to Harvard has been the green light, because the deep lawsuits that originally started with Harvard have now opened the door for us to assume that these visas will soon resume, meaning Harvard has been very successful. And as soon as yesterday, the Department of State has announced that they will be resuming the visas for Harvard in particular. So that leads us to believe that visas for all students will soon be resuming very soon. So I'm hoping that this is only temporary. So the same way we were caught off guard thinking this was only going to be for one institution and it ended up being for everyone, now this one institution will hopefully open the doors for all of us to start seeing these student visas up again. So don't despair. I really am hopeful that the Department of State will soon give new directives on student visas to start interviewing again.
Absolutely. Even I feel so also, because even recently, we had a couple of hundred, people, students who had their visas revocated, but then, they were all active again. So I'm so excited. I mean, so happy that that happened for them. And I really hope that it works the same way even for the others as well. So,
Yeah, it just emphasized how we must be on the constant lookout for the news. I know that, especially as students, we are busy studying, of course, that's why we came here. But now, with immigration in particular, when we have this temporary status, we have to constantly pay attention to the news, because what we've seen is, of course, the student visa for new visas in particular were affected, they were put on pause. But now we have the added layer of a travel ban. So although we expect that we will see new student visas come up and that we will see the interviews come up thanks to the lawsuits from Harvard and the Department of State, please remain cautious for the 12 countries that are now part of the travel ban, because that has now come to effect. And unless there's new litigation, in particular from those 12 countries, we have to remain on the lookout for the news to see if those particular countries will have the student visas. For so far, the answer is no for those 12 countries in particular.
Right. Thank you so much, Isadora, for that, helpful explanation, I would say. And I would like to also greet our folks who have joined us. Ricky, hi, Ricky. Thank you so much for joining us here on YouTube. He says hello, by the way. And stay with us. We are going to take up your comments and questions in a little while. So be with us, Ricky. And also, Isa, the pause, which is being linked to the national security and enhanced social media screening. I mean, nobody thought that social media would be screened at this level. I mean, we've been in social media for, more than a decade or 2 decades, and it's been very, very involving, I would say, and didn't know that it's going to turn up against us someday like this. But how should we understand this shift from an immigration law perspective?
Well, if you didn't think it was going to be this screened this heavily, obviously it goes back to my point before on how we need to pay attention to the news, because this is not a surprise for anyone who's been looking at the news. And so, it's not just for the immigrant community. U.S. citizens are now seeing the very intense scrutiny of social media, particularly at the airport, to the point that when we come in as U.S. citizens, we have to relinquish our electronics. We are now being advised that when we travel to do so with our electronics in airplane mode, because technically even us as U.S. citizens have to, when we're questioned by agents, unless we have specific entries such as global entry, we could be questioned by agents, and we don't even have the luxury of letting them or simply rejecting the answering of questions when it comes to social media, or not giving them our appliances or electronic devices or phones or cell phones or even our computers. So having them in airplane mode is the only way to avoid answering these questions when it comes to social media. I give the advice of putting them in airplane mode, but that won't help the immigrant who's seeking a visa, because of course they will scrutinize very heavily your social media handles, what you have posted, and what you may have deleted. And that's only going to continue, because imagine if you're doing so very heavily for US citizens when you're coming in through the airport, they're going to do so even more to anyone seeking a visa, not just student visas, any visa at all, including tourist visas that we've seen maybe in some countries in particular may be easier to get. Now social media is highly scrutinized. Also remember what's going on inside the US, the whole internal turmoil, the division. So, and even division inside our own government and sadly politics that has seeped into how visas are being processed. Sadly, the advice that we immigration attorneys are now giving our clients is that although freedom of speech is basically how the U.S. has been built, when it comes to acquire immigration benefits, it has to be limited. If you wish to seek any visa, from tourist visa to student visa, even work visas, freedom of speech is something that sadly will be used against you. And that is something that is in the discretion of the Department of State when processing any visas. So you must be very careful with what you may have posted, even if it's your own country's internal turmoil. Understand that the government, in their own discretion, I mean here the US government, may review it and even hold it against you. So we have been at least I have been instructing my clients to be very cautious with what they post, even if their web pages are private, because understand that your page might be private and you may have a friend whose page is not, and they decide to share something, the government may have access to it. We have lately seen some interviews, although attorneys don't accompany their clients to interviews at the consulate level, they do accompany their clients here inside the US at their interview. And we have seen the government show pictures of what they may have posted in their social media, even when their pages are private. So you may think, oh, my page is private, they won't have access to it, and you will be surprised what the federal government can find. So although I encourage people to be vocal and protest if they want to, be careful if you're looking for a visa, and try to balance out what's more important, what's your need. If your need is to come and work in the US or come and study in the US, or to voice your opinion, understanding that sadly, under this political climate, it will be used against you. That's just the way things are being processed right now. There is very active litigation both in the deportation level, that is very notorious. You may see it in the news. There are people who are right now undergoing deportation removal proceedings who are residents right now, facing possible deportation consequences solely for both voicing their opinions, not just in social media, but also in protest. And that's being used against people seeking visas. So it's only going to continue until litigation has some impact on how we regulate social media. Because it's in the beginning stages, as Nifasa just mentioned, we have to be very careful. So if you're seeking a visa, my advice, like I said to all my clients, is balance it out. And if you can be quiet, that is sadly the best way to go at this moment. Because if you want the visa, anything you post can and will be used against.
Well, that leads me to my next question. I mean, what about, free speech and fair immigration policy, stuff like that? I mean, if you look at Secretary Rubio, who hinted, there's that potential visa denials, tied to activism and public criticism. So, how does that sit with US principles of free speech and even fair immigration policy?
So that's the balancing act. So what we've done is there's some, I admit I have some clients who understand that because of their jobs, their studies, they have chosen to delete their pages and they have simply chosen to take, we may say, the easier route and simply keep their visas and not risk it. Others, I admit I have some very brave clients who have chosen to fight their deportation and they understand that they may be facing, originally in the introduction, Ipasa briefly mentioned some visa revocations that we saw, student visas in particular. Some of them were revoked for very trivial reasons, arrests that were dismissed. Some of them were revoked for very serious reasons, maybe posts that didn't disagree with our government's current values. And we went to court and we sued. Interestingly, the government reinstated these visas, so the lawsuit later became moot. But those people were doing it to state, basically for the same reasons, to send a message, the importance and the value of the free speech or the U.S. First Amendment that is so strong. And in a way, some people will argue that made this country what it is today. So it's more of a balancing act. I admit I have some clients who are a bit hungry to express their opinions and they want to go to court and they're not afraid to fight it. Others are a bit more hesitant because they understand they have a job and schooling and they don't want to risk the visa. That's why it's more of a balancing act of each person's values. Also, I must, I'm not going to minimize that it's not cheap to go to court here. The United States is a very litigious country, but at the same time, it's not a country in which going to court is cost effective. It can be very expensive to have attorneys, and the government is aware of this. That's why they know that going to court face deportations, they don't give you an attorney. It's not like criminal court where you have an attorney assigned to you to represent you. Because they know that, they also understand that people who may be detained can't afford an attorney. So I mean, immigration attorneys have been trying to pair up with nonprofits, but we're also a bit overwhelmed at this point. There's many detentions going on. So it's once again, balancing act of each person's values, what they can contribute and what they're willing to endure. Is your boss willing to put up with you missing some time of work because you may be having issues with your visa? Is your school right now? Most schools are in summer break. So it is maybe a good time to be facing litigation. So it is the balancing act of what we can face and what we can afford and where can we find people to represent us. But there are some organizations, depending on the state, who are fighting back. Right now, if anyone's following the news, LA is very notorious for being very active and vocal, and that is one of the issues they're fighting, the lack of freedom of speech for people who may be seeking visas to come to the US and don't have access anymore to that social media aspect that has been so essential in a way to communicate. So hopefully people will keep fighting, but as a balancing act, if you want to come to the US, my advice still remains, be careful what you post because it will be used against you.
Exactly. And that brings me this funny thought that, we used to have notebooks. So I'd say maybe start writing them on your notebooks rather than just posting them on social media, or maybe tell it to your best friend, but not on social media. Right, Isa?
Yes, and don't send it on a text message because remember, they may take your phone and read that message. And if you have that notebook with you, maybe put it in your suitcase or don't carry it in your carry-on because they may go through your bag.
There you go. Thank you so much, Isadora, for that. And yes, I do have more questions, but I think we should take a couple of them from our audience as well, not keep them waiting too much. So, folks out there, I hope you are, enjoying this session and you're resonating with this discussion. So please do not forget to subscribe to our channel. Our handle is at Immigration Talk Show, and check us out. We are on YouTube, LinkedIn, Facebook, X, and also on Instagram. And of course, if you have or you want to contact attorney Isadora Velasquez, for a one-on-one consultation, please visit this link, which is displayed on the screen. Now let's take up Ricky's question. My NIW I-140 petition was filed by employer. NIW I-140 petition processing time for the Nebraska Center is 16.5 months as per USCIS website. Can you give some idea on the typical processing time that you are seeing for the I-140 petition? Also,
Ricky,
can premium processing increase chances of RFE for NIW I-140 approval?
Ricky, if you look on the website, and first of all, thank you. I saw that you were here very early, so I highly appreciate it. But if you look on the website in the top corner, it will say that this is the processing time for 80% of cases. And what we've noticed is they're fairly accurate. So on average, it's around 15 months. 16 tends to be on the high end, but yeah, around 15 months. As to the premium processing, personally, I am a fan of premium processing. Not all my colleagues agree. I have actually seen the opposite. If you do a really good job and you pay for premium processing, not only do you get a quick answer, so you have that weight off your shoulder because in less than a month, 15 days, if you have the need for an RFE, the reality is that I always warn my clients, most of the time you may get an RFE because they want to buy the time to get additional 87 days to give you a response. But in reality, who cares? If your case is good enough and you know you have the information, you know you have the evidence, you're still going to shorten your time significantly from 15 months to 87 months, because once you send the evidence in response to the RFE, they have to respond again in 15 days. So I encourage premium processing. I know it's pricey, but I think it's a good idea. I think it's worth it. I also personally think it increases your chances of an approval. I think immigration has seen they take you seriously when you're willing to invest in premium processing. So it may increase the chances of an RFE because the government wants to buy time to process your case, but I still think it's worth it. So that would be my advice if you're willing to do it. Then again, if you're in that category in which you're not going to get it right away and you're not in a hurry, you may want to save that money. So it's balancing on getting the response right away and getting the weight off your shoulder, or how costly it could be.
Right, right. Thank you so much, Isadora, for that, helpful explanation. And I'm sure that it will be very, very, very helpful for Ricky. So all the best, Ricky. And now let's go on to Minakshi Sood's question. As a foreign student, I'm concerned about my visa status. Could these changes affect my ability to stay in the US if I already have a student visa, or will they only apply to new applicants?
Great question. So there's two changes to keep in mind. One has to do with people who are applying for a new student visa. Those are the people who are seeing that they're not getting appointments. So if you already have your student visa, congratulations. You don't have to worry about having to get that appointment, which is so difficult, almost impossible to find at this point. The other big change is the travel ban. If you already have your student visa and you're out of the country, come back quickly. Understand that there's a list of 12 countries that are part of the travel ban. They gave us a very small cushion to come back. And the reason is because if you are part of this list and you're not back, you're not going to be allowed in, even if you have a visa. So to answer your question, the travel ban does affect people who already have visas available. Even if you have a student visa, if you leave your country, you will not be allowed in. So keep that in mind, that changes affect individuals who have visas. Travel bans affect individuals who have visas, basically making these visas void if you decide to leave. So the visas remain valid if you're in the US, but they will not allow you back in if you choose to leave. That's the big distinction. Now, if you already have a visa, you don't have to worry about an interview. that's where you don't, the student visa becomes a great asset. So you don't have to worry about that interview that no one can find out, and hopefully we'll be able to get them soon again.
For sure, for sure. Thank you so much, Isadora, for taking up this question for Minakshi. Now let's take up Imran's question as well. And hi, Robinson, thank you for joining us. Imran, thank you as well for joining us, and let us take your question. I've been considering going for a part time job during my studies, but with the visa changes, I'm worried that it might cause problems with my status. So, are there specific rules I need to follow for an on campus and off campus employment now?
So far, there haven't been any changes as to on or off campus jobs that will affect your visa, but the main rules are that you need to ask your school for permission. For example, Venezuela is a particular country that, based on a memorandum, they are allowed to work. But to do so, to get that particular work permit, they are encouraged to go to their school, the school that issued their student visas, and let them know that they need employment. The memorandum, and for Venezuela in particular, points out that the country is in dire need, and because of the need, the U.S. government assumes that everyone who has a student visa from Venezuela also has a need to work. So if you are somebody who needs to work, it is advised, and this is for anyone who has a student visa, to go to your school, to the admissions department, let them know that you need to work. They'll evaluate your circumstances. This is called work study. It is allowed under the student visa. Once again, it has not been announced that this will change, if there are any circumstances. Just let them know you need to work, and they will work with you. Most of the cases, they allow for work study inside on campus. I encourage it. If you need it, go get it. Once again, no announcements that it will affect in the future. But as I mentioned before at the beginning of the show, right now, although we might be busy working and studying, it is important to follow immigration news, because no announcements that this will change, but we never know. So it's important to follow if this may change in the future. But if you need to work, go to your admissions department, let them know, and they'll work with you to see if they can offer most likely employment inside on campus and on the campus. And if not available, they'll look for something, at least help you or assist in trying to see if you have something off campus that may even be related to the field that you're studying. So it's good to ask your school first. That's the first step, and it's essential.
Absolutely. Thank you so much. I'm sure that that'll be very helpful for Imran. Thank you, Isadora, once again. And friends out there, to keep yourself updated, since it's very important, especially that, every day there is a new update with regard to US immigration policies. So do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. We do come up with, the latest updates as soon as we have them. And of course, if you want to have a one on one consultation or maybe get some help with your visa process, do contact attorney Isadora Valquez and visit this link, which is displayed on the screen. So thank you again. Now let's go on to Robinson's question. He's saying, I'm a foreign student currently pursuing a master's degree in the US and F1 visa. The new rule proposes to limit the duration of stay for F1 visas to a fixed period of 2 or 4 years, depending on the country of origin. How would this change, affect my ability to complete my degree, and what steps can I take to ensure I can remain in the US to finish my studies?
So I'll tell you how we've been addressing this. The U.S. Is notorious for having students who are actually full-time students and are whose career, whose job is to be a student, meaning that they're master students who take much longer than 2 years to graduate. We have applied for these students to extend their visas locally. It will be an extension of your status. So that would be how I would answer your question. How would you change your ability? Instead of having the typical maybe leave and to go through consular process or having to renew your visa, the same way you have maybe applied to extend your visa before inside the US, that's how you would apply to extend your visa inside. I know it may sound contradictory, they're limiting your F1, but if you're able to show that your master's degree is not done, they have been allowing your extension, just showing how many credits you have left. Interestingly, I don't know if many of you recall, I assume you're all rather young, the student visa typically used to be a visa that had an I attached to it. An I to mean indefinite, meaning you would renew it until you were done with studies. these new regulations that limit the time, we attorneys have been able to fight back against them using their own American techniques, meaning how long Americans may take to finish degrees. Most Americans don't take 2 years to finish master's degrees. So that would be your reasoning to either extend your visa if you are not done with your master's degree. So you can apply, like I said, to the form is the I-539. You can file it inside the US through your school, obviously, to get a new form I-20 to show how many credits you have pending to extend. You could do consular process, but personally, I would encourage you to do an extension of your status. We've noticed that has been easier because through consular process, because of the rule, in consular process, they tend to be a bit more, so we will call it stickler for the rules. So it's easier to do the extension of your status. USCIS, the administrative department here in the United States, is more understanding of the American way of taking a little bit longer than 2 years to finish your master's degree.
That is very interesting. So, I mean, plus different countries have different timelines, right? I mean,
Correct, correct. Americans like to study for a long time, I guess.
well, well, how, I mean, if I may ask, with visa law, how many student visas you're dealing with right now, Isa?
Well, I'm going to tell you a little secret with visa law. We only, when it comes to student visas, we encourage, especially encourage our students to go directly to the school and to process the visa with the school. We only process the visas with the students if the schools are having issues for whatever reason. For example, when a few months ago they were having issues with their revocations, that's when we got really hands-on and fought for our students. But otherwise, because the schools have to work so closely with the students, we tell our students, go with the school, save that money, and use us when you really need us.
Okay. That's interesting to know. And thank you again. Ricky, thank you for your questions. Please stay with us. We will take them up very, very soon. But now let's move on with some of my questions as well, And I wanted to ask you, what's the immediate impact of this policy on Indian students who are aiming for fall 2025 intake? The denials or the free speech and fair immigration policy we spoke about some time back.
I'm sorry, I got this. I was reading Ricky's question and I got distracted. You mean the with the impact that we've seen? Oh, well, the impact that we've seen in the schools, and I know because the same way I encouraged my students to apply to the schools is because I work closely with the schools to make sure that they apply correctly. And what we've seen is schools very concerned about not only the lack of diversity, which was already a problem at the beginning of the administration because they were pushing against um, getting rid of some diversity policies that the prior administration had implemented. But now it's even worse because the schools are actually actively not receiving the visas that they expected from other countries. So they're seeing a lack of diversity in the schools. As Nipasa mentioned in the beginning, introducing me, I am located in Miami, which, as you can imagine, is a very diverse area. But my law school is located in Pennsylvania, not a very diverse area, particularly Carlisle, Pennsylvania. My law school has severely complained that they relied on student visas to meet their quota of what they understand as a diverse school, and they haven't been able to meet it. So that has been the impact, at least in the schools, of not having the visas processed. In addition, right now we're in the summer break. Schools rely on income from international students, and they don't know if they're going to have that income starting August when the schools start. So they are worried about, for example, a notorious school, well, not notorious in a negative way, but a fairly large and famous school here in Miami, Florida International University, the name says it. They are concerned about not having those international students that make their school so famous beginning August, because many of the visas for the freshman year have not been processed and they don't know if they will be processed in time. The Harvard list for Harvard in particular was announced yesterday, June 9th. June 9th, and yesterday was June 10th. We don't know if the visas that are processed just for Harvard, if it's going to be enough time for schools like Florida International University to meet their quota just to fill their freshman class. So University of Miami, Florida International University are worried, yet we attorneys worried that the only school that has been fairly vocal about not meeting the quota or just enough of students has been Harvard. We know the schools don't have enough international students lined up because there are simply no visas being issued, but no one is speaking up in terms of lawsuits besides Harvard. Possibly because they're afraid of losing funding from the government. The government has taken away $2.6 billion dollars from Harvard just because of this issue. So maybe that's why schools haven't spoken up, but at the same time, they are losing a lot of money by not having the students lined up. So I think once they do the final numbers and they see how much money they're losing by not having international students and how much money would they lose if they make the government angry, we may see more lawsuits. And that's when we'll really know the answer to your question as to how are students being affected and how are the schools truly being affected. But right now, we're a bit in the dark.
Oh, goodness me, those are huge numbers. And even if we look at, yeah, the students' perspective, they are afraid that they'll be having gap years or gap months. And, fall 2025 is very, very soon. And they're even worried about spring 2026. So, what about that?
Well, the schools are worried about lawsuits to them because many students have already paid for the
Right.
semester ahead. So they're worried that if the students can't get the visas that they were promised, because like I said, when you had asked me how many visas are firm process, I warn you that we send our students directly to the schools to process their visas. So these students already paid the school the tuition, they paid the room and board, and now they're being warned they might not get their visas. They're definitely going to be suing some schools. Schools like the University of Miami cost $40,000. So these are going to be many lawsuits that the schools may be facing, and we wonder who are they going to sue back? If it's going to be the federal government, or are they going to be rush jobs um, to get the visas going once the appointment starts? Because attorneys like myself, tourist visas are taking a year to process. So attorneys like myself were encouraging people to get student visas if they wanted to come to the U.S. quicker, and now that plan may backfire. So it's going to be interesting couple of months.
Yes, every day is interesting, especially with US immigration. So, friends, do not forget to subscribe because we come up with the latest updates that you don't want to miss out on. So, ring that bell and subscribe to our channel at Immigration Talk Show. And also, friends, I'm sure that if you are navigating a US visa, you may need some help and you may need consultation. So, why not go visit attorney Isadora Velasquez and check her information in the link which is displayed on the screen. So thank you again, Isadora. I'm having a great time. I hope you are as well. Are you ready for more
Yeah,
questions?
I enjoy it always. Of course,
Okay,
of
so
course.
are there any proactive steps that universities or students can take, to minimize this disruption caused by these delays?
Yes. So the proactive step, one of them we hinted to before when we were talking about people who already had the student visa and if it would affect them. One of them is people who have tourist visas, and they said, "Okay, I was waiting for my student visa. Now this appointment is gone. What should I do?" If you have any other visa to come to the U.S., we've been encouraging our clients to come here using that visa. If you have a tourist visa, which is the most common one, use it to enter the U.S. I must distinguish a tourist visa from ESTA, or what we also call visa waiver. Those visas are typically tied to European countries, and that's because a tourist visa, I can apply for a change of status. I can change your status from a tourist visa to a student visa while you're already in the US. So if there's no appointments in the consular process, you can still come to the US with your tourist visa and I can change your status to a student and you can go to school. Or if you come under your age 4 category for your parents' visa or whatever, another visa, I can change your category. But if you come under ESTA or what, as I mentioned, the visa waiver, that is the one of the few visa categories that cannot be changed. You cannot change your status from that to a student visa. So before you enter, make sure you speak with an attorney and find out if your visa status can be changed. But explore that. If you have a visa, try to come to the US and we'll change your status to a student visa so you can study. So if you can't find an appointment abroad, we can change your status here in the US while you're already here.
There you go. Thank you so much, Isadora, for taking that up as well. And now I have another question, and that is, for students who have already paid tuition or, secured their housing, what is the option that they have if their visa plans are now very uncertain?
So when Nipa sent me this question, I actually reached out to the schools that I work with and I asked them, what are you guys doing? And that's how I found out that many of them are worried about lawsuits that may come up. They have mentioned that some students have actually started in the process of suing them if they're not offering refunds. Some of these schools have already started giving them contingency plans, such as potential refunds if they're not able to make it by in time when the school starts. They do hope that during the summer break they will resume with these interviews and people will be able to make it in time for when the school resumes. The third option that the schools have mentioned they will be offering is putting your position on hold so that if you're not able to start for this semester, which will begin in August, September, maybe you can start by the next for spring. So it's advisable that if you've already put your deposit, contact the school. And of course, if the school is unreasonable, I emphasized before, the U.S. is very litigious. This is the type of lawsuit that because private schools in particular, which are the ones that tend to issue these visas, are pricey, attorneys are working on what they call a contingency fee, meaning that they are not charging hourly, and hourly fees can be very pricey. So if your school is being unreasonable and not working with you, not trying to give your money back or hold your spot, be aware that there are attorneys that are definitely willing to work with you to take action with the school. But most schools, I've noticed from my research and preparing for this today, are definitely willing to work with you because they understand it's the Department of State not cooperating with this. And that's why I think this is very going to be very short lived. The same way the revocation of the student visas at the moment was short lived because the schools did speak up. They were not suing as much as we would have liked, but they were privately putting some pressure in the government, letting them know we're losing money and affecting our economy. So hold tight. I think this is going to be brief, but I'll keep you guys posted as to what may happen. But contact your school right now to make sure you're protected.
It's very important to stay in touch with your school, the DSO, and especially because you're an immigrant here, and to be informed is your power. So, friends, do not miss out on any information, and make sure that you have subscribed to the news that bring you the latest updates, and of course to our channel as well, because we bring the latest updates on US immigration as well. Our handle is at Immigration Talk Show. Do not forget to subscribe and ring that bell. So, Isa, we should take up some more questions, and we do have from Ricky now. Ricky, let's take up. He says thanks already, by the way. And our WhatsApp calls also subject to social media scrutiny during visa appointments and USCIS petitions reviews. And our WhatsApp conversations or calls also subject to social media scrutiny for visas and petition. Well, I am one of the core members of the startup helping technically was as well as in raising funds and bringing in new projects. Can you suggest ways to use this to build profile for EB1 petition? Well, Ricky has a lot to say first off, but yeah, never go ahead.
I like your project, Ricky. So first, WhatsApp. Yes, definitely they can be used. Now, calls are difficult because you're calling and it's supposed to be encrypted, so they're not supposed to know. But if you're calling somebody who they can see is somebody they might not like, yeah, they will know. WhatsApp is a tool they can use against you. So my advice is when it comes to going to the interview, delete WhatsApp. Don't have it. Same thing coming to the airport. Don't have it available. Have it on airplane. The truth is, the government knows that you may have WhatsApp. I am one that I am not a fan of WhatsApp, but that's because I am Hispanic, as you may be able to tell. And in the Hispanic community, we love WhatsApp and we abuse it. So my friends use it so much that I just delete it because it's used way too much. So maybe you can get away with that excuse that I just don't use it because it's too annoying and I like to be unplugged. But if not, be aware that they might find it a bit suspicious if you don't have it. But they can go through it. They can use it against you. So just be careful. I'm not saying delete every message. WhatsApp is a little bit easier to control than other media like Facebook or Instagram, in which we think we delete things and they show up in the future. WhatsApp is, when they say it's encrypted, it's encrypted. That's why we see a lot of criticism on the government not being able to access it. So you do have a little bit more privacy when it comes to WhatsApp, but just make sure whatever you don't want them to see, it's not there. to be seen. But yes, it could be technically used against you. As to my tips for EB1, my biggest tip when it comes to how to build it up to be successful is, if you're gonna go the EB1 route, EB1 is for the big boss. So be the big boss. You can't be hands-on as much as you would like to be to really go the EB1 route. If you're gonna be one hands-on, you may want to consider EB2, which is more of artists. I mean, if you're EB1, maybe work on your talent or emphasize how many awards you have won. EB2 is more national interest or more of a petition. So, but EB1 is either be back off and let the firm run itself, the startup run itself. But if you're a core member and you're very hands-on, they might say you're more of an employee. If you're a core member and you're hands-on, focus more on how many awards have you won? How many awards has the company won? How many of them are tied to you? How much money do you make? Either become a very special, above and beyond individual, or become very hands-off, big boss, so that they say he is the CEO. CEOs don't answer the phone. They don't meet with clients. They delegate. Or if you're extraordinary talent, you are extraordinary talent. You're the GOAT. You're messy. You win everything. So that balancing is very important for the EB1 category. Otherwise, you may want to consider other categories. But for raising funds, it's very important to see how big the project is and how much you can bring to it without being too hands-on, depending on what you're doing. I know it's a very complicated explanation, but it's really the best I'm trying to help you here. It's EB1 is complicated. Make sure you have an attorney guiding your
Yes,
hand.
I think, yes. I
Please.
would always suggest that, no matter what visa you are dealing with or are, the process that you are going through, it's always best, to get some important advice from the experts out there who are immigration attorneys like you. And friends, if you need a consultation or some advice, do not forget to also visit this link, which is displayed on the screen and scrolling below, and go visit, yes, this link to get to know more about ISA law and attorney Isadora Velasquez. So we do have more questions, Isa, and I think we should just take them up. So, Control, let's go. Yes, with this first one is from John Wick. Can anyone help me with a situation? I have submitted my DS 160 in 16th of April and paid for my MVR fee and booked appointment on 2nd May. Today I noticed that I submitted the DS in different country. US Embassy portal. What should I do now? Can anyone help me with this? It's very urgent.
Email them. There should be an email, and if not, you need to contact an attorney, because we do have an email, and that's how you let them know I submitted this in the wrong portal, and they'll fix it for you. As an attorney, we have access to an email that we use to fix mistakes. Of course, we're all human. If you don't have an attorney, now is the time in which you hire an attorney. But email is the way to fix mistakes like this. You basically email them and let them know this mistake happened, and they will fix it for you. But that is at least the way we handle these things, which happen to us all the time in our office. You must email them, contact them right away, let them know. Because you're right, it is very urgent. Email them.
Thank you. Thank you, Isa, for taking that up. This is John. I hope that you are resonating with all these answers and discussion we are having today. And folks out there, do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And also ring that bell so that whenever we have discussions like these, you're notified and you can join us with your questions. And Ricky, since you have been commenting, I would just say, folks out there, we also have a number for you to dial in. So why not just call us on this number? The number is 425-436-6335, and the access code is 988-888. Join us. So this next question now is from an anonymous member, and saying, "Hi, did anyone change their visa from F2 to F1 without leaving USA? And how much time is it taking nowadays?"
Yes, you can change from F2 to F1. As to how much time, go to your school, because it will really depend on when your school starts. For example, here in Miami, we have language schools that work by trimester instead of by the semester, and they may be starting in a couple of weeks because they may be summer schools. So when they are working with you, they may be able to change your status from F2 to F1 within a couple of weeks because they need you to start fairly soon in July instead of waiting until August. So find a school that is suitable for you, and that way you can apply for your change of status. That's the form. That's exactly what you're applying for. So yes, you can change your visa from F2 to F1 without leaving the U.S. I highly encourage it. Right now, it is being done right now. It's not being done at the moment are the actual consular processing, the appointments at the consulate level. Do so and find the school to understand how much time it may take, because that will vary depending on the school that you choose. Because like I said, the school is the backbone. They need the I-20. They need all those CVIS forms that they have to process for you. Without the school, you can't get it done. The school will determine how much time it will take.
That's interesting, and thank you so much for the detailed explanation, Attorney Isadora. So now let's go on to this next one. This is from another anonymous member asking, on submitting my DS-160, I got following message. An unexpected error has occurred while processing your previous request. The error has been reported to the site administrator. No further action is required. To retrieve your DS-160 application, please enter your application ID. Has anyone encountered something like this? If so, how did it get resolved? Do you know anything about this?
It's normal. It happens. The system falls regularly. Of course, we attorneys know because we like to submit applications late at night, at midnight, when systems crash. It's normal. As long as you can access the DS-160 application, which I encourage you to, because it's always good to always have applications that you submit to make sure all applications you always submit to the government remain the same with the same consistent information. Make sure you have it. So as long as you can access, it was properly submitted, you should be okay. There's nothing to resolve, as the system said, because it was properly submitted. They're just simply letting you know that maybe it was not sent immediately because they were doing some maintenance or whatever it may be. That's why it was an error message. But the application was properly sent as long as you can access it. That's how you resolve it. If you can access it, you did it correctly. If you can't access it, that's where before I said email it, you would try to troubleshoot it. Either email them and let them know I can't access it, or try to file it again. But if you are able to access it, you did it correctly, and it was just an internal error due to maintenance, because like I mentioned, we've been through it. It has happened before. But if you can access it, you're fine.
I'm sure, I'm sure. And thank you so much, Isa, for taking that up. Let's go on to our next question. And this is saying, hi, has anyone on STEM OPT tried to renew their F1 in the last few months or recently? Please share.
So STEM OPT is having some issues, and it's not just STEM OPT, it's OPT in general. Technically, you should be able to renew your F1 because it's still available, but the government, you know how before we were discussing work study and whether there has been any announcement or any issues with work study. And the truth is there have not been any issues with work study, and I encourage people who need to work study to go to their schools and request it. OPT though, which is different, is when we're done with our school and we want to take some time to actually practice what we studied. OPT has been under the administration's watchful eye, and it might be on the shopping block. We don't know yet, but it has been discussed as something that might be eliminated. And because of that, we have seen some, not issues, but delays with the transferring of OPT back to F1 status. I still encourage my clients to apply the same way I encourage the person who formerly asked before about F2 to F1. So if you're an OPT, definitely go to your school and mention that you want to go back to school and you would like to apply for your F1. The school will work with you, because you should be allowed to apply and change your status from OPT or to extend your status from OPT, which is an F1, to another F1 visa. But be aware that it may take a little bit longer, simply because of the conversations that the Department of State and Homeland Security have been having here in the U.S. about possibly eliminating OPT. But it has not been done yet. It just may take a little bit longer to change from OPT back to F1.
Yes, there is a lot of changes going on. And friends, I think it's always best to consult with an expert, an immigration attorney, whichever visa process you are dealing with right now, whatever your status may be. So why not visit this link which is displayed on the screen, and you can get the details for attorney Isadora Velasquez and also the contact details for her as well. So also do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. Check us out, and let's go on with our next question now. This is from another anonymous participant asking, "Hi everyone, I'm applying for an F1 visa to pursue my master's degree at a public university. All my documents are ready, but honestly, I'm feeling a bit nervous about the interview. I was previously refused a B1, B2 tourist visa, and I'm worried that it might affect my F1 application. If anyone has tips or advice on how to prepare or what to expect during the interview, I would really appreciate it. Thanks so much in advance."
It would be best if you know why your tourist visa was rejected. But the reality is that when our tourist visa is rejected, we don't know. They don't always tell us. But if you know, you may be able to prepare accordingly. If you know that it was an overstay, or maybe because you have family here, or maybe you didn't have enough money in your bank account. Typically, the reasons a visa may be rejected are those. So if you know you don't have enough money in your bank account, you can go ready now to your interview for a student visa, knowing that you need to show you have enough assets, or you need to show that you have enough ties to your original home country, showing that you're not going to stay illegally in the U.S. Understand that those are the main things they're looking for. They want to know that you won't stay in the U.S. illegally, that you will not be working without permission, that you have enough money to support yourself, because the student visa is very limited and that it may not allow you to work. So if you go with those factors in mind, knowing I have enough money to support myself, I have enough ties to my country, my parents are still here, I'm leaving my car, I'm leaving my fully furnished apartment, I'm leaving all my friends and family, and emphasize that during your interview, you maybe have a successful interview, and distinguish that maybe when you had your tourist visa, you were younger, you didn't have that much money, you didn't have a stable job back then. How are you different now than you were back when you had your tourist visa? If you distinguish those two individuals, you may have a better shot during this new interview.
Thank you so much. Thank you so much, Isadora, for taking that up. And, I see more questions, so I don't want to leave them as well. So let's take this one. I would like to know if other people on F1 visa have traveled outside the US and re entered without any issues. I'm planning to travel to my home country for a month, and I'm unsure if I might face any problems when returning. My country is not in the list of banned or restricted countries.
So it depends. What we notice is some countries have complained on treatment. For example, Colombia has complained that they are treated differently coming back to the US. I recently had to travel for work to London, and didn't see any specific treatment, but it depends. What I have noticed is sudden news, like Nipasa was saying. The travel ban happened rather suddenly. Although we heard some rumors, we were surprised by some of the countries that were included. We were surprised by some of the countries that were not included. We were expecting countries like China to be included, and it was not mentioned. So my point is, you always have to be on the lookout. To answer your question is, if your country is not included in the travel ban, sadly, you still have to be very cautious on what is announced and follow U.S. news. If you have a visa and you're going to have to come back. Now we see that at least we'll have a cushion of a couple of days if there is an announcement of a potential travel ban, so to come back quickly if you have to come back for work. I do worry that things like tourism may be affected when you return, but I haven't seen, besides that, specific countries being targeted or treated differently upon their return. There are some countries that I would encourage people not to visit, even if they have a visa and they're not part of the travel ban. For example, any other countries in the travel ban, even if we have family or we want to visit, I would advise my clients and you guys not to go, at least not for now, until things settle down or we get better guidance as to what the courts may do. And when you're coming in, just follow the news. Sadly, we have to follow the news to make sure that the government's not taking any action on any place we may be returning. Besides that, so far the U.S. is good, but that's for the moment.
Thank you so much, Isadora, for taking that up as well. And I don't want to leave Girish or RK without answers, so let's quickly take them up. Girish, hi, thank you so much for joining us here on YouTube. And he's saying prior 5 months of H4 visa overstays and unauthorized work on H4 EAD. departed US, if employer apply for new H1 or I1 or L1 visa, sorry, will be approved. Any waiver are there?
So the 5 month overstay is not really that big of a problem because it's typically when you hit the 6 months that the 3 year ban kicks in. The problem is the unauthorized work. The unauthorized work, there's not really that much of a waiver because the waiver typically requires what we call a qualifying relative, which would be somebody in the U.S. that needs you. So that the unauthorized work is the biggest deal here, for particularly for the H1 visa, because the H1 visa it's more of an employee visa, so that may be difficult. The L1 visa might be a little bit easier to get because the L1 is more for the boss of the company, the leader of the company, or the employee who's very specialized. So there's more of a specific need. So if your employer can choose between the H visa and the L visa, I would encourage your employer to pick the L visa. As to the waiver itself, it's like when you break a vase, you don't go to your mom right away and you tell them, "Oh, I broke this." You wait for your mom to find out, and then you're like, "Oh," and then you say you're sorry. So I would apply for the L visa, and then when the government tells you no, you're not going to get it because of whatever reason, then you seek a waiver. That's how I encourage my clients to apply, because letting applying with a waiver ahead of time is like admitting, "Oh, I made this mistake." Be aware that the 5 months, like I said, typically wouldn't be an issue, although overstaying is never encouraged. Don't do it. But it wouldn't be an issue. It's more the unauthorized work. You have to be honest in the application, so please don't lie. But wait until they ask for the waiver. And once again, if you can choose, pick the L visa instead of the H visa, because the L visa is more likely to be better suited for you, that you can justify that you need this waiver, because typically waivers require that qualifying relative, which is very difficult to justify under an H visa if you don't have one. So go for the L and good luck. It's going to be tough, honestly.
Thank you so much for taking that up for Girish. Girish, I hope that you've got your answer, and if you have any more, keep commenting. Well, now we have RK. He's saying there's a talk of removing OPT. What is the chance of that happening, Isa?
It depends. I honestly think that it will be up to the schools to be very vocal and emphasize how OPT is needed. I I feel that talk about removing OPT has to do a little bit with the falling out between Trump and Elon Musk, because Elon Musk was very helpful in emphasizing how OPT was needed for students to practice what they have learned, and how we could keep in the US great talent by having OPT. So now I believe it's up to the schools to emphasize how OPT is great for the United States to keep that talent. So I'm hoping that schools, the same way Harvard was very vocal in letting the country know how international students are essential for the U.S. to remain as great as it wants to be, if we follow their narrative saying, by the way, it's not just when they're studying, it's also when they're practicing their trade. If we can follow their narrative, we can keep OPT. I would ask you selfishly if you can help us promote, spread the word. I don't think we see students and we don't realize that there is a time in which they're working and how essential they become for the economy, for what we do, and then we lose them and we only see when we lose them. So if we can help spread the word of how great they are when we have the students here so that we can keep them, maybe we can keep it. But right now, I am very worried that it could happen because the Secretary Rubio in the Department of State has been pushing for it. And I believe it's partly based on this falling out in relationships that has not been the best at spreading the word. So that's why I'm asking you to help me spread the word that we need international students, not just as students, but also as employees.
For sure, for sure. And we've always known America to be a land of immigrants where we are all living together, and working together. So
Yeah.
let's see what happens. But a lot is happening, friends, and to keep yourself updated is the key. So do not forget to, subscribe to our channel. And before we leave, Isadora, I would really ask, what's your guidance to students and families, currently who are stuck in limbo? So should they wait out or defer or look at alternative countries?
Well, for students, it depends where you are. For my clients who are stuck in limbo in the U.S. right now physically is not the best place to be stuck in limbo because of the high level of detentions that are happening. For example, when the visas were being revoked and we didn't know what was going to happen, I admit that I was encouraging my clients to go to Canada, to return home, and it's something that I never thought I would be fighting, but I was generally worried about the high level of detentions we were seeing. Also because the detentions were tied with transferring people and they were not humane conditions. So that's where if you people are in limbo in the US, I encourage them to leave. But if you're in limbo in other countries, I do encourage them to continue considering the US because I do think litigation is the only way we can stop this ongoing changes that are not really fair. For example, the OPT elimination is something that for students who already have their student visas, they were expecting to have that hands-on experience. It's part of the packet of going to school, paying for the tuition, and now the possibility that you may graduate and not be able to work at where you may have been applying, that should be frustrating. So I have encouraged those students to not give up and to consider litigating, and maybe consider fighting it, to not just be complacent, because I know that may be a limbo, but it's a limbo that I think we can fight legally without the fear of persecution or detention, which I think is the biggest concern right now. So it really does depend on the limbo. For my individuals who were part of the travel ban, I basically called everyone in the 12 countries, asked them to come back to the US, depending on the visa. If it was a tourist visa, I basically we're now litigating. We filed lawsuits against the government. I keep emphasizing how expensive the government is because the litigation and attorneys are. Because like Ricky asked when to get an attorney involved, when to have a G28 representation. Honestly, from the beginning, because what we've seen now is a perfect storm of people who maybe before during the prior administration filed using notarios, paralegals, maybe with the best intention, but now that things are a little bit more complicated, it's difficult to fight, or maybe because you didn't keep your DS 160. That's why I previously mentioned make sure everything is the same. The government's finding little loopholes to attack you more. So on complicated cases like EB1, like we were discussing before, it's good to have an attorney from the beginning. On simple matters, like personally, I find student visas to be best done by the school directly. Those are cases in which it's best to just simply have your documentation in order and choose to pick your battles and litigate them. That's why I give the example of OPT, in which being in limbo, depending on where you're located, if the limbo is simply not knowing whether you're going to continue or not, or if they're going to give you the visa or not, give you the program or not, it's good to litigate it. So it's good to look where you are, what options you have available, and see if you have that trusty attorney next to you that's willing to take the case to court. Because you could be the example that everyone looks up to if you keep the visa alive for everyone to enjoy. So think about it. I'm here to help.
For sure, Isa. I mean, that was wonderful. What a good thought, and thank you for sharing that with us as well. Folks out there, I'm sure you really resonated with this conversation we had, and you must be taking away good information with you and have learned quite something from this session we had today with attorney Isadora Velasquez. So do not forget to check her out as well. This link is displayed on the screen. You can check out her contact details if you need a one-on-one consultation as well with her. And also, thank you so much, each one of you, for joining us with your questions, for viewing. And if you have shared, thank you so much. And also, please feel free to keep sharing our content with your friends and folks who would benefit most. So, yes, our handle is at Immigration Talk Show. Subscribe now and ring that bell. So, thank you, Isa. It was really wonderful to have you here. I know if we especially talk about student visa, we can go on and on, but sometimes sticking to what we have thought we'll discuss. And I'm sure, if there'll be more updates, we would love to have you back to discuss further on this as well.
Whenever you want.
Thank
Happy to
you.
be
Thank you
here.
once again. Have a wonderful day.
You too.
Thank you, everyone, for joining us. And yes, if you do have more questions or want to reach out to me as well, I have a phone number. My number is 408 335 6444. That is also my WhatsApp number. So you can just send us your questions, and maybe that way I could also send it to Attorney Isadora. And you can also email me. My email is nipa@staffingme.com. And once again, please do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And stay tuned on Immigration Talk Show because we do have a lot more coming in that you don't want to miss out on. It's Nepasa saying bye for now. Hello, everyone, and welcome back to Immigration Talk Show. I'm Napasa, and I'm going to be your host for this session that's lined up for you. And before we head on with today's discussion and also have our guest join us for today's webinar, I have this very important disclaimer to read out. So, by watching our videos, you agree and understand that information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. I hope you keep that in mind, friends, throughout this whole session. And I would like to tell you that you can also be a part of this session by commenting wherever you're watching us and also by calling us on this line where you can dial in. And the number is 425 436 6335, and the access code is 988 888. Absolutely. As you can see, the topic of discussion on the screen already, we are going to discuss about what are the do's and don'ts for the H-1B cap. And it's going to be very interesting a session. And most of you may have questions. So please feel free to join us with your questions. You can comment your questions or call in to ask. And also, if you're being thoughtful enough, share this link with your friends where they can also join in, especially if this is something they could benefit with. So share it, friends, with your friends and family, and let's do this together. And absolutely, without any further ado, please help me welcome our guest for today, Attorney Prashanti Reddy from the Law Offices of Prashanti Reddy. Hi, Prashanti.
Hello, hi Nipasa, how are you?
I'm doing good, Prashanti. It's always good to have you, and welcome back.
Thank you.
So, friends, Attorney Prashanti Reddy has been practicing immigration law here in the US for almost 3 decades now. So, you should definitely go check her out. And if you need a one on one consultation, why not contact her as well? Her number is 212 354 1010, or you can email her at prashanti@readyesq.com, or go visit www.readyesq.com to get to know more about Attorney Prashanti Reddy. So, yes, since it is the cap season and this is a very, very important topic of discussion, many of you have questions, especially with all the updates and this and that every day. We have a new thing, especially with immigration thrown at us. So, Prashanti, what would you like to tell folks out there before we start today's session?
Um, yeah, it's really hard to keep up, as you said, because something new is happening every day and not in a good way. I wish it was. Um, but, and, we are getting blindsided and losing focus with reference to our regular immigration work with reference to H-1Bs, etc., because something or the other is coming up. But we have to keep in mind that there is regular work to be done, and we shouldn't lose sight of that. And it's business as usual for the H1s. So, a lot of people filed registrations this year. People thought that there'll be very few registrations filed, but that was not the case. It might be slightly lesser than last year, but it's not that much less. So there is still demand. Companies still need employees, and they have enough business to require new employees. Um, we also have to keep in mind that the deadline for filing your H-1B cap is fast approaching. So we decided to, go back on track and get back to our regular business of filing H-1Bs and other work visas for our clients as they need them. With the whole, student CVIS termination, things seem to have been resolved in a positive manner. We can get back to, as I said, our regular work. So we thought we'll talk about, the H-1B cap again and the do's and don'ts, so that we can help employers and employees navigate, their H-1B filings this year, which have to be filed before June 30th. So let's get right to it.
Absolutely, Prashanti. And June 30th may seem like a long time, and you may think that you have a lot of time in hand, but I think I would like to say, friends, that don't keep everything till the end. Work on it while you still have time, so that if there's anything more to work on, you'll have time later. So, yes, Prashanti, let's go ahead. So, if you could tell us, some of the most common mistakes that can lead to H-1B registration denial.
Registration denied. Oh, since we're already done with registrations, I think let's
Yeah.
talk about the actual cap, right, Nibasa?
Okay.
Um, so let's go to a question that addresses the H-1B petitions rather than registrations.
Okay. Sure, Prashanti. But would you like to tell any of the common mistakes that they should avoid, while they are in their petitions?
While filing a H-1B petition, you mean?
Yes. Is it allowed? Can you hear
Yeah,
me?
yeah, I can hear you. So, yeah, since the registrations are over and we don't have to worry about them until next year, let's talk about the actual filing of the H-1B petitions.
Hmm.
And your question was, what are the common mistakes to avoid
Some
while
some
filing?
common mistakes, right? Some common mistakes that can, lead to denial of the whole petition also.
Right. So, one of them that I can mention, and we can go over a whole laundry list of items, but one that comes to mind is not paying the correct fee. USCIS fee is very complicated, especially for H-1Bs, depending on the number of employees you have, depending on whether you are, um, a nonprofit, uh, or you are a for-profit organization.
Mhm.
The fees change, and there are many different kinds of fees, and all these different kinds of fees change. So it's very complicated to put it shortly. So it's important to know what the fees are. Number one, so contact your attorney to find out what the correct fee that you need to pay is, or at least do proper research to see what it is. And not only the fee changes depending on your number of employees that the company has, it also there are different fees, different kinds of fees applicable in different circumstances as well. So if it's an extension, it's a different fee. If it's a cap petition, it's a different fee. If you're over 25 employees, it's a different fee. Under 25 is a different fee. If you're a nonprofit organization, there's a different fee. So as you can see, and there are various different, there's an asylum fee, there is ACWIA fee, there is, a fee, the regular H-1B fee. So, it's just so complicated that sometimes even I get confused. So make sure you know what the different fees are and make sure which fee is applicable to you and how much you need to pay. The second, again related to fee itself, is write the check properly once you've determined what the fee is. Make sure you put in the right fee amount. If you're especially filing by mail, put in the right amount, sign the check, date it properly, put it in numbers, and so often cases get rejected. And we're talking here not about how to avoid an RFE, but how to avoid rejections from the mailroom itself. And this is one of the reasons for rejections. It doesn't even go to an officer if you don't put a proper check or the proper fees. Another reason why it would get rejected in the mailroom is if you don't send it to the right address. Sometimes they do forward it to the right address themselves, but oftentimes they will just send it back. Third reason, if you're not filling out uh, tick marking certain boxes, especially with reference to fees and cap exempt and start dates, then they will just send it back from the mailing room itself. Because you might have sent the correct fee, but you might have marked the wrong box, so they think that you sent the incorrect fee. So that's another reason. Third reason is if you have not signed the petition. Even if one place, there are several places where the I-129 petition has to be signed by the employer, and if you miss out signing even in one place, then they'll send the entire petition back. They will not send an RFE. So that's another common mistake. And remember, the address is very simple for CAP cases. You just have to follow your registration notice to find out what the address is. So these are some of the common mistakes that can lead to the petition coming back from the mailroom itself.
Thank you so much, Prashanti, for going through all of these very important points that we need to keep in mind so that we avoid, making it fall heavy on us. So, friends, I hope you're taking notes. And I would just like to greet our friends who already joined us. Hi, Rag. He says, good morning, Nipa and Prashanti. Well, good morning to you, Rag. On our end, it's already afternoon. So, good afternoon to folks. Good evening. Thank you so much, everyone, for joining us. And we're looking forward for you to participate also with your questions. And we have Seema Patel. Seema, stay with us. We will take up your questions. But for now, we will head on with some of the other questions which I have also for you, Prashanti. And if you could tell us, if it is allowed for the same person to be entered into the lottery by more than one employer.
Um, yes, you can be. And um, again, Nipasa, I don't want to talk about the lottery, so let's
Okay,
try to avoid the registration questions. But
sure.
yes, it is. It is. You are allowed. A beneficiary can file as many lottery petitions as they want, but a petitioner cannot file twice for the same beneficiary.
Okay, okay. So, all right, then let's go on with our next question, Prashanti. And this is if you could tell us if can an H-1B cap petition be filed for a future job position or should the job exist right now?
That's a good question. So, with reference to that, um, yes. Um, well, sorry, what was your question again? I was just sorry about that.
I was asking if, the question is, can an H-1B cap petition be filed for a future job position or should the job exist right now?
Okay, got it. So, with reference to filing any H-1B petition, whether it be cap or non-cap or a transfer or an extension or an amendment, you have to show that there's a bona fide job offer, and you have to show that the bona fide job offer exists as of the time of filing the H-1B petition. So, while the petition can start in the future, so all cap petitions can only start as of October 1st because that's when the new fiscal year starts. But you have to show that you have a job for the person as of the date of filing, even if it's a start date of October 1st. So, to give you an example, if you are a consulting company, you have to show that you have a purchase order or a work order or a contract from the client where the person is going to be placed, showing a start date of October. but the contract should have been signed as of the date that you're filing the petition. So you should already have work. You cannot tell USCIS that, I don't have a contract right now, but I will get a contract in October or November, or I will look for a contract once the person gets on my payroll. That's called speculative employment. So that's not allowed. So you have to show that you meet all the requirements, whether it be employment or the other requirements, uh, of the H-1B petition as of the date of filing the petition.
Okay. Thank you so much, Prashanti, for taking that up and for clearing some of the doubts maybe even our friends have out there. And hi, Jadav. Thank you for joining us with your question. We will take up your question very soon. And I also want to tell folks out there that if you haven't as yet subscribed to our channel, subscribe now. I hope you're not waiting too long or procrastinating. Subscribe now and ring that bell icon so that whenever we have discussions like these, you are notified and you can join us with your questions. Also, best thing is that you have this opportunity to take where you can call in and ask your questions to the attorney directly, and the number is 425-436-6335, and the access code, which you'll have to dial right after the number, is 988888. So join us. Okay, Prashanti, now I have this next question for you, and that is, well, now that the H-1B CAB registration is over, what are the next steps for employers and selected candidates, and how can they prepare strong petitions before the filing deadline?
Next steps for employers, if they've already been selected, is filing the H-1B petition, and ensuring that meet all the requirements, as I just said, towards, getting a H-1B petition approved. So, in order to prepare a strong petition, you have to meet all the basic requirements of a H-1. Um, and of course, as I said, you have to avoid the package coming back from the mailroom, and we already discussed in what instances it can come back. But with reference to the substantive requirements for a H-1B petition, you have to know what those are in order to prepare a strong petition. So first thing is that you have to have a job that is a specialty occupation, that is the job that requires a bachelor's in a specific field. And you have to be able to prove that your job requires a bachelor's in a specific field. And there are many ways of doing that. One of them is just going to the Department of Labor website, which is the Occupational Outlook Handbook. This is available online as well. And you can look at the various positions and that are listed in there and what the job requirements are for those positions. So that's, and then you have to make sure that, as the other half of the specialty occupation requirement, you have to make sure that the employee has the degree that's required for the position. So you have to show that the job requires a degree and that the employee actually is qualified for that particular position. So that's the specialty occupation part, which is an essential part of filing a H-1B. And with reference to the specialty occupation, make sure you uh, produce enough documentation to convince USCIS that it is a specialty occupation. So that's one way of making your petition strong. And that information is, giving a strong job description, giving a detailed, specific job description, showing that, the job is complex enough to require a bachelor's in, a specific field. For example, if you're doing a bachelor's as a software engineer, if you're doing a petition as a software engineer, you would put in a job requirement, a job description showing that the complexity of the job. You would say design, develop programs, that kind of thing. You would use the word design and develop. You would use the word analyze, anything to show that the job requirement is complex. You wouldn't use the word test or because testing is not considered to be, um, a high level requirement in the IT space. You wouldn't necessarily use the word program because programmers, again, don't require a bachelor's degree for a programmer, just a computer programmer. So you would avoid using those kind of words, and you would use design, develop, analyze, that kind of description when you're giving a job description. So a strong job description, a detailed job description with examples really helps your petition and helps to show that your position, requires a bachelor's degree in computer science. Just giving you that example of a software developer or software engineer. So that's, and you'd also make sure that, as I said, the job cannot be speculative. So one is specialty occupation, which we covered. The second part is speculative employment. So you have to make sure that the job is, you show that you have a requirement for the job, even if it's a future requirement. So in order to show that the job is not speculative, you would submit documentation such as a contract, a work order, an MSA, right? So that's the second part, showing that providing strong documentation to show that the job is not speculative. Third, documentation to show that you qualify for the job, for the specialty occupation job. So you would submit your degree copies, all your transcripts. Just a degree copy is not sufficient because it does not actually show what subjects you learned, and so the officer cannot see whether the subjects are related, the courses are related to the job description or not. So you would put in all your transcripts, you would put in your degree copies, you would put in an evaluation of your degrees if you have a foreign degree, because again, you don't want USCIS to speculate whether the foreign degree is equivalent to US degree or not. So that in order to avoid that, you would put in an evaluation from an accredited evaluation agency showing that your degree is actually equivalent to a US degree. And then if you're filing a change of status, even if it's a CAP petition, last but not the least, you have to show that you're maintaining status. And in order to show maintenance of status, you would put in documentation to show the status. If you're on F1, you would put in a letter from your school showing you're maintaining status. If you're on OPT, you would put in your EAD document and a letter from your employer where you're working on EAD, or you could be putting in pay stubs to show that you're actually gainfully employed on a STEM OPT if you're on STEM, because on STEM it cannot be work that is not paid. It can't be voluntary work. It has to be paid work. So you'd put in your pay stubs. If you're on CPT, you might want to put in documentation to show whether your college requires you to work while you're studying. Is it a work study kind of requirement? And you get credit for the work that you're doing. You put in that kind of information. So this is the kind of documentation that you can put in to show that, in order to prepare a strong petition to show that you qualify for the H1 and to avoid an RFE.
Okay. There you go. Thank you so much, Prashanti, for the detailed explanation, and I hope that folks out there were already taking notes. And I think we should take up a couple of questions also from the audience so that they don't feel like they're ignored too much. And folks, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Find us not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. Connect with us. So now I got this question from, let's take up Seema's question. The first question we have is, I've been hearing about people getting their H-1B petitions rejected because they didn't meet the cap requirements. How strict are these rules, and can anything be done if a petition is rejected due to missing the cap?
You cannot even file a petition if you have not registered and being selected in the cap. You cannot file a petition after the period that you're supposed to file. That is, you're given 90 days. So you have to file within 90 days, and there's nothing you can do really if you filed after, unless you're able to show that you filed on time, but for some reason USCIS lost your petition. Even though I have done that last year, and we filed a few petitions even after the deadline, and we filed them online and they were accepted, but they were actually filed on time initially, but there was some issue with the petition, and it came back, and therefore we were able to refile it. So sometimes USCIS might take that into consideration, the fact that you filed it and there was some issue with FedEx delivery, and for no fault of your own, it didn't get delivered on time, etc. So it's always worth a try. And I think that's what SEMA is asking, whether if you miss the date filing the cap and it gets rejected because of that, can you refile? Yes, I've done that, but you can't always depend on USCIS accepting those kind of petitions. Um, if they didn't meet the cap requirements, that really depends on what you mean that they didn't meet the cap requirements. If it gets denied after an RFE because the H1B requirements were not met, maybe you'll have a chance to respond before it gets denied because you will most probably get an RFE. Um, and then you can submit your explanation in an RFE or hopefully make amends when you're responding to the RFE. Of course, there are some things that you cannot make amends on, such as if you already have an LCA approved, and if the LCA was not filed correctly, you cannot file a new LCA at that point of time. But rejections also, SEMA, with reference to mailroom rejections, you can refile, resend the case if it gets rejected in the mailroom. But remember, this has to be sent out before the 90 days period that is given to you. If you get the package back for some reason after the 90 days period, then as I said, you can try sending it out, but you can't expect always to be successful in those cases. It really depends on a case by case basis.
Right, right. Thank you so much, Prashanti, for taking that up for Seema. And Seema, I hope you got your answers. If you have more clarifications to make, kindly keep commenting with your questions. So this next one is from Jadav, and he's saying, if I apply for an H1B under the cap and my employer gets audited, what should I be ready for in terms of paperwork and extra checks? Is that something I should be concerned about?
Yes, because if your employer gets audited, and these are called FDNS visits, and this is a good segue into a little bit some information on FDNS visits. So this is the fraud detection unit of the USCIS, and after cases get approved, they sometimes conduct audits, and they have in-person audits. So they come to the office, they might call the beneficiary to ask questions as to what kind of work you're doing, who you're working for, who the client is, what your work location is, and they might ask the same questions of the employer as well. So they want to make sure that you are maintaining your status as per the LC approved LCA. So they want to make sure that you are at the location as required by the LCA. You are getting paid the prevailing wage as required by the LCA. So they often do these checks after the fact, after the approval, to make sure that you're maintaining status, and you have to be aware of this, because if FDNS site visit doesn't go well, then they can ask USCIS to revoke the petition, and then you'll fall out of status. So it is important that you speak to your employer if an FDNS officer contacts you. Speak to an employer, be on the same page as your employer before you actually talk to the officer. Be aware, take a copy of the entire H1B petition, be aware of what was submitted, what your salary is, that you're getting that salary, what the work location is, maintaining everything as per the terms and conditions of the H1B petition. So, yes, it's important that you know what is in the petition and that you maintain it and you're
Very,
following everything as per the petition. Yeah.
yes, yes. Thank you, Prashanti. Thank you for taking that up and for the detailed explanation. It seems like every point is so important. I really hope that friends out there, you're not missing out on anything. But the best thing is that you can always go back and rewatch even after this live stream has ended, and that you can do by watching it in our space. Our handle is at Immigration Talk Show. Don't forget to subscribe to our channel. All right. So Rag, hi again. He has a question for us. So Rag is saying, can I manage my startup as a CEO on H4 no EAD if I'm not taking a salary?
I suggest you don't do that because on a H4, you're not supposed to be working, and managing your own company is working. So you should wait until you get your H4 EAD.
Okay. All the best, Rag, and I know you will get it. So go apply for it. Thank you, Prashanti. Now let's take up this next one. This is from Nirav. Hi, Nirav. Thank you for joining us here on YouTube. And Nirav is asking, how does the H1B cap lottery process impact the priority dates of petitions? Are there selected that are selected? Sorry. Let me take that again. How does the H1B cap lottery process impact the priority dates of petitions that are selected? And what are the implications for petitions that are not selected, particularly in terms of maintaining the beneficiary's immigration status and eligibility for future cap filings?
I don't understand what he means by Nirav means by priority dates, because the priority date is usually used for green card petitions, not used for H1Bs or for registrations. But trying to decipher what Nirav is asking, um, once your H1B lottery is selected, um, then you file for the petition, and uh, whoever files the petition first, it's first in, first out. So
Mhm.
people who file their petitions earlier will get approvals, or they will process their cases first. Um, for petitions that are not selected at all, then you can try in the next lottery, and you could be selected. It does not in any way impact, your next lottery, because the lottery system is a lottery. It's completely random. So it doesn't matter how many times in the past you have applied for the cap lottery.
Okay, that's interesting. Thank you so much, Prashanti, for taking that up. And thank you, Neera, for participating with your question. And
Also,
yeah.
to the beneficiary's immigration status, if you're not picked in the lottery, then your status remains whatever your status was. It's status quo, basically. You have to continue to remain in status. If you're not in the country, of course, then there's no question of status. If you get picked in the lottery and you file your H1B petition, then as of October 1, or whenever your H1 gets approved, then your status changes to a H1, whichever is later. So that's how it impacts your status.
Okay, thank you so much. And friends, don't forget that, this is your opportunity to join us with your questions. And you can do that by dialing this number 425-436-6335, and the access code is 988-888. Also, best thing is you can comment your questions and we will be happy to take them up. So just check us out, not just here on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. So yeah, now coming back, Prashanti, to few of our questions before we head on with the other questions from our audience in Facebook. Well, I have this next question, and that is: are there any restrictions on changing employers after being selected in the H1B cap?
Yes, that's also a good question, actually, because a lot of people ask me that question. They file for registration through some employer, and that employer doesn't want to file a H1B petition, and they think that they can now file a H1B petition since they're selected in the lottery through another employer. So that's not possible. The lottery and the selection is tied to the employer that did the registration. So if the registration gets selected, then the employer that's filed the petition, filed the registration, must file the petition. Of course, once the petition is filed and approved and you started working, you can always file for a transfer of the H1 from that employer to another employer. So if you do want to move employers, that's the way to do it. But you cannot do it before, you know, before you start working for the original employer.
Okay. Yes, many people actually ask this, and sometimes it's like they want to change from employer A to employer B or to employer C, and it becomes difficult, I think, right, Prashanti? And they're not allowed to do so.
Correct. Yeah, because the registration, as I said, is tied to the employer. So unfortunately, if the employer is not willing to file a H1, and that's completely possible nowadays, because they do the registration in anticipation that there will be work available, because they don't have to show necessarily that work availability at the time of registration. And then they are not able to file the H1B petition because they're not able to find work,
Mhm.
because something has changed, because the market has changed. And we see a lot of registrations are wasted because of that. And that's the reason USCIS sometimes conducts a second lottery, because even though they're selecting more people than they should, even in the first lottery, they're selecting about 100,000 or 120,000 when we only have 85,000 slots. They're accounting for that, but their accounting falls short because many more people don't file, and they sometimes that's why I have a second lottery.
Right. You think it's going to happen this time as well?
We have to wait and see. Even if there is a second lottery, it's not going to be big numbers. It'll just be a few
For a
cases.
smaller number of people. Let's see. Let's see, friends. We don't know what's going to happen, so we'll just have to wait and watch about the second lottery. But now let's concentrate on folks who got selected in this lottery and who are planning their next steps or are already on it. So, yeah, now next question for you, Prashanti, is if you can tell us, are there any restrictions on changing? Oh, sorry, we took this. So, is it okay for a candidate to work on CPT or OPT while waiting for H-1B approval?
That's also a very good question because I've been receiving that, a lot of people asking me that question. A lot of people think that once they get selected in the registration, that they should work for the that company who filed their registration, and filed their H1 maybe, even before the October 1st or before the H1 gets approved. They should be working with them on CPT and OPT. It's not necessary that you should be working for them. You could be working for another employer and start working for this employer once the H1 gets approved after October 1st. So you could be working for a completely different employer on CPT and OPT. But your question was more, do we have to work on CPT and OPT once it gets selected? Yes, you have to continue maintaining your status until you change status, until your change of status gets approved. You have to continue maintaining your status on F1. And if that means that you're working on OPT, then you have to continue maintaining your status on OPT. And if that means having to work because STEM OPT requires you to uh, you know uh, work for money, then you have to continue doing that in order for your H1 change of status to get approved. Otherwise they'll say that you're not on valid F1 status and they will only approve your H for consular processing.
Right, right. Thank you, Prashanti, for taking this up as well and for the detailed explanation. Now let's go on to our next question, and that is, what happens if an H-1B petition is selected but later withdrawn by the employer? Can the candidate reapply? Like you already touched on it just now a bit, but can they reapply?
If the registration is selected but then withdrawn, is that what they said?
If the H-1B petition is selected but later withdrawn by the employer?
Ah, well, depends. If is it withdrawn before the H1 gets approved, then you're not considered to be cap exempt. You'll have to file again for registration next year. But if it was withdrawn after you start working for them, then you will still be considered to be cap exempt. And then you can file your H1 using that 60 days grace period, uh, you know, and find another job within the 60 days. Or if you already have another job, just file for a transfer.
Okay.
And it is cap exempt. So.
Yeah. Well, thank you again, Prashanti, for taking this up. And folks, if you're resonating with Attorney Prashanti Reddy, her, taking up each of our questions and patiently answering them so well, why don't you give her a call, or maybe you can choose, for your case as well. So her number is where you can reach out to Attorney Prashanti Reddy, 212-354-1010, or go email her at prashanti@reddyesq.com, or yes, go check her out at www.reddyesq.com. And also, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. If you haven't as yet subscribed, what are you waiting for? Subscribe now, friends, and share this with your friends and family who could benefit a lot with all the latest information we have on US immigration. So, yeah. Now let's take up some more of our questions from our audience in Facebook. So, Control, if you can please display some of them, please. Let's go on with them. So we got this first question from an anonymous participant. When you file for I 130, you choose the service center. Do we have the choice? Please help. Thanks.
It's can you choose the service center? No, you cannot choose the service center when you file an I-130. You have to. There is a list of service centers that I-130 goes to, based on where your if you're the petitioner, wherever you're living. Uh, Based on the state that you're living, you file it at that service center.
Okay. Thank you, Prashanti, for taking that up. Let's go on to this next one, which says after approval of EAD I 765 and I 485, what is it? What is next? Does I 485 go with insurance of green card? And does the I 130 and when does the I 130 get approved?
Does I-485 go with issuance of green card, and when does I-130 get approved? Um, yeah, but so usually I-130 will get approved before the 485 gets approved, or both will get approved together. And after the 485 gets approved, then there's an issuance of the green card, because that's when they get the card in the mail. So first you'll most probably get an I-130 approved. First you might get a 765 approved, which is your employment authorization, because that's given as an interim benefit while the petition is pending. Then you might get an I-130 approved, and then the 485 might get approved, or the I-130 and 485 could get approved together. And once the 485 is approved, you'll get an I-797 approval notice, and then you will get the green card, the actual card, in the mail. It'll be mailed to you.
Okay. That's nice. Thank you so much, Prashanti, for taking that up. And now let's go on to this next one, which says, hello, my husband and I are in the middle of process of marriage green card. He is in Mexico. I'm in US citizen. I am the US citizen, and our I-130 got approved, and we are waiting on information from NBC. My question is, as a US citizen, does it affect anything if I decide to get Medicaid? Medical in my case.
I don't know what Medi-Cal is, but Medicaid. So it doesn't matter that you're getting Medicaid, as long as the applicant, the beneficiary, has. Even it may not matter even if the beneficiary doesn't gets Medicaid. But what is important is that the beneficiary should not be considered to be a public charge. The beneficiary would be considered to be a public charge if you know they've as per at least the present definition of a public charge, and that keeps changing again, and it might change again under the Trump administration, because under his previous term they had expanded the meaning of public charge. But presently, public charge means a person who has received actual money for sustenance, and a person who has received long term, um, has been admitted long term into a rehab kind of facility at the government's expense. So those are the
Okay.
two uh, factors which will disqualify you from getting a green card based on the public charge rule. Um, Also, you as the petitioner will have to have we sponsor them and fill out an I-864, which is the affidavit of support, which means that you have to have enough income to be able to sponsor them, depending on your family size, $25,000 or more. So if you're on Medicaid, does that mean that you don't have sufficient income? Uh, so I'm not sure what it is, but you have to be, if you're not able to sponsor them because you don't have sufficient income, then you might, or you're retired, you might, you have to get another sponsor, then an additional sponsor, a joint sponsor, who will fill out again the affidavit of support and submit their tax return. So as you see,
Okay.
there's many nuances to it. It's not just, uh,
Yes.
they might be, I've answered questions that you might not have asked also, because you may not have known to ask them.
Yes, yes. And actually, they've just put up a situation about themselves. So, of course, and I do not know what is Medical. So, thank you so much, Prashanti, for taking that up. And, I hope that this was sufficient and a good answer for anonymous participant from our Facebook group. Thank you so much. So let's go on to this next one. This is also from an anonymous participant asking, "Hi, I petitioned for my mom's green card in June 2024. She was interviewed 4 weeks ago at Santa Ana office. I-130 was approved the next day, but I-485 is still pending after 4 weeks. Is this normal nowadays?"
Well, a 485 can take a while. It takes 12 to 18 months for a 485 to get approved. So that's how you have to count the processing time. Not from the date of the interview. The interview can take place anytime in between. It's not necessary that the interview will take place at the fag end uh, of the case and then it'll get approved immediately after. So processing time varies. So I would just look at the overall processing time and see whether you're within the normal time or not. So if you've applied in 2024 June, it's still not even a year. I wouldn't worry.
Okay. Well, thank you so much, Prashanti, for taking this up. And now let's go on to this next one saying, "Hello, I'm looking for an immigration attorney. My husband and I have been married 5 years and we have a house and children. We have filed I-130 and it is being reviewed. However, my husband's I-485 was declined due to not sending the correct documentation. I sent 2022 W-2 and not 2023. We have to appeal with an I 29 209B. They are revoking his EAD to work. Has anyone gone through this? And do you have any recommendations? Do you have lawyers or attorneys that can help ASAP? Absolutely, yes. We have Attorney Prashanti Reddy here. And Attorney Prashanti Reddy, what would you like to say to this?
Definitely, you can call me up and I can give you a free consult, and then we can decide, um, how we can take the next steps. And this is an example of why you shouldn't be filing the petition yourself, because this could be an easy fix and you didn't have to get a denial. It's possible that you can also maybe consider refiling your petition or filing an appeal. You could do either one, and we can look into it and once we know more about your case. Yes, unfortunately, the EAD will no longer be valid because the 485 has been denied.
Mhm.
Remember, when you choose between filing an appeal, refiling a case, there are many considerations. So you have to do what is right in your situation. In some situations, it's just easier to refile. In some situations, you cannot refile because maybe the person is out of status and if they're not married to a US citizen. In some instances, it's important to get EAD, so they might want to refile so that they get the EAD again, because a motion to reopen can sometimes take a while. So these are the things to consider when deciding, and also it depends on why it was denied and whether USCIS is likely to approve the case on appeal or it's a better idea to refile the case entirely. So these are the considerations that we have to discuss before we decide which approach to take.
Right, right. Thank you so much, Attorney Prashanti Reddy. And well, anonymous participant, if you're watching us right now, you can get in touch with Attorney Prashanti Reddy on her number 212-354-1010. And her email address is prashanti at reddyesq.com. And when you do contact her, don't forget to let her know that you got the contact or you watched her here at Immigration Talk Show. So thank you so much, Prashanti, for taking this up as well. And I do have a couple more questions if you have a little more time, maybe.
Sure.
So, Prashanti, this next question that I have for you is if you can also tell us, what happens if an H-1B petition is selected? I think we've taken this. So, this
Yeah,
next
we
one.
take.
Yeah. How can an employer prove the job, a specialty occupation to meet H-1B eligibility?
How can the employer prove that the job is a specialty occupation to meet the H-1B? I think we kind of discussed this a little bit
We did.
um, with reference to specialty occupation, but very briefly, you have to show that the position requires a bachelor's degree in a specific field. And how you show that is you can show that it's common in the industry to require a bachelor's degree in a specific major. How do you show it's common? You can print out DICE and Monster job site listings, and you can print out several to show that, look, this is a position, and all these positions require a bachelor's degree in that field. You can also go with the employer's uh, previous practices. So if they've hired a person with a bachelor's degree in a specific field previously for that particular job, you can show proof of that. You can also go to websites like the Occupational Outlook Handbook, which lists positions and basically talks about what the common requirements are for that position. So these are three ways where you can show that the job is a specialty occupation. If you're not able to show any of this, because maybe the industry generally doesn't require a bachelor's degree, but you require because for some special reasons, then you have to show the complexity of the job and why you require a bachelor's degree and how your job is different from other jobs, and and it's why your job is more complex when compared to other jobs, and therefore you might require a bachelor's degree in that particular field.
Okay. Okay. Thank you, Prashanti, for taking that up. And well, before we go, if you could also tell us about what should employers avoid when offering remote or hybrid work in an H-1B cap petition?
It's perfectly okay to provide remote work or hybrid work. You should put all the work locations in the LCA, so please make sure you do. Please make sure you pay the salary that is the highest among all the locations. That's a requirement. Also, what you have to make sure of is that you keep track of your employer. So if they're moving houses, they might move without telling you, and then you would not have filed an amended petition because the work location has changed. Most probably, salary has changed. Then they fall out of status. So please inform your um, employees that they need to let you know, and you need to file an amended petition before they change their home location if they're working out of home. You also have to be aware that if it's a home location, that the offices can come and visit your home. And you have an LCA posting requirement at the work location. So if that's your home, you have to post it on your fridge or wherever it is that everyone can see. I know it sounds ridiculous, but that's a requirement. And you have to be ready to welcome the officer into your home, show them your workspace, and answer any questions that you have if there is an FDNS visit.
It's very interesting. And thank you so much, Prashanti, for taking that up. Absolutely important. I hope that friends, you are, taking notes and are able to follow what we have been discussing. And thank you so much, Prashanti, for taking that up as well, very patiently answering each of our questions. So I think with that, we have definitely covered almost all. But still, if we have anything left, Prashanti, maybe you would like to give an end note before we leave.
Um, File your H-1B petitions carefully. Use an attorney or an expert to file them. You have won a lottery, and it is really a lottery in the true sense because it's difficult to get through. So don't waste that opportunity. Make sure you file your petition correctly and in a timely manner.
Sure, absolutely. Very, very nice of you to say that and remind friends out there. So thank you so much, Prashanti. It was great having you with us today. And I hope to see you soon again.
See you again next week. Thank you, Nipasa.
See you, Prashanti. Thank you. Have a great day. And folks out there, you can also contact Attorney Prashanti Reddy. And in case you especially want a one on one discussion, every case is different. So why not give her a call? Her number is 212-354-1010. And you can also email Attorney Prashanti Reddy at prashanti@reddyesq.com. And when you do, please do not forget to mention that you watched her here on Immigration Talk Show here on our channel, and she'll be happy to assist you. And well, that said, you can also subscribe to our channel. Don't forget to do that. Our handle is at Immigration Talk Show. You can find us not just here on YouTube, but also on LinkedIn, Facebook, X, on Instagram. Connect with us, stay connected with us. And yes, this is it for now. You can also contact me, by the way, in case you have any questions, which we will be happy to address, with an attorney. And my number is 408 335 6444. You can call me. You can also WhatsApp me. That's my WhatsApp number. And yeah, you can also email me at nipa@staffingly.com. So this is it for now. But don't go anywhere. Keep watching Immigration Talk Show because there's a lot more coming here. And there's so much good and latest information on US immigration that you really do not want to miss out on. So keep watching and bye for now.
Hey everyone, welcome back to Immigration Talk Show. I'm your host Sam, and we are live right now at 2 p.m. EDT on YouTube. And I'm so happy to have you all here, and thank you so much, guys, for joining us on this platform as we are back again with another very exciting and very insightful session. And before diving in, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information shared by our experts and attorneys, including comments and replies from users, is not a legal advice. So, use of information at your own risk. All right, once again, friends, welcome back everyone to Immigration Talk Show. I'm your host, Sam. And so happy to have you all here. And also, we are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. So, do follow us on these many platforms. And if you haven't subscribed to our channel yet, then do it right now because we come up with latest updates and also some amazing webinars. And similarly, we do have this webinar today on the topic H1B visa myths versus reality. What is the truth? That sounds super interesting. Also, with the guest whom we are going to have this session, is also very, I would say, energetic and very much bold in her statements. So I'm really happy to have her here again, and let me welcome attorney Nandini Nair, who is a partner at AY Strauss and leads the immigration practice with over 25 years of unmatched expertise. And her insights have been featured in the New York Times, CNN, Bloomberg, and more. And she has been recognized as a trailblazer in the legal field. So, hi Nandini, and thank you so much for being here with us. It's really our honor to have a show with you.
Thank you so much, Sam. I really appreciate asking me back. I'm glad the last time went well, and I'm happy to be here.
That's great. And in fact, we all are so happy and excited for the show. And this is the second time that we are meeting. So thank you so much again for joining us. And I'm sure our viewers are excited for this session because, Nandini, whenever we talk about myths and facts, we have multiple questions. I mean, there's no limit to it. So many myths we didn't even, understand, like, oh, are these myths? So it's like going to be really exciting. And before diving into the topic, if you could please give us a brief what our viewers can expect from today's webinar.
I think the big overall thing today is to break down what is actually the reality, right? I know that there's a lot of forums out there, WhatsApp groups, Telegram, where a lot of information gets jumbled and it's very wrong, inaccurate, misinterpreted, and it really creates a lot of turmoil and probably issues for individuals. So the goal today, let's break down some of the myths. Let's break down and show you what actually is the reality. Is there possibilities? Is there none? So that you have an accurate picture of what isn't there in store for you tomorrow. So that's the goal of today's show.
That's right. I think it's really going to be very insightful as you are going to separate facts from fiction. And this is what we all need. So I think without any further ado, Nandini, let's go ahead with my very first question. And this is a very important one because you have so many years of practice and you have been with so many people around there. So according to you, which is one of the biggest myth about the H-1B visa that you come across often in your practice?
One of the biggest myths I would say is, outside of people who use the program or understand the program. So a lot of people think the H-1B program is used by companies to bring in cheap labor, right? Foreign labor, right? They're underpaid, they're working, 60-hour weeks, all of these type of things. That's the common mentality, scenario, perspective of individuals who are not in immigration, who don't, use foreign talent. So, and again, that's an absolute myth. So we're talking reality. Majority of professions in the H-1B program are actually paid incredibly high compared to an average US worker. Now, if you go to San Francisco and you look for a job as a software engineer, for example, you are making over $100,000, maybe $150,000. I mean, at a base level, that's what an entry level H-1B person can work at. It has to work at. So how is that cheap labor? Cheap labor, I would say, is somebody making less than $60,000. That's cheap labor. So there is an absolute myth across the country, that this program just brings in these individuals and they're being paid, $10 an hour, and it's not regulated. There's not compliance, and it's a complete abuse going on. And that is actually false. Now, I'm not here to say that there isn't abuse in the program. Every program you name out there, whether it's Medicare, whether it's, the education, anything, there's going to be a small element of fraud in it or misrepresentations. And the H-1B program is no, better than that. But the thing is that there are so many legitimate people. There's so many legitimate employers. There's so much that is right with the program that people just don't understand. They just fall for that myth. This is cheap foreign labor, and that we should eliminate this program because of that. That's the number one myth I hear all the time.
Wow. Thank you so much, Nandini, for putting that up. And I think it was very important. Of course, cheap labor, we all have that thing in our mind. And most of the time, when we also hear from most of the workers themselves, then they also put up these point of views. Of course, different people have their own opinions, but it creates a lot of confusion with that. And of course, you mentioned it clearly, it's nothing about that.
Mhm.
So that's really good, and thank you so much for just clearing up that very important confusion. Okay, so let's move ahead with the next very important question, and that is about green card.
Mhm.
So, Nandini, many believe that the H1B path is directly connected to green card. If you're going to get H1B, you are going to get your green card. So, is it true, and how accurate is that assumption?
Well, if there was such thing as a guarantee in life, I would be a millionaire. There is no such thing as this. Okay. No, you cannot. It just because you come here on an H1 does not guarantee any sort of pathway to a green card. Because you know why? It's not in your control. It's up to an employer to file for you. And even along the way, there's so many steps involved. It could get denied. The employer can withdraw it at some point. You may move to another job. There's just different things that can stop and put hurdles up where there is no green card at the end of the day for you. Now, the good thing about it is, yes, is there a pathway? Absolutely. There is a path once you come here. If you have an employer who's willing to do that for you, they follow the correct steps, they have a good attorney on their, helping them through this process. Yes, there is a pathway to the green card. But is it guaranteed? Absolutely not. Immigration is not something that is a guarantee in life at all. It is something that has to be evaluated, looked at based on the current law, not what was happening 20 years ago, right? So it's an evolving and fluid situation always. So don't fall for that. Oh, come here on an H, I'm going to get my green card. That's not true. That's absolutely a myth.
That's right. Because so many people think that if they are going to get H1B, automatically they are going to be a green card, get the green card. But absolutely, there's no guarantee. And if there will be guarantee, then everybody will be a millionaire. But that
Yeah. I would I would not I would be living like a different life if I could get you. If I said to someone, I can guarantee you that green card, yeah, that would be a different life whatsoever. But no, it's not true. The best part is, like I said,
Mhm.
there is a path, and you have to get onto that path, but there's no guarantee at the end of the day. So, but at least we have an avenue for you.
Absolutely, and that's very well put up. All right, so let's move ahead with the next question, or I would say next myth. As Nandini, there's a lot
Mm.
of talk that H1B visa holders are underpaid as compared to the US workers.
Mm.
And this is not only, we have been hearing like from past 1 year, from past 2 years. I would say from the time, people are crazy about for the H1B. So it's been a very
Mhm.
long time that people are been complaining, I would say, or been saying that they are paying less as compared to the US workers. So what's your call on that? If you could please
Right.
let us know the reality.
I mean, I don't think that's the reality. I think that, we have a wage scale that's mandatory for the H-1B program. It's not that an employer can just pick out a salary and pay the worker that way. No, there are things that are in place by the US government, and not by the employer, by the US government, who've done these surveys, and they say, hey, you need to pay at this level, you need to pay this
Mhm.
minimum salary. Now, sometimes those salaries, I will say, are not moving up to inflation and certain standard of living. But regardless, I don't think it is underpaid compared to U.S. workers. For your viewers to understand that wage levels, where it comes from, the Department of Labor, which runs the labor of us, as employees in the United States, they do surveys every year through sampling of companies. So it's not like the Indian company or the Chinese company is the ones who are providing this data. No, they do their own data survey. And that's where they come up with an average estimation of where the salaries should be for this profession in this county. So there's actually metrics and there's actually data behind that wage that you're seeing on that website. So it's not arbitrary, it's not randomly selected, it's none of those type of things. And when you do a comparison of that salary to a US job, you are going to see it's not equal, it might be slightly better. Are there areas and professions that are going to be a little bit less? But that's data. The Department of Labor said, hey,
Yeah.
that job is not as you're paying this way. So I don't like that talk that H-1B workers are underpaid. I think there is metrics involved, and there's boundaries and guidelines and guardrails available. Does it move up based on inflation? Maybe not. And that's what I would give to a foreign worker who's here complaining about the job, or complaining about wages not going up enough. Maybe there's some truth behind that, but it's not like the program is looking to do.
Wow, that's great. And I think most importantly, it's about the earnings, that is why the H-1B workers go to the US. And when they says about these things, it really stops the other people also to move to the US, and it like demotivates them
Hmm.
because they are not ready for these things. But Nandini, I mean, why these confusions are happening? I mean, what do you think? What can be the cause? Why these so many myths are rising for the H-1B?
I think we have a really big population of H-1B workers now. I've been practicing 25 years. When I first started, this was not a known program like that. I think Y2K, the tech booms and all have created an influx of people. So when you have an influx of people,
Yeah.
they're going to talk, right? And they're going to have a friend of a friend of a friend who had one bad experience. And that seems to set some sort of story or rumor out there in all of these, forums and stuff. Oh, well, this is what's going on. I think I said in the previous show, I joined some of these forums, right, as like a bystander to see what's going on, what's the talk and stuff. And I'm amazed by the misinformation that keeps spreading. And I think that's what's going on, that why people are holding on to these myths and these stories and these rumors, because it's just going like wildfire in a lot of these WhatsApp groups and telegrams and stuff like that. It's one person's experience, two persons experience, 10 persons experience. It does not define the program and define everyone in that who's on an H-1B. That part is not being looked at more carefully. It it's kind of like you want to believe the bad, but what about the good?
That's right. So, what message would you like to share with our viewers who are planning to go with the H-1B, or who are experiencing H-1B, like how they can be careful regarding myths versus reality?
I think talk to an obviously lawyer. Like, one of the things that people don't realize is there are a lot of lawyers who will do free consultations, or they'll do a consultation for $100, $150. And I always tell people, go get that opinion. If you're worried or concerned, you don't know for sure, do the consultation. It doesn't hurt you at all to spend half an hour with an experienced lawyer who corrects you. Wouldn't you go do that with a doctor? If you don't feel well, right? You're going to a doctor. And if you get a bad diagnosis, aren't you going to a second opinion? Of course you are. So do the same. This is your life. This is your status. This is your everything. Why not get the correct information? Don't fall for those forums. Go to the source. Ask the questions you want to ask and go.
That's perfectly explained. And I think, Nandini, the way you are saying, it really feels so motivating. I mean, you just look into the eyes and you go on and speak. It feels so good. So I'm sure our viewers are not just, getting the information, but they are also getting that motivation that from now on, they are not just going to sit and listen, but they are also going to stand up and take the actions. Because, creating these confusions are really destroying everything. So these
Yeah,
sessions are really important. And thank you again for your time and for your support that you're here. And with that, I
I
would say,
appreciate
friends,
that.
yeah, yeah.
Yeah, I would tell your viewers, like, the one of the most important things to me is putting out correct information to individuals. I'm very straightforward. I don't want someone's life ruined because I said something wrong. So I'm very strong about these type of things and stuff. So and I care. I really deeply care about their lives and stuff like that. So for my clients, I want them to do well. So they do well, I do well. You know. I don't
That's
want to go home and sleep and be like, oh man, I messed up that case or something. I don't want to do that. That's somebody's life in their hand. In my hands. So that's kind of how I think.
wow. That's great. And I think that's how everyone should be. And that too, when you are actually, I mean, somebody is relying on you. So I think that's great. And thank you so much, for putting up these very important information. And friends, till the time, we have covered few questions. We also have time, and we have 45 minutes another. So go ahead and put as many questions as possible, because this is the time you can get directly in touch with attorney Nandini Nair, and you'll also get the contact details. That is the best part of our session. That you can see the contact details on your screen, 973-287-0966, or else you can also go ahead and share your case or any doubts that you're having through email. Her email ID is nnair@avstrauss.com, and the website is www.aystrauss.com. So, with that, friends, also don't forget to like, share, and subscribe to Immigration Talk Show, as this is not just the amazing webinar we are having right now, there are more to go. So, to keep you updated with those amazing webinars, make sure to like, share, and subscribe to Immigration Talk Show. All right, Nandini, so I'm loving the conversation, and let's go ahead with another one. There's also a common perception that H-1B workers are tied to single employer and have very limited job mobility. So what's the reality behind it? What options are actually available to them?
I think I'm going to say it's dual thing, a myth and a reality. Okay, why is it a myth? Myth is no, you're not tied actually to um, one employer. You can move. If you're on an H-1B, it's portable, so you can move from A to B to C to D. Whatever opportunities are in front of you, you can absolutely do that. Of course, the challenge is every time you move, that new employer needs to go through the whole process, right, of the H-1B. And where is this the reality that hits a little bit? Because you have to refile, there's always that doubt of whether I'm going to get approved if I file that transfer, right? There's a risk. I'm not going to take that away from anyone to say, it's not a big deal, or no, it's a risk, right? Because that petition can get denied, right? So
Yeah.
even though you might have moved A, B, C, and then D gets denied, that's an impact. So there is this nervousness in the foreign national employee population where they're scared to move because, hey, I have approval now. I have 3 years on this. I don't want to move because, what happens if I get denied? And especially, now we're in a difficult time in immigration, people would be more nervous about moving. So the myth is, I can't move. No, the reality is you can move. You can file. You can move from A to B to C to D, whatever times, how many times. There's no limitation. There's no waiting period. You can do it. The reality is every time you move, you got to refile from scratch. So there's a risk of denial, risk of, some other issue going on every time you do that. So it can kind of create that doubt, and almost like a feeling of like I'm stuck because I'm so scared I don't want to make that attempt. But there are ways around it. And I always tell people, like, don't join the second employer. Like, you want to join until the case is approved. Don't be like moving on top of because you got a receipt notice. Try to premium process the case. So there's ways and strategies to minimize the risk and get it down to as low as possible. But that is where the strategy has to come in from your lawyer to understand how the process works.
That's right. That's wonderfully explained. And thank you so much, Nandini, for clearing up this factor, because, so many employers are also there who gets like confusion on this topic as well. So I hope that our friends are understanding this thing, and you can move, but of course you have to start from scratch. So keep those pointers in mind, don't get confused, and have a proper clear picture in your mind so that it will be easier for you to have your immigration journey in a smooth and relaxed manner. Okay, so Nandini, as you mentioned about premium processing, also, my next question will be that we have heard about premium processing, right? So, is it something to do with the chances of the approval for the H-1B visa holders?
Okay, I know there's a big myth out there, and it's actually a dual myth. One myth is that if you file in premium, your case is more likely to approve. The other myth is that you file in premium, your case is most likely to be RFE'd, because that clock is ticking on the officer. And both are false. In my practice, I have seen none of that to be true, meaning that I have filed cases in premium and things I thought would should got an RFE, never got an RFE. Things that I thought were straightforward cases, getting RFEs. It's a very random thing. What is premium processing to your viewers? It's not for them to look at it and, make a judgment call or anything. It's to act upon the application. Yes, the officer's on a clock, right? That 15 days, tick, 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 is going on in the background. And maybe, the myth is they just issuing the RFE because they don't want to look at the case, or they're issuing the approval because they just want to get this off of their desk. Those are all, I think, personally myths. But, do I like premium processing? 100%. Do I like the $2,800 that I have to pay? Not a chance. That's ridiculous for them to do their work. But, it is something that's available. Here's the biggest benefit of premium for your viewers
That's right.
is that you get to talk or maybe email the officer. So there's the ability to make a little bit more contact with your case and on your case if you use premium processing. That is the biggest benefit. Otherwise, when you file in regular, and your viewers will see this, you got to call that 1-800 number or you got to put the online inquiry. You're not hearing back from anybody. I don't even think there's a live person there sometimes. I don't know where it's going to. So the benefit of premium is not about the approval or the denial, more that communication is available directly sometimes with the officer. And that is a critical thing in your application.
That's right. Absolutely. I think thank you so much, Nandini, for clearing up that because whenever we think about premium processing, spending more money, so we obviously think that now we spend more money, so we'll get more benefits. Benefits, as in our chances of getting our visa approved, is becoming more and more. But that doesn't happen. It's all about the process that becomes faster.
That's right.
So that's great. That's wonderfully explained. And with that, let me go ahead with my next question. And this is something for the entrepreneurs mainly. So, is that H-1B visa holders can't start their own businesses? How much truth is there to this?
Okay, this is a more nuanced question. So the legal answer is yes, an H-1B can start their own business. Okay. But the reality of it is different. The reality is that when you start your own business, you are not going to be able to start it and just be the own person in it, meaning that you have to be able to show your separation from the company. Okay, that the company stands on its own and you are a worker but even though you're an owner. So how do you do that? The company has to have a board of directors. There's got to be other people who are able to control your decision making about the business. You cannot be the sole decision maker. So a lot of people are like, oh, you can just start your company. I'm just going to go incorporate. I'm going to work out of my basement. It's going to be in my wife's name, all of these type of things. And they think that is okay. No, that is not okay. That means you are working without authorization. If you're going to do something like this and you're going to get sponsored by that company and you're owning that company, you have to do it properly. You have to have that board of directors. You have to have a hierarchy. You have to have people who are able to override your decision, things like that. So to show what's called the employer-employee relationship. The employer is the business. You are still an employee, even though you have percentage ownership of that company. So it has to be looked at very, very carefully.
That's right. That's absolutely right. And I think that was very important because so many, our friends only, our viewers only, when they go for H-1B, one thing is for sure that they ask regarding business also.
Mhm.
So I think this is what the answer is. And let's go ahead with my next question. And this is something about like, is it true, Nandini, that the H-1B holders have no right if they are fired or laid off? Because currently, also, like few days back, also, we have been hearing in Silicon Valley, so many H-1B visa holders have been laid off.
Yeah.
So I think it is a very timely question. So please go ahead and let us know about the reality.
Okay. So the reality is that, you're here in the US based on work, right? That was on a work permit, you were sponsored by an employer. Like
Mhm.
that's how you came here. So when that employer does lay you off or fire you for whatever reasons, um, there is an issue here for you because the reason you're here is because of them. So, but what are your options? Okay, if that happens to you. Well, luckily, about, I want to say 6 to 7 years ago, we got a new law that says that you can have a 60-day grace period if you are terminated or laid off, as long as you have still 60 days left on your I-94, then you can stay in the country. You can't work, but you can stay in the country. And that gives you an opportunity to find another employer, change your status, or wrap up your life and go and depart, the US and stuff. Those were not available, guys, to your viewers for like until 6 years ago. So if you got laid off 6 years ago, you're done. There's no, options here. Um, the other thing that H-1B holders really need to be aware of is if you get laid off or fired, you are entitled to return transportation back home. What does that mean? So when they lay you off, let's say they have to give you money or buy your one-way ticket back to your home country, not for your spouse or your kids or anything. They just have the obligation to you. So that's a second thing that has to be there as a right that you have to be aware of. So they can't just be like, okay, bye, end of the day. No, they got to give you this opportunity.
Mhm.
Third is, and remember this very, and I know people don't want to sue and all of these type of things, but you actually have the same rights of anyone who's a US worker, meaning that if you were fired because you are a whistleblower, you were fired because there was some reason because they're trying to just get rid of you or something because you're older or any of those things, the same protections that a US worker has, you have. Now, what does that mean? Now, let's say you are a whistleblower and you got fired because said you complained about something that the company was doing wrong, and they fire you because of that. You can sue them. I know H-1B people and people won't think of doing that and stuff like that because they're so afraid. But you are not some separate category of an employee. You have those rights. You are protected in this country under those same guidelines that I'm protected under. So don't be afraid that of, if somebody you did something like that or whatever, and you get fired because of that, don't like consult an attorney, labor and employment attorney, and maybe there's an option for you to get a settlement or something of that kind. Again, these are not things I'm advocating, so please make sure that people understand that, and it should not be some sort of frivolous thing. If it's you got laid off because you got laid off because they don't have work, there's nothing you can do about that. So this is, again, simply about other circumstances, which is provable, not any fantasy that's coming up in anybody's head. It's actually provable that you are still having that same protection. So keep that in mind if any of these things are happening. But if you're laid off, you got your 60-day grace period, you return transportation, money, and that's it, really. Those are your options in front there. But at least you have the 60 days. Not a lot of time. I wish they would have moved it to 90 at least, but at least you got that much time.
That's right. And that's very well said. And that was really insightful, Nandini. But also, there's a follow up question that is coming in my mind. All right. For once, for example, if there's any employer who got laid off, then
Mhm.
is it like if he's applying for the H-1B visa for the second time? I mean, not he's applying, but maybe the next employer, somebody
Mhm.
from USA is applying and hiring the same candidate who got laid off maybe 4 years back or 5 years back. Then
Mhm.
is that laying off thing going to impact their future visa application?
No, not at all. As long as they didn't work without authorization. So let's say these guys got laid off, right? Last week, and we've been hearing about this for the past many months, right? Of layoffs going on. No, just because they got laid off does not impact their visa application the next time around or a year from now. Any of that. There's no negative consequence that's going to happen to their application. Now, If in during that 60-day grace period before they file, they go and work somewhere and and they find out about this illegal work, yeah, then that you have an impact. But you got laid off, you had 60 days on day 42, you filed the petition that got approved, and then you started working. No, it has no impact. I have filed so many of those type of cases, and I explain it. Hey, he's not subject to the 60-day grace period. The clock began here. We're filing timely. You explain it out in the letter. You're perfectly okay.
All right, that's a great thing because Nandini, I asked this question about the future visa application. This maybe I didn't add it in the questionnaire, but this is another myth. I don't know, of course, it's a myth that what people are having in their mind. So thank you so much for that explanation and clearing up that doubt because that was also very important. And okay, let me go ahead with my next question that I have here. In the current immigration climate, as we all know, it's little uncertain. So, what are the biggest new challenges or changes that you are seeing for H-1B applicants?
I mean, I'm seeing a lot. I think, you know, at the core level, at the real basic level, this administration is not interested in keeping this program alive, right? They want to dismantle the program. The good thing is it's a program that can't be dismantled by executive action. Trump cannot just dismantle it. It was created by Congress and it has to go through this whole process. And so I don't think they can dismantle it. I don't think it'll ever get dismantled. But I find the biggest challenge H-1B people, and this is again for everyone who's on a visa here, they are going to find that things that were routine previously, like a routine application, is going to get more difficult. It's going to get kicked back a little bit more. It's going to be a longer processing time. I mean, I think your viewers need to understand that he's planning on closing a lot of consulates across the world, right? Now, what does that do when you do that? It creates that queue for the visa interviews, right? Now we're instead of 120 days or 30 days, you might be looking at a year to get a visa appointment, you know? So I think the biggest challenge is the mindset of this administration that is seeking to really tamp down this program or all foreign workers, try to make it harder, put up hurdles in front of everyone, take away certain protections that are in place, and add new restrictions, right? One of the things yours might be interested to know is at some point, and I think this will become shortly, he, especially for software consulting companies who place people at customer sites, they're asking, well, what's the customer's requirements for an H-1B for this type of position? How is somebody supposed to find that out? Sometimes my client doesn't even know the end customer because there's layers in between and things like that. So it just makes the application difficult. It makes it nerve-wracking. It makes it something that was routine 1,000 times more difficult now. So I see that as the biggest thing. It is the environment we're working on under right now in this administration. We are going to face challenges on the daily. And we're not going to have a heads up. That's the other part that, we're not going to know in advance of anything. We're finding out just like everybody else finds out through the media, through what's happening when they're going and picking up F1 students and canceling their CVAs, It's not like some announcement went out, right? So that is a real challenge for people because you always have to be nervous then if you're on a visa during this administration. So, but you got to do the best you can with that and try to stay out of what could potentially cause problems for you if you can. I mean, that's all advice I can give on that. But yeah, your challenges are this administration coming up. It's coming.
All right. I think now it's really, I would say, high time for everyone, to be aware about everything, to be very vigilant, to be cautious. And I think, friends, if you will get the right guidance and, if you're updated with everything, then of course you're going to make your own way. And there's no one who can stop you. You just have to make sure that you like, share, and subscribe to Immigration Talk Show because we come up with these insightful webinars and also with lots of different news updates that is very important for our viewers to be aware about and to get themselves updated regarding anything that's happening in the world of immigration. So just make sure that you like, share, and subscribe. And also, the best thing is that you can also press the bell icon so that whenever we come up with any news update or any live webinar, you'll get the notification. So thank you so much, Nandini, once again, for explaining these things in a very simpler term and that too in a very interesting way. So I think let's also greet to our audience. I can see lots of viewers have joined us: Sonia, Kritika, Christopher. So thank you guys for being here. And let's take one of the questions of Sonia. I'll take first. So Sonia is saying a lot of people say that the H-1B visa is only for people in tech jobs. Yeah, this is again a very important one. But I have heard that this isn't necessarily the case. So can you clarify which types of jobs or industries are eligible?
Okay, that's absolutely true. That their H-1B program is not for tech jobs. The program was created in 1990, so decades and decades ago, and the tech boom had not yet really happened. It was on its way. Um, the H-1B can be filed for any job. Okay, if you have an employer, any job that requires at least a bachelor's degree for that industry. So I do tech, absolutely, but I do physicians, I do dentists, I do accountants, I do finance people, I've done marketing executives, HR people, you know, fashion individuals, civil engineers, like anybody you can think of that they're going to work in a profession that requires a bachelor's degree or higher. That position in itself qualifies for an H-1B. Now, of course, who uses the program the most? Yes, tech people uses the H-1B program because outside of the United States, there is a great talent. We see it from India, we see it from China, and Europe and things like that, that the technology curriculum is strong in those countries, and there are individuals who are willing to come to the United States or want to come to the United States. And so the program is utilized a lot to bring in that type of talent. But that is a myth that it is only for tech workers. You can use that program for definitely other professions out there. So don't let that be the thing that everybody thinks. It's not true.
That's right. All right. So, Sonia, thank you so much for your question. And in case, if you still have any follow up question, then please go ahead and put them on the comment section. We are really going to take that question, and I'm sure Nandini is going to provide the best answer for that. Okay. So, let me take Kritika's comment here. So, hi Kritika, and thank you so much for joining us. She's saying, can you clarify the distinction between work authorization and immigration status in the context of H-1B visa, particularly with respect to the differences between H-1B approval notices, I-94 cards, and I-797 forms, and how do these documents impact an individual's ability to work and remain in the US?
Oh, Kritika, that's a long question. Wow, I'm gonna have to do an immigration class at this point. Okay, so let's talk about this. And there is a distinction. You're absolutely right. Work authorization does not mean that's immigration status, and vice versa. Okay, so let's talk about. So what is your status? Your status in the country is H-1B, is H-4, it's L-2, it's L-1. Like that's your status, right? That's what you are doing in the country. Like that's how you came into the country. Now you can be here, like for example, let's take this, H-4. You're here legally, your immigration status is H-4, but that visa does not allow you to work without other things happening first, right? So you don't have work authorization. You can be in the country, you can live here, you can go get your driver's license, you can do all of those things, but you cannot work, right? It doesn't allow that. It's not enabled for that status. Now, for an H-1B, you can come into the country, you are an H-1B, that's your status. Now, let's say we talked about before the transfer petition, right? You do employer A, and then employer B, you file that application, the transfer application. That case gets denied. Okay. Now your ability to work under that employer, your work authorization is gone if you joined employer B. Think about also people like got laid off. We were just talking about this, right? So that 60-day grace period. So you got laid off today. Today is April 30th. Okay. Because the law allows you to have those 60 days, tomorrow someone asks you and stops you and says, what is your immigration status? You can say, I'm on H-1B, because the law allows you to say that for that 60 days. But are you allowed to work for anybody? No, you are not. You are in the country legally. Nobody's going to do anything to you. But are you allowed to work? No. And that is the difference, that status does not necessarily mean you can work. And you have to remember that distinction very carefully. Because if you think just because you are here in valid immigration status, whether it's H4, whatever, that automatically that translates into you allowing to work for, at a gas station, work for at a store, work at an employer, whatever it is. No, that is not the same thing. So be very mindful of these two terms. It does not mean it is the same thing. And you have to understand that. And if you don't, you really need to talk to someone and make sure you don't work without authorization. Because one of the things I will say, the challenge the Trump administration is going to look at is individuals who have worked without authorization. These are kind of the questions that are coming up in H-1B applications now that we're seeing. So we're very mindful, and we're doing a lot of review of someone's work history before we're filing a case, because we have just kind of started, and I started about a month ago, that we've been seeing some of these things coming up. So be careful.
That's right. And I think, Kritika, be very mindful and be very particular about the steps you are taking. And in case if you have any doubt about your case, or please let us know what your status is right now in the comment section only. And the great thing is that you can also get in touch with Attorney Nandini Nair. And the contact details are on the screen, so you can go ahead and give her a call on the number. Also, share your case or share your query with the email ID, and you can also go ahead and check out her website. That will be really helpful for you and the best we can advise right now. So, Kritika, I hope that till now you have subscribed to our channel. If you haven't done it yet, then make sure that you do it right now. Okay, Christopher is here, and let's take Christopher's comment. What are the potential implications of AI and machine learning on H-1B visa requirements, particularly with respect to the definition of specialty occupation and the assessment of an individual's qualifications? And how might AI driven tools impact the H-1B petition process? Interesting.
Okay. Very interesting. What do I think about AI? I get this asked all the time. I'm not afraid of AI for myself. I think, for example, I think I have value besides my H-1B petition drafting or my support letter. I think there's more to me, than that. So that's one. But what do I think is going to be the impact for an H-1B? I think the impact for everyone across the globe is that AI is going to reduce the number of available jobs,
Yeah.
in certain sectors. And so that will create a less of a need for foreign talent, right? That's where the impact is you're going to see. You're going to see employers like, I don't need to hire anybody extra. I don't need this, because now a project that I needed 10 people for, and I hired 2 H-1Bs because I couldn't find them. I don't need 10 people. I only need 4 because AI can pick it up, the rest of it. So where do I see impact? The economic impact of AI is going to be that there's going to be less jobs out there, and the top of the top or the middle of the top, all of those people are the ones who are going to be employed, and the people who are more in the lower level with less technical skills and less skills generally are going to not be able to rise into those type of positions. So that's what I think. One. Now, like again, AI tools for the H-1B application process. I think, the goal of CIS and all of these government agencies is to use AI to facilitate a less paper filing process, which I would welcome. I don't want to be filing paper. I want to file things online as much as possible. It's easier for all of us, right? So I think we're going towards that process. But here's the part of AI. Now you are going to have a computer or these high-level tools who are going to be able to check an application for thoroughness, check the applicant's information so quickly that if there is incorrect information in your profile, it's going to come up like this, right? Whereas an officer, again, we're human beings, right? The officer's like, okay, this application looks fine. I'm tired. Like I'm going to just approve it. They don't have to work like that anymore. The AI is going to do that. If you notice, they ran a code, a script to pick up the F1 students. That's how they found the ones who had issues. They used AI in the background went through state databases to see anyone who's been arrested, charged, and things like that, and pulled up those and cross-matched with CIS to see who's on a visa. And they filtered that out, and that's how they picked up the F1 students and canceled their visas. So as much as it's going to go forward to be, I think, great, and hopefully streamline the process, this is where the background will be.
That's perfectly explained. I would say, Nandini, that was really insightful. And of course, talking about AI, this is another myth. And of course, it is related to H1B because people are thinking that AI is going to replace jobs and they are so afraid. But what you explained, that is very well put up. And I'm sure that it's nothing to be afraid of. In fact, it's more about, supporting humans as people are doing manually and they may get tired or they may be overburdened, so they may overlook works, but AI is really helping, and just within a second it's making things very easier. So
It's an evolution. We have to accept it. I don't know that why people jump crazy about it. Did we not go from horse and carriage to a car? That when that happened, a lot of people lost their job.
exactly,
That's what happens. So it's going to happen here.
that's right, and there's nothing to be afraid of, friends, because that's how you are going to develop. And if AI is developing, I think you should also develop your skills.
Yeah. Great.
So
Okay.
that's great. Yeah, be competitive, be positive, be hopeful, and also keep watching our session. I'm sure that our friends are watching our session and really enjoying it. And with that, Shiva is here. So, hi, Shiva. Thank you so much for your question. Let's take up your question. Can we change employer before landing into US? I mean, can we transfer employer from India itself after stamping done? Okay, so let me go ahead with the next one. Is this a myth or a fact? Presently working for MNC in India, but coming to USA via consultancy. Is that fine during stamping interview if I have proper answer why I'm coming via consultancy? Okay, so let's answer the first one first. Yeah.
Okay. So let's take this one at a time. So can I change my employer before I come to the US? So I'm assuming, got an employer A to file the H-1B, got it approved. You went for stamping with employer A information. And now you're like, I don't like employer A or whatever. Employer A is not wanting to bring me on board now, but I found employer B. Can I file a petition under employer B? And the answer is it depends on how long ago employer A filed your application and got the approval. So there is a time frame of 6 years, generally how I do it. Okay, and different lawyers have different ways of calculating this, but mine is 6 years from the fiscal year you got your H1 approved. If you was within, let's say, 2 years, okay, employer A didn't want to bring you on, but you have this H, you got your visa stamp. Now B's like, oh, you have a visa already approved? Come on board, let me file for you. Can they do that? Yes, they can do that. and not go through the lottery, because that's the follow-up question. Do I have to go through the lottery again? No, you don't, because the point was that you've already been counted against the lottery, right, within that 6-year time frame. And so you're not subject to it. So is it possible to do that? Yes, it is possible. Again, timeline is critical. When was the H1 from employer A approved? We would have to look at that and see if then we can take you to employer B. But yes, it is possible.
All right, that's a good one. But I wonder, Nandini, that does this even happen? Can we change employment? This is a very new question for me. But still, viewers are interacting with us. We are getting to know a lot of information. So thank you so much, Nandini, for putting up that answer. And let's go ahead with the next question of Shiva. Yeah, presently working for MNC in India, but coming to US via consultancy. Is that fine during stamping interview if I have a proper answer why I'm coming via consultancy?
Yeah, that's all. Yeah, if you are able to articulate why you are going to leave the MNC and come to this maybe smaller company, I'm assuming in the US. If you're able to articulate a valid reason, and I'm assuming you're going to be saying something like, better opportunities in the United States, blah, blah, whatever it is, you're going to say, and you're able to successfully get the stamping done based on that. Yeah, absolutely. Again, just because you work for an MNC in India does not preclude you or stop you from getting a visa issued by the Department of State or the U.S. consulate. That's not going to be that relevant. I mean, now there are going to be officers who may ask some silly questions. You always have to be prepared for that. But if you have a good answer, and there are definitely good answers as to why you would want to come to the U.S., I think you should be okay. But you got to remember, you got 5 minutes, or maybe even 2 minutes sometimes. So articulate well. Don't don't sit there and be shy. You got to speak well.
And I think speaking skills you should get from Nandini Nair because she's excellent in that. So we can understand, you'll be a great mentor to her. So Nandini, please go ahead. And I would say, Shiva, you can also get in touch with Nandini, not only regarding your immigration complexities, but also how to develop or, to get better in speaking skills. That will be great. Okay, so let me take up Rao's question. And hi, Rao, thank you so much for joining here. What are the H1B extension requirements in 2050?
I'm thinking he means 2025. I think that's
Yeah,
a type.
absolutely. Why 2015? I mean, it's 2025. Okay, yeah, please go
Yeah,
ahead.
10 years ago, I'm going to look a little bit younger, at that point. In 2025, again, I think the application process is very similar to what has been in the past few years, but the level of scrutiny, the level of review is going to be something that is going to be challenging. I think what everybody needs to understand is what's going to happen is your entire being, your entire environment, your entire background is now going to be looked at, right? Because there's rules now coming out that they're going to check your social media, right? That they're going to look at your phones and when you come back in, they're looking at see whether you're a pro-activist, right? Were you marching against Israel and like all of those type of things. So I think the biggest thing for viewers to understand is all of you, like your world is under their scrutiny now. It's not just going to be the H1B. It is all these external things that now you have to be mindful of. Did you file your AR-11 in time? That's a question that people are not thinking about. There's a rule. They put that in the rule has always been there for decades and decades. But people would I moved, I didn't do the AR-11 for 6 months. The law says within 10 days, guys. And are they going to hold you to that? Yeah. Now they're going to hold you to it. What are they going to do about it? We have yet to know what's going to happen. But could they utilize this as an issue? Absolutely. So remember your entire world is being looked at.
That's right. And that's very important for everyone, not only for Rao, but for everyone, to go ahead and look for this information. And Rao, I would say that, till the time if you haven't subscribed to our channel, and I think you are little new to our channel because for the very first time you have asked any question. So we do have these amazing webinars, and our channel is all about immigration world. So it's really going to be helpful, and also let us know, what are your current status, or if you have any other question for Nandini, then we are really going to take them up, as we are here for you guys only. And also subscribe to Immigration Talk Show, another very important thing. Okay, so Nandini, till now we have covered so many questions from our viewers, but just with your permission, if you have 5 more minutes extra, then we can also go ahead and take some Facebook questions as well, if you're comfortable.
Yeah, absolutely.
All right. Okay. So, control. Yeah. So this we got from Manav, and he's asking, I'm on F1 and traveling to India in the summer for 15 days, and will be coming back for the internship in June. Will it be safe to travel?
I'm going to say no. I'm going to say don't travel. I really am concerned for my F1 students right now. They seem to be really on the target for this administration for, I have no idea why. There's so much more they could go after. But I, if you were my client, I would ask you to say to decline that trip. I would say please avoid that trip at least for another year or so until we have a little bit more information on what this administration is going to do and what the courts are going to do about it. Because I can't trust your ability to return at this point, without issue. So my recommendation is don't travel.
All right. So, Manav, I hope you got your answer. And, any other query, please go ahead and let us know. Okay, so let me take up Senim question. We had our interview on the 17th April 2025. My husband is the main applicant for our diversity visa. Our case went to 221G due to my husband's y- uh, arrest years back. Visa officer requested a court document, just two questions. Why do they keep all our passports? And once we submit the court documents, do we get a chance for approval? What do you have to say, Nandini?
Okay, so they always keep your passport for every visa interviews. That's a very common thing. It's nothing that's specific to you or to individuals. If you want your passports back, you're basically asking to withdraw the application. Because remember, if the application is successful, you're going to get a visa issued within the pages of the passport. That's one of the reasons that they keep it, right? They're not going to then want to call you in for another interview and do all of those things. They do it all in one shot.
Yeah.
Now, submitting the court documents, do you get a chance for approval? It's all going to be dependent on what the reason was. How long ago was the arrest? What the issue was? A lot of those type of things. Do I think there's a strong chance of approval? I think you're in a tough situation because you're seeing that for any slight reason, the administration is denying applications or deporting people and things like that, right? So I would be concerned if that is the reason that you got the 221G and they're asking for these documents. Um, the level of success might be a little bit lower. So I want you to be mentally prepared for that possibility. It doesn't mean it can't get approved. I'm not saying that, but just keep that in mind that submission of those court documents is not the end of the story. It is just the beginning of the journey you're going to be on for this.
Wow, that's really great. Thank you so much, Nandini, for making us aware about the reality, but that too with some motivating lines, because that is also very necessary, because people are quite scared and very anxious. So, friends, if you are on the right track, I said that nobody's going to stop you. So be little hopeful, be little resilient, because with right guidance, that too, if you're going to approach with the right attorney, then that's going to be like wonderful for you. So get in touch with attorney Nandini Nair and share with her any doubts, any questions, any queries, and she is here to give you the expert advice. And I'm sure that you'll feel better and you'll do better. Okay, so let's move ahead with the next question. And this we got from anonymous participant. Hello, I'm looking for an immigration attorney. Okay. My husband and I have been married 5 years. We have a house and children. We have filed I-130 and it is still being reviewed. However, my husband's I-485 was declined due to not sending the correct documentation. I sent 2020 W-2 and not 2023. We have to appeal with an I 20, 209B. They are revoking his EAD to work. So, has anyone gone through this? Any recommendation? Yeah, any lawyer? Of course, we are going to share your contact details, Nandini, but what are your views on that?
Okay, well, I'm trying to understand what kind of preference category they're under. I'm going to try to assume U.S. citizen filing for spouse, because the way they're saying married, and file the I-130 and the 485. In my opinion, I don't think the 290B, again, not knowing a lot of the facts on this and what exactly happened, is going to be helpful. If it's a category of U.S. citizen spouse,
Mhm.
um, I would refile that 485. That would be my advice. The 290B is not. It's the processing times are ridiculous, and getting that EAD to be reinstated is going to be ridiculous. Based on the limited information, my gut is like I'd rather refile that 485. You know, in my opinion. But again, facts matter. The entire story matters. So take this with that information that I don't know the full facts and stuff, and kind of maybe talk to an attorney and give them the full facts, and maybe there will be a difference in a strategy at that point. But just this limited way, yeah, I'm looking at refiling that.
All right. And this anonymous participant is looking for an immigration attorney. So, friend, here's the detail. Here's the expert here sitting in front of us. The contact number is 973-287-0966 with the email ID nnair@aystrauss.com, and the website is www.aystrauss.com. So, Nandini, I think that's all for today's episode. And these were the Facebook questions. And we also got two questions from Rao. So, I mean, if you allow, can we take that questions because it's
Sure.
already 1-6. All
Yep,
right.
that's fine. No problem.
That's so sweet of you. So, Rao is here and asking, is it mandatory to carry client letter with consulting company? Client won't share letters to contractors. Any guidance on it?
No, it's not mandatory. No. I say that very quickly and don't jump on me on that, because I'm going to go into more about it.
All
Is it
right.
mandatory? No, it's not mandatory. Okay. However, let me give you what goes on the ground. Okay. They're going, especially with a consultancy company that may not be big and well known, right? We're talking like the TCSs, Wipros, Cognizants. I'm talking the smaller companies and stuff like that, maybe 25 employees and stuff. There is this issue where people or the consulate thinks that the letters might be fake, or there's issues whether the project is real and things like that, because there's been those issues, there have been such incidences, right? And they're going to be wary of that situation. So yes, you don't need the client letter and stuff. However, if and when they ask you at that interview who's going to be the end client you're working for, and you say let's say Pfizer, right, is the end client or something like that, and you are not able to provide real good information that you are actually, that's where you're going to go to, it creates doubt. It creates an issue in the officer's mind. And remember, you got that 2 to 3 minutes, 4 minutes in front of that officer. What's the alternative? The alternative is to see if you can get an SOW, a purchase order with your name on it by Pfizer. That's the way it will be okay or helpful. Now, again, what everything I tell you is in general. Okay. There are people who've gone without any issues. There are people who had the client letter and got the denial too. Okay. So it's not that just having the client letter. What I walk you through is how can you present yourself the best? It's not a guarantee. It's how what do I do? Right? It's like you dressing up in a nice suit when you're going to an interview, right? If you came in sloppy jeans and a t-shirt, what's the impression you're making? It's the same concept when you go to the consulate. What's the best presentation I can show to this person in front of me that I am actually going to be working at Pfizer for this company? That's how you have to look at it. And yes, if Pfizer does not issue those letters, because many end companies will not do that, then what else can you show? What else is there available? Again, one case is not the same as the next case. One case can show this, another case can show that. It all is an individual situation. So walk yourself through that process as to think, how do I best handle this? Can I get that statement of work at least?
That's right. And I think this is almost the same question. I'm on H1B with consultancy company. The client is not sharing letters to contractors. Of
Mhm.
course, it's the same. Most insurance companies won't share letters to contractors.
Yeah,
Okay.
and it's a common scenario. What I like to prep people with when I send them to the consulate, when I don't have the client letter, do I have a end client contact? Possibly, because what's going to happen? They're going to reach out to the end client. We all know this, generally. So you want that point of contact to get that email and be able to verify, yes, we're expecting Rao on this project and stuff like that. So again, just like I said, what other things can we do to make you look
Mhm.
the best you can in front of this officer?
Yeah.
It's not a one size fits all situation, guys. It is going to be individualized. It's going to be customized, um, and that is how you go in front of them. And also speaking, you got that 3 minutes. You got to articulate it. I constantly have these issues with my clients who are not able to articulate things. You got to be able to practice. And I always tell them, practice some of the possible questions. You go online, you will find the typical questions that a consulate officer is going to ask you. Practice, be
Yeah.
strong, like you got to look like you're telling the truth, not that you're not, right? But you got to be strong, and people who are strong in front of the consulate officer will be more successful.
Yeah.
Somebody's not going to push me, right? Because if I know what I'm saying, it's not going to, like, I know what I'm saying about immigration, right? It's the same way. But ask me a technical question or how my iPhone works, I have no clue. But same way.
Absolutely. And I think it's not only Nandini, in consular offices, somebody is liking if somebody is providing strong answers. In general life also,
Mhm.
somebody is going to be confident and, share any insight strongly, then that becomes little more catchy. So it's
Yeah,
nothing hard and
preparation is
fast
key.
rule. Yeah, yeah, please go ahead.
No, I was just going to say preparation is key. Like,
Absolutely.
I mean, guys, I know what I've been doing for 25 years, but I still prepared for today, right? Like thinking about what I could, questions and possible things and stuff. Preparation is key. Don't go into that interview blind. It's like you got to know what you're talking about. You got to be able to answer these questions. So again, I'm like very strong with my clients about all of these things because I want them to get the visa, you know. And sometimes I do interview preps and things like that. So they're, yeah, do all that.
That's great. That's wonderful. And that is so inspiring. So thank you so much, Nandini, for your time. I know it is 1:13, I mean like 1 hour, 13 minutes. And really appreciate your time. You patiently answered so many questions. So really honored to have a second episode with you. And that too, we didn't even realize how this 1 hour got passed away. So, again, thank you so much for being here. And as always, it's our pleasure, it's our honor to have a show with you. Any last message, any last tip that you want to share with our viewers, then please go ahead.
I would just say that, immigration overall is challenging. It is a beautiful thing. I think this country is the best when it has diversity of thought, diversity of people from all over. But it is a challenging time. Be mindful, be careful, get the advice that you need, tread lightly on whatever you're doing. Is what I my advice to you is for the next couple of years. Be careful out there and stuff.
All right. That is a beautiful message with a very insightful tip as well. So, thank you so much, Nandini, for being here. And soon we are looking to have another episode with you again. So, hope to see you again and have a great day. And again, thank you so much for being here.
Thank you so much for having me. It was my pleasure.
All right. Okay, friends, so that's all for today's episode. Hope you like this video. And in case if you still have any questions or any doubts regarding today's webinar, then please go ahead. The questions section is just on the left of your screen. Put them on there, and we are going to take up those questions even after this live stream ends. Don't forget that we are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. Follow us on these many platforms. And also, if you haven't liked, share, and subscribe to our channel, then make sure you do it right now, because that is the only way you can keep yourself updated. And can keeping you updated is really a very important factor in today's preparation. So don't miss out that. Also press the bell icon. And it's me, Sam, signing off for now. So goodbye, everyone, and take care.
Hi everyone, welcome to Immigration Talk Show. I'm your host Rajni Bharara, and before I move ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone to Immigration Talk Show. I'm Rajni Bharara, your host, and today we tackle a topic that is at the crossroads of opportunity and controversy. The H-1B visa program. Is it a catalyst of economic growth and innovation? Or does it pose a threat to American jobs? Well, we are going to talk about that with our guest today, who is none other than attorney Erin Green. He's not just an immigration attorney, but also an H-1B visa expert. So we are glad to have Erin on our show again. So now, without any further ado, because I have a lot of questions that I would like to ask from Erin, so I would not like to waste any more time and directly, welcome him to the show. So, Erin, welcome to Immigration Talk Show once again.
Thank you. Good to be here. Thanks for having me.
It's a pleasure having you. And, I was so excited for you to come back so that we can talk about this topic, because this topic in particular, everybody is talking about it, and people are so much curious to know about what's been happening. And because every now and then, just yesterday, we got an update on uscis.gov about H-1B visa. And every now and then we are getting so much information about this particular visa. Before we talk about H-1B visa, or whether it is good for the economy or whether it is posing a threat to American jobs, I would actually like to know from you, like from the time President Trump has taken the office, a lot of people are, are always having a debate about whether it is good for the immigrants, especially, or whether it is bad for the immigrants. And now that the deportation is going on, people are having so much to talk about. Some are in favor, some are against. I mean, celebrities are crying and making a video and posting that on their social media. So I would like to know from you, with all that have happened, what do you think about it? Is it like, with whatever that is happening and whatever that Trump administration is doing, do you think it is benefiting the immigrants, or is it going against the immigrants?
Yeah, I think what Trump's doing is benefiting legal immigrants, people who come here in categories like H-1B, L-1B, TNs, people who abide by the laws of the country, people who do not for a second want to have any kind of violation, even if it's an overstay of an I-94 or anything. So it's a good thing that when people break the law, that it's taken care of. I can't believe it's even a debate. Especially at this stage, they're removing criminals right now, and hardened criminals, some of the worst. I can't believe that's a debate. But as they remove all the criminals, yes, they need to look at, for example, those who have been given asylum hearings and don't show up, when they're called, which is probably 90 to 98% of people who are given asylum hearings just don't show up to their hearing years down the road. That shows you how much of a scam the asylum entry that's been going on for years, and especially the last 4 years, where it's been elevated to a degree that no one can believe. So yes, what's going on now is what Trump promised. Those who are criminals and here illegally are being removed from the country. It's going to take a long time. But yes, illegal immigration is bad for legal immigration.
Right.
H-1Bs wait years and years to do everything right. They so-called wait in line, quote. They wait in line, they pay fees, they make sure everything is right, they stress out, they do it the right way. We're the most generous country in the world. We offer the most legal green cards in the world by far. And especially when it comes to work visas and work green cards, we offer the most in the world by far. So there's a mechanism to get here. The fact that we cannot take on the entire world's poor people, even though we have a heart for poor people, but you can't just allow people to come in the country just because they're poor and tell them, just claim asylum and then you're in and you can get everything you want right away. That's not how the system should work. That's a broken system. And yes, it does affect those in the legal immigration community, like our H-1B workers.
Right, very well said. But then, Erin, I would also like to know from you, all these influential celebrities who have so much influence on people, and because, people do look up to them. So, I mean, they are not directly involved with all these things, but when it comes to all these, controversies, they do share their opinions and viewpoints on what they think. So why do you think these people are, if I can say, like, crying for these people who are being deported and posting the videos and coming in favor of them, though they know that, that the path that they chose and how they came to the country was not the legal way. But then why do you think, this is also happening on the other side?
The problem is that celebrities are ignorant and or stupid. So that combination can be very influential when they have millions of followers or fans that like them just because they can sing a song or act in Hollywood or Bollywood. But here it's Hollywood. It's ridiculous. Those who follow these people are probably and believe in their opinions and what they say are probably the most ignorant people in our society, unfortunately, and not the brightest. And unfortunately, a country of 330 million will have a lot of folks who never read anything about immigration or any topic, but they get a little feed on their Twitter or Instagram or whatever they use, and some celebrity is posting that, and now they think they understand the topic. They don't. It's misinformation. It's terrible. These celebrities are the worst. If they could just do what they are paid to do or what they are famous for, which is either sports or acting or singing or whatever, then everything would be a lot better for the rest of us. But they have to now chime in on every social topic or legal topic that they know nothing about. It's unfortunate. For your listeners, I would not pay attention to any of them. None of them are experts. None of them know what they're talking about. And, everyone has sympathy for poor people. I don't have to be a celebrity to say, I feel bad for poor people. I like them to come and have an opportunity, but you have to do it in a systematic legal way that's fair to everyone. Right. I've said for many years, if they could increase the H-2B program, this is a little bit off topic. The H-2B program is for non-degree workers. It's different than the H-1Bs where you have to require a degree, right? A 4-year degree or equivalent. H-2Bs are your farm workers, people who work in hotels. They come in seasonally, and it's great. They're usually people looking for a little bit of a better job, more money in their job, and this was established for that and to fill a need in the U.S. The problem with the H-2B program is that there's not a lot of them given out. I don't know the actual number, but again, like the H-1B, there's a cap and a lottery for that, and companies apply for those, and it's great. The people are vetted thoroughly. They come seasonally, they go back, they bring the money back to help their families in different countries, and then they can come back again. If we could expand that program, we could help a lot more of the world's poor. But by doing what they've been doing for the past 4 years, especially, and before, with this phony asylum claiming sham, scam, and just allowing people to come in willy-nilly from anywhere, it almost blows your mind. Right. And that's an educated opinion. I've been reading and lurking into this for years and years. Plus, I'm an immigration lawyer. But just by being an immigration lawyer doesn't mean anything. Because I know a lot of immigration lawyers, very well-respected immigration lawyers, who take the opposite approach, who think, no, all these people should be coming in and should have an asylum hearing. It makes no sense. These people don't qualify for asylum. They know it. And they're just trying to substitute some kind of logic in there to bring in masses of people. Some of these lawyers profit off them, obviously, and others are just ideologically backwards.
Right. So, but Erin, do you think, because if immigration attorneys themselves, if they, come in favor of these people, and also celebrities, them being so influential and they have so much influence on people and people's mind, and also by the political parties, they are also called for campaign promotions, right? When they are going out for campaigns, these celebrities are also called. So, do you think if they make these statements, do you think it creates any kind of influence, or like the government also creates this, or also have decisions, or makes decision based on what these people are saying?
Not this government. No.
Okay.
Traditionally, when you talk about these celebrities, they have been in our country, they've been 80 to 90, even higher left wing, meaning Democrat, very liberal left wing. We're seeing a shift now as the country saw in the last election how it had been destroyed for the past 4 years, and how these folks are just preaching nonsense. We've seen a shift in a lot of voters to say, you know what, this is ridiculous. We've gone too far. These celebrities have lost most of their influence, in my opinion. And the fact that there's a rise of celebrities that are actually posing another opinion now without the threat of being canceled or, fired, which is what had happened. They use fear in their industry to hold a grip on one political position and opinion. And if you disagreed with them, well, you weren't going to get your next acting job or your next music job, etc. So now there's a big shift. If I'm an H-1B worker, and I see these yo-yos screaming because we're enforcing the law, finally, I wouldn't pay any attention to them. And so that's my advice to anyone out there who's not American or who thinks these celebrities have some kind of influence. They don't, especially not on this administration that's just been elected overwhelmingly.
Yeah, really glad, right?
Yeah, I can't imagine if the other side would have won, how this immigration mess would have continued and gotten worse. Who knows what would have happened, leading to the destruction of our laws and our country. Who knows? But now it's time for law and order to restore the destruction that has been done over the past 4 years. And they're doing it now. They're starting on day one and they're getting going and they're just starting.
But do you think this mess will be, I mean, all this mess that the government is or the administration is trying to clean or that they're trying to accomplish, do you think they will be able to do this in these 4 years?
In terms of stopping the ridiculous, everyone come in, we'll let you into the country, we'll even fly you in program, that's already been stopped. So it's like a drain with water. That's been shut off. Now, what has come in the last 4 years, we don't know. Is it 10 million? Is it 12 million? Is it 8 million? A lot of them came in, just over the border, and there's been no, they didn't have enough resources, and they didn't want to have enough resources to catch them. So the challenge will be how to remove a lot of the illegals that came in the past 4 years, and I don't know how long that will take. But they need to start somewhere. You start with criminals. You have a record of them. You know where they are. I think they'll move on to people who have not showed up for their asylum hearings, which is the whole reason why they were allowed here in the first place. Then they'll go after them, and but that's a whole different topic. That's not something I'm an expert in, but I certainly am very fluent in it, watching what's been going on the last 4 years in that arena and how our border we don't have a border. Mm-hmm. So now we need to build a border, and that's what we're trying to do.
Right. Okay. Now let's come back to our topic, H-1B. So I would also like to know from you, Erin, that how do H-1B actually impact American job markets? Because, some people are saying that it is posing threat to American jobs. So would you say that it is posing threat to American jobs? Or because we have, also heard conflicting reports about whether these visas create jobs or they reduce the job opportunities for American people?
I really think they create jobs. Look, if we had an abundance of American students who want to get computer engineering degrees and electrical engineering and mechanical engineering sometimes, and all these other related degrees, STEM, if we had an abundance of that in the computer field alone, then you can make the argument that, the H-1B is not needed, and you would see companies would not utilize the H-1B like they do now. But because we have a shortage in school of American students not taking these particular majors, they simply don't want to do coding. They find it boring. We have a great need for foreign talent. H-1Bs fill the gap immensely, and we could use even more. You can see the numbers of H-1B applications in the lottery every year. Last year was over 700,000, I believe, if I'm correct. And that doesn't even include all the existing H-1Bs that are in the country who've already made the lottery. And they're all employed. None of them are unemployed, very few. And you can look at these big companies' web pages, you can see all their career openings, and there's just tons of openings in these positions everywhere. So I believe that it does not hurt the American worker at all. In fact, American workers who are in the field are at a prime. Companies do not need to spend thousands and thousands of dollars on green cards and H-1Bs and extensions. If they have a talented American worker at the same level, they'll simply hire the American just by economics. So my answer is no. I don't think it hurts American workers at all right now.
Okay. All right. So also, guys, if you're enjoying this conversation and if you're getting information out of this conversation, make sure to subscribe to Immigration Talk Show and like the video, share with your friends and family who you think needs to hear this. So yes. And coming back to you, Erin, I would also like to know if you can provide some examples of maybe some companies or sectors where you think, hiring H-1B workers has led to significant job creation.
So most H-1Bs, as you know, are computers and computer-related jobs. Now expanding into AI, which involves obviously computers, data engineering, software, anything from software to even project management, anything related to the STEM field of computers and computing. That's the biggest use of H-1B. It still is. You can see the LCA data statistics. So what exactly is the question? How do these H-1Bs contribute to growth in companies?
I was saying if you can provide some examples of some companies or maybe some sectors where you felt that, this hiring H-1B workers have created significant job creation for, US workers. Has led to
Yeah, so
significant.
the IT sector. So the IT sector. So for example, if you don't have talented folks here and you need an abundance from overseas, well, what comes with that is very innovative people. Some of them will go on to start new companies after they leave their company. They'll start startups. They'll make new products. The H-1Bs who are working for existing IT companies, even if they're big companies, they can develop things within their H-1B role that will lead to new products, new platforms, new algorithms. These will turn into new services and products, which will need additional employees to support them. So there can be a lot of growth, not just from the H-1B worker, but from other workers. Let me give you an example. When I was the head of immigration at Infosys, I used to go to all the client sites, which were all mostly Fortune 500 companies. And I met with all the managers and we talked to all the employees and answered their immigration questions. They were all mostly H-1Bs and L-1s. And at the time in California, there was a big controversy over one of the clients removing their H-1B department and replacing it with Infosys, for example, and another contracting company, and basically taking over the whole IT function. So when I talked to some of the managers, I said, they're removing the IT department that's there, and they're bringing you guys in. So 3 things. Number one, in a lot of these situations where the IT department is removed, they offer the jobs to the folks that are already there. In a lot of these cases, I know they did at Harley Davidson. That was one that I worked on. The electric company in California. I'm not sure about that, but going further, the managers would tell me that when they come in and bring in a specialist like, an Infosys or another company similar to that, they save them a lot of money because what they're doing is very innovative. They save them money. And I'm not talking about just saving them salaries. They know how to do things better and faster, leading to a better product that saves them money. And in turn, by saving the money, the company can hire a lot of other employees in different fields. And those are majority, obviously, American employees. So it can be a win-win approach when a lot of H-1Bs come in and innovate. And that's what it leads to. Again, I mentioned entrepreneurship as some folks leave and start their own businesses or move. But yeah, I think it's a positive. I know fear mongers out there will say, yeah, but Americans are losing jobs. I don't know about that. There's so many jobs out there that if an American did lose a job, let's say because they replaced the IT department at that person's company, well, they could easily find another job. Also, some of those workers, let's face it, are not that great. Okay, so these companies have old IT departments. They're not doing very well. They come in and innovate. You can see right now, like with the government, what they're doing. They're going into all these government agencies and they're cleaning out the pork. People who either don't come to work, they're lazy, they're getting rid of them. They want efficiency. So a lot of that happens when you utilize either a big IT subcontractor, or just, you're hiring H-1Bs in general.
Right. Thank you so much again for answering the question, Erin. We have started receiving a lot of questions from the viewers, which we are going to take in a bit. But before that, I would like to come back to President Trump, and I would like to ask you that, very recently, he changed his stance on H-1B visa. Earlier, he said it's very, very, very bad, if you remember. And then later, he said, he came in favor of it and he supported the H-1B visa. What do you think? Why do you think, that sudden change of stance happened? And, what do you think actually influenced that?
Okay, first of all, he never said he was against H-1B visas. In fact, I can remember during his first 4 years in office, he was very supportive of them and made statements to that effect. So if we go back in the record, I guarantee you I can find you that. If he said anything negative about it, he changes his mind. When he gets educated on a topic, he's the type of person that seems to listen to people and can change his mind. So if he did say something where he doesn't support look, he runs the Trump organization. They use H-1Bs. They probably use a lot of H-2Bs as well. That's, but what I've seen is that he's very supportive of H-1Bs. He realizes the value in them, the need for that labor force, the professional labor force as it is. So I question those people who say he was very negative on it. And if you can send me some links of stuff he said, I could probably find you. I know I can, because I remember I can send you other links where he said the exact opposite. So I wouldn't put too much stock in something in the past. And also, if you want to look at the past history of the 4 years where he was president, H-1Bs did not decline in any way. And in fact, the wait times were much less. So we're hoping to get back to less wait times, which is frustrating our whole firm and probably every other lawyer out there. It's become crazy how long you have to wait. Yeah, you can pay premium, but premium is now close to $3,000, which is crazy. It's a big expense, especially for small companies. So I think things will only get better. I wouldn't put any stock in fear mongering, which is what people like to do when it comes to Trump, just because for some reason they don't like him, and then they start making up things.
Again, thank you so much for answering the question, Erin. Let me quickly.
And I don't know where that very, very bad shift comes from. I'd like to see that in writing, where it comes from, because I don't think that's what he said at all.
Okay, all right, but thank you so much again for answering the question, Erin. Maybe if I get it, so I'll also try to share that link with you if I get that, if I see that. But for now, let me quickly take the viewer's question. But you answered it very well. But again, I would like to take the viewers' questions, and because we have been getting many, so let me very quickly take Sahil's question for now. Sahil says, as an H-1B visa holder with several years of experience in the US, I have begun to question the program's impact. Do you think the H-1B program genuinely contributes to job creation and economic growth, or does it primarily create competition for American workers? And I think you already have answered this, but still, if you would like to take it and answer it again.
I mean, in general, I think it's good. Again, I work with recruiters all day long, my clients. I work with HR departments, legal departments, recruiting departments. But when I get to talk to the recruiters and I can see what they're doing, it's just basic common sense. If you have an American worker and you have an H-1B worker and they're both applying for a role, which has a salary band, sometimes has a salary band, obviously they can go from here to here. But my point is, why would the employer want to hire an H-1B worker when you have an equally qualified American worker and take on thousands and thousands and thousands of dollars and time and a little bit of unknown? Things can get denied, when they can just take the American worker, is what I'm saying. So if anything, I don't think it hurts the American worker and dealing with recruiters all day and seeing how they recruit. And yes, in some cases, they're going to need the H-1B employee because there simply aren't enough Americans who have applied, or, it's some kind of niche skill and this person has it and they just happen to need sponsorship. So no, I don't think the H-1Bs damage the American IT workers. I think American IT workers are some of the best off, most well-paid workers that we have.
Right. And, you're not just an immigration attorney with that. You're also an H-1B visa expert, right? And if it genuinely hurts, you would know, right? More than anybody, I think you would at least know. So
typically what happens is there's a case. There's a case. Someone complains because he's an American. He feels he's been wronged by his company. He files a lawsuit. And then the issue is, well, I was replaced simply by someone else because I'm American and I'm not, and that's why they replaced me. That's usually not the case. Those are far and few. I remember years ago when I was working there, when I was the head of immigration at Infosys, I remember we dealt with a lot of these cases when we were contracted to come in and perform a lot of work for some of these big companies. So there are cases here and there, but if you break it down, it's not a lot of people who are complaining. And in a lot of cases, that person simply was there for many, many years and was basically not contributing, not innovating, not doing a good job. We have at-will employment in the United States. You can fire anyone for any reason. That's how our laws work. So, but those tend to make the headlines. Something like that. It's juicy. There's an element of racism in it, maybe. So those make the headlines. News reporters love to pick that up and make a whole story, and then that gets out, and people think that's happening everywhere. It's not.
Okay, so Sahil, I hope you have got your answer. Thank you for your question. And guys, if you have any more questions related to this topic that you like to know answer of, so what you can do is you can also give us a call on the number 425-436-6335, and you can also put the access code, which is 988888. Yes, you can ask your questions by also calling us. You can give us a call and ask your questions by dialing the number 425-436-6335. And don't forget to put the access code. The access code is 988888. Yes, and make sure to subscribe to the channel, and also like the video and share the video with anyone you feel should know and watch this episode. And for now, let me quickly take RK's question. And RK says, do you think the problem with us immigration is the employers? H2A is uncapped, yet so many undocumented agriculture workers. Had the Bracero program employers abuse the workers? Okay, I think.
Is you talking about H2B?
Yeah.
I'm not familiar with H2A. To be honest with you, our firm we don't handle H2B. We don't handle H2A. So I'm not really an expert on that. I don't know if I can give a comment on that. There are definitely a lot of undocumented agricultural workers here. Is there a need for them? Maybe. Do Americans, the old argument is, well, Americans don't want to do these jobs, so we need to bring them in from, South America and now from everywhere. I mean, if that's the argument, then you got to expand the H2B program or the H2A program, which I don't know much about. And if you do that, maybe you can bring a lot more people in legally, and it would benefit everyone. That's a win-win. But Congress needs to do that. It's not something the president can do. H2B numbers, like H1B numbers, can only go up through an act of Congress. The president can't sign a presidential executive order and say, okay, we want more or less. This is set by Congress. That's why we have 80,000 right now.
Right. And he goes on to say that layoff FYI showed that between 2022 to 2024, 580K IT workers, 580,000 IT workers got laid off. Why does Congress not restrict level 1 and 2 H1B workers when mass layoffs? Keep level 3 and 4. They create jobs for H1B and USC. What do you have to say?
Well, Congress can do whatever it wants. If Congress comes together and passes a law that says you can only get H1B if you're level 3 or level 4, that will become the law. So Congress can do that. The problem with Congress is they never will pass. They haven't, I don't know in how many years, they're never going to pass a comprehensive immigration bill, either because they don't want to, they like the status quo, both sides, or they just can't agree, obviously, both sides, or because these bills are filled with so many things that they get crazy. I remember, I think it was 2012 when the Gang of Eight, when they were going to pass. I did a lot of lobbying for my company in DC, and they were close to passing an immigration bill, but it didn't happen. And then if you do pass an immigration bill, you can make some changes. You can, like what he says, maybe let's get rid of level 1 and level 2 H1B workers and just keep it at level 3 and level 4. Okay, you can do that. I don't know what effect that would have on the IT industry, because a lot of level 1 and level 2 workers are very vital. Some of them are students who finish their master's or their undergrad, and then they're working for a nice company, and they need that H1B to continue. They only have 3 years on their OPT and their STEM OPT. So who knows what the impact on that would be. I think they should create more numbers personally. We have 80,000 now. I think they should get back to like maybe 200,000 a year would be a solid number. That's just my opinion. I think, judging by the cap numbers, we certainly need that, if not more. So those statistics don't lie, the number of applications.
Okay. So RK, I hope you have got your answer. In case you want to know more, continue posting your follow-ups, and you can also give us a call on the given number. And yes, but thank you so much again for answering the question, Erin. We still have a lot of other questions. Okay, Skywild Designs is here and says, hello, any news on H2B programs since it feels like employers are not proceeding with out of country recruitments? What do you have to say, Erin?
Again, I don't deal with the H2B program. I know about it. It can be very useful. It can employ a lot of good people who might not have an opportunity in their country or just want to come here and work and bring the money back to their family without necessarily moving the whole family here. It's a good program. They do a lot of jobs that we so-called may have a shortage in America on. For example, landscaping, hotel industry, agriculture, as you say, things like that. If Congress can look at expanding these programs, we could have a lot more opportunity for people who want to work, who maybe don't have the opportunity in their home country because it's a poor country or whatever.
Okay, looks like I have a slight technical problem, but I'm trying to resolve it. But meanwhile, let's go for a short break. So let's take a short break and come back quickly. And welcome back, everyone, to Immigration Talk Show. I'm Rajni Bharara, and I'm so sorry about that technical glitch that happened before the break. But now we are all sorted. And welcome back, Erin. I'm so sorry about it. And which we had to take a short break, but now it's all good and we can continue the show. And Erin, I would again like to move to the viewers' question because we had so many. And so I hope Designs, you got your answer. Thank you so much for your question. And let me take Empire's question. Empire says, why do groups try to remove H4 EAD? Why do they keep litigating in the courts to have it removed? As well, it was on the regulator agenda in the past by the Trump administration to remove it. Why? What do you have to say?
Well, in the past, L2s and H4s were not allowed to work for many years. When I started working as an immigration lawyer, there was no work option for an L2 or an H4. And then they changed that because they figured, the spouses come here for long periods of time and are very hamstrung and handcuffed. They can't do anything. So they changed it. And then L2s could work. And then for the H4s, as you know, they could work as well if the spouse if the H1B had an approved I-140. So it's a little bit different than the L2. There's just groups now in that situation, you can make a stronger argument because an H4 can work anywhere for anyone in any position, that could impact American workers. If you think about it, it could be any job. So there are a lot of groups out there, lobby groups and whatnot, who don't want the H-4s working. And they could make an argument that it does affect the American worker, as I said, because it can be in any industry at any level. So theoretically, you could just simply be taking a job, as opposed to my argument with the H-1Bs, where we have an industry that we really don't have enough people in our own country. So it's a little bit of a different argument, and that's why it's constantly being challenged by groups and in the courts.
Okay. Empire, I hope you have got your answer. If you have a follow-up, please continue posting your follow-up. Meanwhile, let me come back to my questions and let me ask, the question that I prepared for you, Erin. So, Erin, recently, the new H-1B visa reforms, starting January 17th, it was said that these reforms are aimed to improve fairness, right? So, what do you think? What are the most significant changes that workers and employers should know about?
I think you're referring to reforms about the lottery program. A lot of what you mentioned, a lot of what's in that January 17th has to do with cleaning up the CAP registration program so there's less fraud. That was a big part of it. There was a little bit about CAP exempt employers. As you know, if you're an employer that's not a regular employer, let's say you're like a government institution or sometimes educational entities, sometimes nonprofits, they can get H-1Bs year round, so they're not subject to the cap. There was something about, making that a little bit friendlier. Otherwise, then something about how they define the specialty occupation itself, maybe when they're going to look at petitions. That could make adjudications a little bit easier for H-1B. Right now, I don't see much of a problem in the H-1B field. We file, I can't even tell you how many H-1Bs we do every day. But so we see responses, we see the levels of RFEs. We can get pretty good statistics even internally. And right now, H-1Bs do not seem to be issuing a lot of needless RFEs like they have in the past. I remember about maybe, I think 5 years ago, we just saw, it comes in waves. So there's got to be some internal directives. We all of a sudden be quiet, and then every other H-1B was getting RFE'd with the same RFE. So no method to the madness. But right now, I think it's pretty good. We file H-1Bs. The wait times are a little bit annoying, but we're not seeing too many RFEs, what we call the boilerplate RFE, where you get a 10-page RFE, and then you can see they haven't even looked at it, and they just print it out and send it to you. In addition, I can see lately that with H-1Bs and some other categories, they're getting a little bit better with their RFEs. I think that's internally they've been instructed to do a little bit more on asking for very specific things. So maybe you'll get a shorter RFE, but it's looking for something very specific. We're seeing a lot of that trending lately. That's good because they can focus on something that actually is a legitimate issue, and you don't have to send them a response to 10 pages of nonsense when you've already provided everything there. So, yeah, I hope that answered the question adequately.
Right. It does. Thank you so much for answering the question, Erin. Erin, with that, I would also like to know from you about, with India providing the majority number of H-1B visa holders, right? So, how do you think these recent policy changes are specifically going to impact Indian tech professionals?
Well, anything that's done in the H-1B program will impact any H-1Bs. It doesn't matter if they're an IT professional from India or a chef from China or an accountant from Brazil. It doesn't matter. Whatever they implement, it affects them across the board. So there's no specific cutout for, let's go target. They can't do that. They can target the H-1B program. They can make some changes, maybe some beneficial, maybe some negative changes. But yeah, so to answer your question, Indians specifically will not be hurt any more than anyone else who has an H-1B.
Okay.
Indians and Chinese do make up the vast majority of H-1B users. That is true. Sometimes they get a bad rap for it because when people are criticizing H-1Bs. In a sense, they could be criticizing Indians because Indians use the most, let's say. And it's just it's an unfair criticism. I work with Indians. As you know, I was the head of immigration for Infosys for over 5 years. I've been to India a lot. I live in an Indian community in Texas. 80% of my neighbors are Indian. This happens to be an Indian community. I can tell you the Indian population is the type of immigrants we want here. I can tell you the crime rate for Indians is almost zero. There might be a little bit here and there. Very good students, very good parents. They want their kids to get a good education. These are the role models for the types of immigrants and H-1B workers we want in the country. So maybe sometimes Indians get a bad rap because they're using the H-1B so much, but at the end of the day, these are the types of new Americans that you want here eventually.
Right. Okay. Thank you so much again for answering the question, Erin. Let me quickly take Empire's question again. Empire is back with his question. He says, if the 580K layoff is okay, I think we already have taken this. Maybe let's take Yuri's question. Yuri says, I'm on vacation in India and was laid off effective Feb 1st, 2025 with a half-month severance. I'm on H-1B exempt visa since June 2023 with stamping valid until June 2026. My return flight is on February 17th. What are my options for safe re-entry into the US?
Well, if you're no longer employed by the company on your H-1B visa, you should not enter with that visa unless you have a new H-1B approval for a new employer. And then you could use the visa plus the new H-1B to enter. But if not, technically, you shouldn't make an entry back into the US on that H-1B visa because you're not working for them. You're not on their payroll. You're separated from the company. So that technically would be illegal.
Okay. So Yuri, I hope you have got your answer. In case you have a follow-up, continue posting it in the comments below. And
if Yuri can enter on a B visa, he could come in and look for jobs while he's here. Obviously, he's not working. And then if somebody wanted to hire him, he could change status from B to H-1B while he's in the US. He could do that.
Okay. Okay, Yuri, I hope you have got your answer. And let me quickly take Amarjeet's question also. So he says, my wife is on H4 here in New Jersey and also have Canada open work permit. She's planning to visit Canada as a tourist. Is it allowed on open work permit or need to apply visitor visa? What do you have to say to Amarjeet?
To enter Canada? Okay, so I'm not a Canadian immigration lawyer. I have colleagues who do rest of the world. I do US only. But an H4 can travel to Canada. I believe Indians have to get a visa to get to Canada. Oh, she said you have a Canada open work permit. So the H4 could enter Canada legally. She's planning to visit as a tourist. Okay. Yeah, I'm not familiar with what Indians need to travel to Canada. If I recall correctly, they need a Canadian tourist visa to enter as an Indian, I think. So in that case, yeah, you can't use visas and be deceptive about your entry. So if you're coming in for one purpose and not to work as a tourist, you shouldn't be using your Canadian open work permit. Same thing goes for the US.
Okay. Okay. So Amarjeet, I hope you have got your answer.
I get the Canadian visa. Yes.
Okay, but guys, Erin is not just an immigration attorney, but also an H-1B visa expert. So if you want to get a detailed consultation with Erin, and if you have any case regarding H-1B, you can directly get in touch with him and contact him on his number 469-459-1771. I would like to repeat the number 469-459-1771. You can also email him. His email ID is erin@eeglawgroup.com. Yes, you can also email him and also visit his website, which is www.eeglawgroup.com. So make sure to get in touch with him for a detailed consultation regarding your H-1B cases or any immigration case that you are looking to looking for help or looking for a consultation. But for now, let me quickly take Rag's question also. Aaron, Rag is here, and he actually wants to know, okay, we have also we have people posting on Facebook groups questions related to H1B, which we would like to take, but I think we will take them in a bit. But right now we have another viewer, Rag, and it's not related to H1B, but he wants to have your guidance on L1A. So if you have anything for him.
L1A, in order to qualify for an L1A, you have to work for a company outside the U.S. that's related to the future U.S. employer. It can be a parent, subsidiary, they're affiliated companies owned by another company. There has to be a relationship. You have to work there for at least a year. And to qualify for the L1A, you have to be a manager or an executive. So if you're a manager abroad or an executive abroad and you're coming into the U.S. to fulfill a manager or executive role, then that's the most straightforward way to do an L1A. You can also do a hybrid L1A where you're a specialized knowledge person abroad and you're coming in, or vice versa. But most L1As, they're a manager in their current job, they're coming to be a manager in the U.S., and they've worked outside for at least a year. And those are the best cases for the L1A visa. There's no cap on the L1A. The L2 spouse can work right away as soon as you enter. You don't even need an EAD card anymore. So the L1 is a good tool or mechanism for companies who need to move their workers to the U.S. And yes, if I'm an expert, there's one thing I'm more of an expert on than H1Bs, it's L1s. So those two are pretty much my bread and butter. I've been doing that for over 20, I don't know how many years, but yeah, solid visa. Your company will obviously have to sponsor you just like an H1B. But if you want to reach out to me, a lot of our clients are most of our clients are companies, and they do a plethora of L1s or H1Bs.
Great. So maybe Rag, you can directly get in touch with Erin. You have the details right on screen. You can note down his phone number, his email, and you can also visit his website.
Oh, one thing about L1s, I get people calling me a lot, and they're like, "Well, I don't have a company." We're a law firm, so if you have a company that you're employed with and they're thinking about moving you, yes, call me. I can speak to your company. We can explain how it works. I can talk to you. That's great. But if you're just asking about L1s, the first thing you need to do before you come to me is have a company that you work for. Same thing with an H1B. Have a company that's going to sponsor you. So once you get that company, then yes, I can talk to you and answer your questions, and we can move from there and facilitate how we're going to do an H1, an L1, whatever the work visa is.
Okay, so he's back and he says, thanks, Erin. What are the latest trends for L1A?
Trends, they've been pretty consistent over the past 8 to 10 years. The trending L1As have gotten much harder over the last 8 to 10 years. When we used to do them 20 years ago, it was very simple, very small application. You just put an org chart and you didn't need much more. But now, even an L1A, which, as I mentioned, you just need to be a manager overseeing professionals. Our applications are like this. I mean, because there's been a big shift into attacking these. So we don't just put org charts in. We want to show them that you're overseeing people. We want emails. We want resumes of the professionals you oversee. We want examples of you calling a meeting, making a decision. Maybe you have budgetary authority. So there's no right or wrong. But when we do an L1A, the support letter can be 18 to 25 pages, if you can believe it. Whereas years ago, it was 2 to 3 pages. So they've come a long way with L1As and L1Bs in terms of making you prove it. Really, that's the big trend over the last 8 to 10, maybe 15 years, I'd say.
Okay, great. So thank you so much again, Rag, for posting your questions. If you have more, continue posting them. We will try to take as many as we can. Okay, so I think Skywell is again here, and Skywell says, thank you for answering that. I would like to know if you need a petitioner to acquire the H1B, and does it only get tied to Silicon Valley companies only? What do you have to say, Erin?
Number one, you do need a petitioner, but it doesn't have to be an IT company or a Silicon Valley company. I'm doing a H-1B for a construction company that needs a project manager, for example. I have another client that's a social working group in New York. They're like social workers, and they're hiring an H-1B. As long as the job requires a 4-year degree. So if you say, well, I want this restaurant to hire me as a waiter, that's not going to work for an H-1B degree. I can tell you I've done an H-1B for an executive chef years ago, which was a tough one because a lot of chefs at that level traditionally don't require a 4-year degree. So we really had to prove that this role did. Not easy. But most occupations that require a 4-year degree, it can be in IT and it can be in accounting, it can be in construction, it can be really anything. As long as the role is it's a specialty occupation requiring a 4-year degree within the industry and within the company generally. And you can show that, then you can go ahead and pursue the H-1B category.
Okay, so Skywell, I hope you got your answer. Thank you so much for your question. If you have another follow-up, please continue posting it. And Rag says, thanks, Erin and Rajni. You're most welcome, Rag. And make sure, I'm sure you must have already by now, but if you're not, please make sure that you subscribe to the channel. And all of our viewers, please make sure that you subscribe to the channel, like the video. And if you think your friends who needs to know the information about H-1B, please do share this episode with them. And let me take Miss K's question. And Miss K says, why would the birthright citizenship EO include work visa and students? Administration asks individuals to do it right away, but I think the executive order would punish H-1B workers. Why would the administration do that? Also, why the uptick in 221G at the embassy? What do you have to, I mean, it's not related to H-1B. So, I mean, if
Okay.
you would like to answer, Erin.
No, I can answer the first question. The reason why they put out that executive order is because they want this issue to finally go to the Supreme Court. It's not because they want to hurt H-1Bs, people here legally. They want the Supreme Court to decide who should benefit for birthright citizenship. As you know, there's not many countries in the world that have blanket full birthright citizenship that we do. So it's a very novel idea. When it was introduced in the States, the purpose of it was to give freed slaves and their children citizenship at the time, and it served a useful purpose. Since then, there hasn't been much debate about it. It's just always been the law, and it's been abused. I can tell you, they've busted Chinese and other rings where they would bring in these rich folks, rich Chinese people. They put them in a very fancy hotel just to have their babies, so the kids could one day, the kids would be citizens and they could come back and then they would go back to China, for example. They busted a lot of those rings up. So me personally, I feel yes, the Supreme Court should take a look at this and decide. And the reason why they worded the executive order that way is because they knew the next day it would be challenged. Okay, they knew that nothing was going to change, and then it will be appealed until it gets to the Supreme Court. The Supreme Court will eventually have to decide this case. My personal opinion, I think H-1Bs and L-1s and people who come legally should definitely maintain the birthright citizenship. I think that's a good idea. On the other, I don't think anyone who comes illegally should benefit from birthright citizenship. I just think it's just a tool, a wrongful reward for people breaking the law. I don't believe that. Now you might ask, well, what about tourists? Someone who's here not too long, like a bee. That's a little bit of a gray area. I'm not sure about that. There's a lot of tourists that come in. There's more bees that come in than any other category. So do we want to maintain the birthright citizen? That's something that's an interesting question that should be decided. There's a lot of people who feel that birthright citizenship was for a specific purpose and not for the way it's been used for hundreds of years. So we'll see. But to answer your question, Trump wasn't attacking birthright citizenships for Ls or H-1Bs or people here legally. He just knows that it's going to be attacked, so he wants to get the issue out there, and then they want to debate it and have a final decision eventually about it.
Right.
What was the second question?
Also, why the uptick in 221G at the embassy?
I don't know if I can report an uptick. I have a lot of L blankets all over the world. I have a lot of you can imagine the amount of people processing. I don't report an uptick, but if you see an uptick, I don't know. I don't think there's an uptick. I just think, different embassies are harder than other embassies. For example, I do a lot of E2s. This is a little bit off topic, but E2s India doesn't have an E2 treaty, but E1s and E2s are per treaty, and most countries have them. I can tell you, for example, E2s in Canada or other countries are pretty straightforward, whereas if you try to get one in Tokyo, it can be very hard, and they're very strict. So, different consulates have different people working there and different protocols and different ways in which they decide cases, and probably the same thing for 221G. I don't know if there's an uptick now. I haven't seen anything about it.
Okay. Thank you so much for answering the question, Erin and Ms. K. I hope you have got your answer to both your questions. And if you have any more, you can continue posting your follow-ups. Even if the show is over, we will try to, share your question with Erin. We'll try to get an answer from him. But thank you for asking your question. And now, Erin, I would like to move to the Facebook questions that are posted by the people and the viewers in the Facebook group. So, Control, please, if you can share the screen. And yes, so one of the viewer has said, hello, my H-1B extension was approved on January 23rd at the Texas Center. So when can I expect the approval notice?
Yeah, so unfortunately, it can take, we're seeing anything, this is something that has trended downwards. It can take at least a week, 2 weeks before you'll get the approval notice. I assume you looked online based on your receipt notice, or was a premium case and you haven't received the approval yet. Either way, yeah, they can take time. I'm going to say anywhere between 7 to 13 days from when you can see that it was approved. You should have your receipt notices. That's what we're running right now, approximately.
Okay. Let's move to our next question. So the next question that we have is from this anonymous member who says, what is the current processing time for H-1B approval notice to be released for master's court?
So if you're talking about the master's cap lottery, that is done on the same day as the regular lottery or the day after. They used to do that one first. They used to do that one second. Now I believe they're doing that one second. Yes, to give the Masters people a better chance of winning the lottery. They switched that about 2 years ago. I'm not sure the processing time. Processing, you mean just to get an approval notice after being approved, like the last question? It would be the same answer. I don't. This is kind of a vague question.
Okay. Maybe let's move on to our next question. So because not much details are there in this question, so let's move to our next question. So this anonymous member says, hi all, my H-1B transfer has just been submitted to USCIS, but my wife and my son have to travel on family emergency to India. Is it okay for dependents to travel while petition is filed with USCIS?
Yeah, so H-1B transfer, also known as an H-1B portability, is when a worker finds a new employer who files an H-1B, and they call it an H-1B transfer. Everyone should know that if you wanted to, you could start working when the case is filed for H-1B transfers. You don't have to wait for the approval notice, which is great. Although a lot of employees, they want to wait until the approval is in hand before they jump ship, just to make sure, give them some peace of mind. The question is, yes. So the I-539 H-4 for the wife and son were filed together with the H-1B, and now you need to travel. Well, look, if you have a visa that's still valid and you can travel back in, then I would say you could travel. You're going to need that visa anyway, because you're not coming back without a valid H-4 visa. Sometimes what will happen is when that's filed, they will notice that the person has left the country, and they may cancel the I-539 application. It's possible. So just be wary of that. But if you have to go and you have an H-4 visa to return, you can certainly do that. And in most cases, you should be okay.
Okay. Thank you so much again for answering the question, Erin. I know it's 5 o'clock, but we have completed an hour. But if you have like few more minutes, I would like to take maybe 2, 3 more questions, if you're like.
Yeah, sure. I have time. That's
Thank you
fine.
so much. Thank
Go
you so
ahead.
much.
Yeah.
Okay, let's move on to our next question. So the next question that we have is, Control, can we please move to, okay. Anonymous member says, hello, I just came to United States on H-1B in the end of December. It was finalized that employer will pay me 180,000 annually. Now he's saying to pay 150,000 USD per annum. So there will be change in petition. Is it an issue or is it normal? Please advise.
Normally, H-1B employers don't lower the salary, but they certainly have the right to. But before they pay you the lower salary, they must submit what's called an H-1B amendment, which tells the government that we're paying less than what we stated on the original H-1B. So it looks like here they're going to file a new petition with an H-1B amendment, and then they will be able to change the terms of the H-1B that you're currently under. If they don't file an H-1B amendment, then you're entitled to the 180,000, which should be noted on the I-129 and in the support letter, and they must pay you that. They cannot pay you less unless they file an H-1B amendment.
Okay. Okay, thank you again for taking that up. Let's quickly move to our next question. So the next question that we have says, hi everyone, sorry, this is not related to H-1B. Last night I had an accident. The person in front stopped in the middle of the road. My insurance expired recently and yet to renew it. Her insurance company called me today and said the blame is on me for everything, but I can dispute it. Please, what should I do, and will it affect my green card application? How can I get a lawyer? Thank you for your help and suggestions. What do you have to say, Erin, to this person?
It won't affect your green card application. This was an accident in the road. Everybody thinks the other person is at fault. If you have an insurance company, you should have an insurance company, car insurance company they're using. I would speak to them and explain to them the situation and see what they say, because they're supposed to represent you in this situation. And then based on whatever their suggestion or their guidance is, you may get a lawyer or not. But I think if you talk to your insurance company, they will tell you what to do. If you don't have insurance, then I would hire a lawyer. You can go online and there's a million lawyers who do personal injury. This is what this is. Just put your city, put personal injury lawyer, and you'll have 100 coming up. And you can call them. Yeah, that's what I would do.
Okay. I think now let's quickly move to our next question. Okay, this is from Yogeshwara. And Yogeshwara says, visa process for family. Hello, I'm currently on H-1B and wife is on H-4. We are planning to start the visa process for my parents, sister, and brother-in-law. I have a few questions on the process. Can mother, father, sister, and brother-in-law go for the visa interview together or separately? Let's take one by one. What do you have to say about this?
Okay, first of all, you have an H-1B, your wife has an H-4. Your mother, your father, your sister, and brother-in-law are not entitled to any H category visa. So maybe he's referring to them coming to visit on a B visa. That happens a lot. Indians in the U.S. like to bring their parents here, and they come. Sometimes they'll come for up to 6 months at a time. So if you're doing that and they're going to get B visa interviews to visit you, that's perfectly fine. Your mother and father could technically go at the same time. Remember, each person needs to fill out their own DS-160 online and schedule an interview. So I think the mother and father can go together, and the brother-in-law and sister would go together separately, but together. The process for a B visa is the same, whether they're a parent or a brother or a friend who wants to visit you. And what are the documents needed? Well, For the B visa, you want to show that you have ties to, I assume you're from India, you want to show you have ties to the home country. So, maybe you get a letter from your employer. If you have an employer, your last pay statements, bring a bank statement. If you're renting an apartment, bring your last few rental payments, even the contract, the lease of your apartment. If you own a home that you live in, you can bring that. I've counseled clients sometimes to bring a gym membership to show that that's still active. There's a lot of stuff you can bring, but those are the most popular ones. And you have to convince the officer that you're going to the U.S., but you have a life to return to, and that you're not just going to stay in the U.S. forever and ignore your I-94. So, yes, I think he means getting a B. So I answered it in that context.
Okay. All right. Let's move to our next question. I hope Yogeshwara, he got all his answers. Let's quickly move to our next question. So next question says, me and my wife have upcoming travel to India for stamping. We have booked our tickets, but lately we are feeling very anxious to travel, fearing what would happen if 221G is issued, which may take weeks to months to resolve. Having said that, I'm reaching out to understand your experience. If you or your friends have traveled to India or stamping in last 2 weeks, okay, they are talking about this anxiety. They want to know how people are dealing with it. How are you dealing with this anxiety if you are planning to visit for stamping in coming weeks? There is a lot on stake here with the kids' school and mortgage in US, and hence want to understand how is everyone. Okay, so this is more about, I think they just want to hear from other people, but as an immigration attorney and an H1B visa expert, what would you like to say? I mean, what would you like to tell this person?
So the first thing is when you're going abroad to get your new visa, plan ahead. You obviously want to have the appointment already scheduled while you're in the U.S. and usually schedule it for the beginning of your trip abroad, not the end. So you can have your interview at the beginning, and then you'll get your passport back, and everything will be smooth, and then you can enjoy the rest of your trip. In some categories, you can use the Dropbox. So if you've already had that visa already before, you may be entitled to use the Dropbox where you don't need an interview. Nevertheless, my advice to anyone is if you're traveling abroad and you're going to need a visa to come back and get the stamping, when you're in the U.S. a few months before, secure your interview date already, do your DS-160 and secure your interview date from here, have it all set up, and then plan your trip around that date. That would give you the least amount of anxiety because at least you have it early. Maybe there's a week or two delay. You're still good because you're there for 2 or 3 weeks, but try not to schedule your appointment towards the end of your vacation or your trip because, you got to get your passport back. And sometimes there are delays and they're out of your control.
Right.
That's the best advice I can offer.
Ms. K also has an advice to offer to this person, and Ms. K says, I don't think the child should be punished for the actions of their parents, but should remove the ability to sponsor that parent for a green card. Let's see. Well, I don't know. But let's move to another question, maybe. If we are left with any, so
That had to do with, I think that was from birthright citizenship, but go ahead.
okay, I think that's it. For the questions from Facebook, but we still have one question which is not related to H1B. Erin, this RK actually has asked this question, and only if you want to answer this. RK says, don't you think the federal government has jurisdiction over undocumented immigrants, given that they can arrest and detain them for deportation?
Yes, I do. The federal government has jurisdiction over them. If they're here breaking the law, they can certainly arrest them. Coming in illegally is breaking the law. So you can arrest somebody for that if you're here illegally. I just came from the Bahamas 2 days ago, and I went through customs. In this case, it was in the Bahamas. It was pre-clearance. But can you imagine if I just ran through there? What would happen to me? And I'm an American. I would be tackled, number one. I would be held in secondary. I probably would be arrested, just for starters. I don't know when I would get into the U.S. I don't know what would happen, but yeah. So obviously the federal government is charged with overseeing our immigration laws, not the states, the federal government, and they have the power to arrest and to make the laws, obviously, to enforce the laws or not enforce the laws, as we've seen. So yeah, that's a pretty basic question.
Okay, I think that's it. Thank you so much to all the viewers for asking these amazing questions, and thank you so much, Erin, for answering all these questions in so much detail. And we really, really loved your insightful answers. And honestly, I would love for you to come back for another episode. And guys, if you want to get in touch with Erin for a detailed consultation, make sure you give him a call on the number 469-459-1771. I would like to repeat the number 469-459-1771. You can also email him. His email ID is erin@eeglawgroup.com. You can also visit his website, which is www.eeglawgroup.com. So make sure you get in touch with him and his team. And thank you so much, Erin, for being here. Really, really, a great episode. And I really would love for you to come back. So I'll get in touch with you. I'll share an email maybe whenever you're available. So we can do another episode on H1B or maybe L1A, right? So
yeah, we could do L1As for an hour. There's a lot to talk about there. If you have a lot of L1 folks and listeners, that could be a good one. Green cards are always interesting. So thank you for having me. I love talking to you, Regina. You're a great host. You're very smooth. I think I should see you on the TV here soon. If you're going to go into journalism, you'd be good. You could ask some great questions. So, but yeah, thank you. Yeah, I look forward to any time. I like talking.
Thank you so much, Erin, for your kind words. Really hoping to see you very soon, and we'll decide on the topic. I'm going to frame a topic and share it with you. But for now, thank you so much for being here. And guys, thank you so much for your questions and for joining the session. We'll see you again very, very soon. We have another show coming up, Daily Immigration Dose. So make that you are tuned in on that. But for now, I'll have to take your leave. Make sure that you like this video, share this video, and also subscribe to Immigration Talk Show. I'm Rajni Bharara signing off for now. Take care and bye.